Programme motion. Minister to move.
Move formally.
The question is the Employment Rights Bill, Programme number 2 motion, as on the order paper. The question is the Employment Rights Bill, Programme number 2 motion, as on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The clerk will now proceed to read the orders of the day.
Employment Rights Bill, as amended in the Public Bill Committee, to be considered.
Now, we will begin with new clause 32, with which it will be convenient to consider other new clauses, amendments and new schedules as listed on the selection paper for day 1. I call the Minister to move new clause 32. Justin Madders.
Thank you, Madam Deputy Speaker. I beg to move that the clause be read a second time. Madam Deputy Speaker, let me first of all start by referring to my register of interest, as I have done throughout the passage of this bill, and let me thank members in all parts of their House for their valuable contributions throughout the passage of this bill to date. In particular, my honourable friend, the member for Llanelli, for her assistance in taking the bill through committee stage, as well as the other members of the Public Bill Committee who provided substantial debate and scrutiny. The Government's plan to make work pay is a core part of our mission to grow the economy, raise living standards across the country and create opportunities for all. It will tackle the low pay, poor working conditions and poor job security that has been holding our economy back. The bill is the first phase of delivering our plan to make work pay, supporting employers, workers and unions by raising the minimum floor of employment rights, raising living standards across the country and levelling the playing field for those businesses who are engaged in good practice. This is a landmark bill which, once implemented, will represent the biggest upgrade in employment rights for a generation. It is therefore important that we get the detail right. The amendments being put forward by the Government today directly demonstrate our commitment to full and comprehensive consultation on the detail of the plan to make work pay. On the 4th of March, we published 5 consultation responses relating to key areas of the bill. This package represents the first phase of formal public consultations on how best to put our plans into practice. We have also undertaken extensive engagement with over 150 stakeholder organisations in addition to the formal consultations. We've taken great efforts to listen to the range of views from businesses, trade unions, representative organisations, civil society and others. The insights gained have been invaluable in informing these amendments to ensure the bill works in practice, both for workers and for businesses of all sizes across the whole country. These amendments will strengthen the bill, providing further detail and clarity on measures and ensuring measures can be implemented in a straightforward way. I will now turn to the detail of the amendments. The Government is moving a range of amendments in relation to zero-hours measures. These amendments will help ensure that the zero-hours contract reforms work for workers and employers, supporting a culture where secure work and prosperous growth go hand in hand. Amendments in relation to Clause 1 covering the right to guaranteed hours will clarify requirements where a worker works for an employer under more than one contract at the same time. Clarify that under a guaranteed hours offer, if it is accepted, work must be provided by the employer for the hours set out, and these hours must be worked by the worker, and enable a worker to take a case to an employment tribunal on the grounds that an employer deliberately structured the worker's hours or offered work in such a way so as to make a reduced guaranteed hours offer or to avoid having to make an offer at all. I certainly will.
Given the urgent necessity to promote growth, surely the acid test of a bill like this is whether it will actually make it more attractive for entrepreneurs to create jobs. What is the answer?
Well, the answer is in the Department's press release, which Simon Deacon, Professor of Law at the University of Cambridge, no less, says the consensus on the economic impacts of labour laws is that far from being harmful to growth, they contribute positively to productivity. Labour laws also help ensure that growth is more inclusive and that gains are distributed more widely across society. I'm sure that the right honourable member wants to see that happen. Amendments in relation to the rights in clauses 2 and 3 to reasonable notice of shifts and payment for short notice cancellation, curtailment and movement of shifts will ensure that the right work appropriately for workers whose contracts specify the timing of at least some of their shifts, provide that a worker is only entitled to a payment from their employer for a shift cancelled, moved or curtailed at short notice if they reasonably believe they would be needed to work that shift, and allows employers to disclose personal information about a worker in notices of exceptions where appropriate and in accordance with data protection law, and ensure that the usual burden of proof applies where it is alleged that such a notice is untrue.
On that point, we give way.
Certainly will.
The Minister will have seen the appalling evidence that our committee took from McDonald's, where the BBC investigation exposed allegations from hundreds of young workers who were suffering harassment, even allegations from one worker of managers soliciting them for sex in return for scheduling shifts. The tightening up that he proposes is very welcome. When does he think he will actually set out the detail of... When will he set out the detail of, for example, the period of time which someone must work before being offered a 0 hours contract?
Thank the Chairman of the Select Committee for his question. We're aiming to work on this once the bill has reached through this stage, and consultation will take place in due course. And I have to say, the chuntering from the benches opposite really just fail to appreciate the power imbalance that there is in some workplaces at the moment, and the exploitation and harassment that arises from that. So, on measures on guaranteed hours, reasonable notice of shift and payment for short notice cancellations, we will seek to ensure that workers, often in fragmented sectors with little voice of their own, do not bear all the risk of uncertain demand. However, we recognise that there are cases where unions and employers working together may want to agree more tailored rights than the provisions allow, which would benefit both the workers and the employer, given the unique context of that particular sector. Unions, businesses and trade associations have made a case for that flexibility in their meetings with us. We want to allow for that. We also provide a baseline for sectors where unionisation is uncommon or agreement cannot be reached. So new clause 33 and associated amendments will allow employers and unions to collectively agree to modify or opt out of the 0 hour contract measures. Like the other workers covered in the parts of this bill, agency workers deserve a baseline of security and access to a contract that reflects their regular hours. Many agency workers have a preference for guaranteed hours, according to survey evidence. 55% of agency workers requested a permanent contract with their hire between January 2019 and September 2020, according to the DBT Agency Worker Survey. And we are keen not to see a wholesale shift from directly engaged workers to agency workers as a way for employers to avoid the 0 hours provisions in the bill. New Clause 32, new Schedule 1 and associated amendments will narrow the broad power currently in the bill and instead include provisions for similar rights to be extended to agency workers. Hirers, agencies and agency workers can then be clear where responsibilities will rest in relation to the new rights. These amendments reflect the call for clarity from stakeholders in their response to the Government's public consultation on this issue. Given the important role that agency work plays in businesses and public services, we recognise the need to work with the recruitment sector, employers and trade unions to design detailed provisions for regulations that work, that is, they achieve the policy objective of extending rights to agency workers without unintended consequences for employment agencies and hirees, and we will work on that in due course. The Government is now also moving amendments in relation to dismissal and redundancy practices. This bill will help employers to raise standards in relation to these practices so that the vast majority of businesses that do the right thing by their workers will no longer be undercut by those with low standards. Certainly will.
Madam Deputy Speaker, I had the good fortune to serve with the Minister for 21 sessions on the Bill Committee. And at the end of that, we had a document 192 pages long. We now have 270 pages of amendments, most of which come from the Government. Why are they tabling so many amendments and giving it just 2 days' scrutiny? Are these just more union demands?
I've literally just explained where we've been consulting with businesses and trade unions and put amendments down as a result of that. And of course, if the honourable member is concerned about the length of the paper for the amendments, he can of course withdraw his own amendment, which we will no doubt be debating later on. We are moving some technical amendments to clause 21 on unfair dismissal, which updates cross-references in other legislation to the sum, which is the existing cap on the compensation which can be awarded by an employment tribunal in most unfair dismissal cases. It is the Government's intention in putting forward this bill to end the unscrupulous use of fire and rehire. We are proposing technical amendments that allow the clause to work as intended to provide those protections. They ensure that once the provisions of the bill, which make unfair dismissal a day one right, come into force, the automatic unfair dismissal protections from unscrupulous fire and rehire practices apply once the employee starts work. This brings it in line with other changes to unfair dismissal. These amendments also make clear that a person will be protected from fire and rehire where they're dismissed and then rehired to do exactly the same job as they were doing previously, but on worse conditions. Clause 25 will modernise the collective redundancy framework to ensure that it works for employees and employers alike. We have listened to feedback from business on the clause as introduced, which required consultation whenever 20 or more redundancies were proposed to be made across an employer's organisation. Businesses told us that this would have put them in a constant state of consultation, so the changes proposed would ensure that this clause extends protections for employees whilst limiting burdens for employers. The amendment means that collective redundancy obligations will be triggered where 20 or more redundancies are proposed at one establishment in line with the existing law, or the number of proposed redundancies across the organisation meets a certain threshold. The Government will set this threshold out in due course via secondary legislation. This will happen after we have consulted, ensuring that it balances the needs of a growing business with the interests of employees. This could be a proportion of employees in a business, a suitable number of employees across a business, or some other threshold proposed through detailed consultation. Employers will also be required to notify the Government of redundancies which meet the threshold set in secondary legislation. The Government's intention is to ensure that it is more difficult for a small and scrupulous minority of employers to ignore their collective redundancy obligations, as we have seen in recent years. New Clause 34 will therefore double the protective award an employment tribunal can make from 90 to 180 days. We consulted on this and other matters from October to December 2024, and after listening carefully to a range of responses from businesses and employee representatives, we have concluded that the maximum period of the protective award an employment tribunal can make should be raised from 90 to 180 days. This is on top of changes the Government has already made. From the 20th of January this year, employment tribunals have had the ability to uplift a protective award by up to 25% where an employer unreasonably failed to follow the code of practice on dismissal and re-engagement. We recognise that responsible employers up and down the country already go further than their current obligations to collectively consult and will continue to do so. They recognise that collective consultation with their workforce can be valuable in finding solutions to challenges that businesses face. We will publish a new code of practice to guide employers on their collective consultation obligations and promote the way good employers are working with their employees to arrive at mutually beneficial outcomes so that all businesses are required to do the same. The Government is also moving amendments in relation to the Bill's provisions on flexible working and dismissal during pregnancy. This Bill will increase the baseline set of rights for employees with parental responsibilities, enabling more working parents to get on at work and achieve a better work-life balance, whether that's raising children or looking after a loved one with a long-term health condition. Businesses will gain too, where this boosts increased workforce participation and it will help employers fill vacancies. These amendments will ensure that these provisions work as intended. Clause 22 adds a new power to make provisions for non-redundancy dismissals during or after the protected period of pregnancy. The amendments will add supplementary provisions to this power. This is to ensure that the regulations can clearly set out details as part of defining the circumstances in which a pregnant woman can still be fairly dismissed. And we will work with stakeholders on how to exercise these powers in regulations. There is also an amendment to Clause 7 which proposes that the flexible working measures in the Employment Rights Bill be added to these provisions in scope of Section 202 of the Employment Rights Act 1996. This means that the Security Services, MI5, GCHQ and the Secret Intelligence Service will be exempt from disclosing any information related to flexible working requests if, in the opinion of a minister, it would be contrary to national security. In these instances, the employer would not need to disclose those reasons for refusing a request for flexible working. The Government is also moving amendments in relation to statutory sick pay. In our plan to make work pay, we committed to establishing a fair earnings replacement for lower earners. We launched a public consultation which asked employers, employees, trade unions, stakeholders and members of the public what this percentage rate should be. After carefully considering the responses to this consultation, the Government believes that an 80% rate strikes the right balance between providing financial security to employees who need it, including retaining an incentive to return to work when appropriate, whilst also limiting additional costs to business. Today's amendments will set the rate of statutory sick pay at 80% of an employee's normal weekly earnings or the flat rate, whichever is lower. Consequently, we will be removing the previously proposed power for the Secretary of State to prescribe the percentage rate in secondary legislation. However, ministers will still be able to use the existing power in Section 157 of the Social Security Contributions and Benefits Act 1992 to substitute a different provision as to the weekly flat rate of SSP or the percentage rate of the employee's weekly earnings, depending on which is lower. These amendments also amend the weekly flat rate to £118.75 as agreed by Parliament as part of its annual uprating exercise. The Government is also moving amendments which will add 2 new provisions into Part 2 of the bill. Analysis conducted by the Resolution Foundation found that 900,000 workers reported they had no paid holiday, despite this being a Day 1 entitlement. New Clause 35 will create a new duty in the working time regulations for employers to retain records relating to holiday pay and annual leave for 6 years. I'll give way.
I'm grateful to the Minister. I apologise that he's moved on a bit. I was just waiting to hear what he said. I don't know if the Minister can correct me, but in terms of the provisions made around menstrual health, menopause strategy, etc., I believe that that doesn't include the condition of endometriosis, which can be crippling for people in the workplace. So I'm not sure if I may not have seen it in the bill, but does the Minister have any plans to make sure that that becomes a protective area of sick leave? Because it's devastating for many women, but at the moment they very much struggle to be able to recognise with that terrible disease in the workplace.
I'm grateful to the Honourable Member for raising this important point. It was something that was touched on in the Bill Committee, but there aren't any amendments dealing with that specific issue today. Returning to the question of holiday pay, where an employer does not keep adequate records, a Fair Work Agency enforcement officer may seek a labour market enforcement undertaking from the employer to ensure future compliance. Where the employer refuses to give a labour market enforcement undertaking or fails to comply with one, the Fair Work Agency enforcement officer may apply to the appropriate court for a labour market enforcement order, and I'll give way.
I apologise, Minister, you have moved on a bit, but I just want to come back to the new level of statutory sick pay, which is £118.75 or 80% employees' weekly earnings. The current situation, am I not correct, is that an employee with weekly earnings of £125 would at present get £116.75, but under your new model, they'd only receive £100. Is that correct?
Yes, but I think the Honourable Member is forgetting the fact that we're moving the waiting days, and with the provisions on the lower earning limit going, there will actually be 1.3 million people who will be accessing statutory sick pay. We think this is the right balance. We think this will leave people in a much better position, and of course it's something that we will always continue to review. I'll move now on, Madam Deputy Speaker, to the issue of umbrella companies. We are aware of non-compliance in the umbrella company market, where umbrella companies can be responsible for denying employment rights to those who work through them. New Clause 36 will allow for the regulation of umbrella companies and for enforcement by the Employment Agency Standards Inspectorate and subsequently the Fair Work Agency. The specific requirements on umbrella companies will be set out in the relevant regulations, which set out the minimum standards of conduct for employment agencies and employment businesses. We will consult before amending these regulations, and we are committed to working with the sector to ensure that future regulation works effectively for umbrella companies. This amendment marks an important step towards ensuring non-compliant umbrella companies are no longer able to deny workers the rights that they are owed. The Government is also moving a range of amendments in relation to Part 3 of the Bill, which covers the Adult Social Care Negotiating Body and the School Support Staff Negotiating Body. With regards to the School Support Staff Negotiating Body, the Government is moving 2 technical amendments to correct incorrect cross-references. The School Support Staff Negotiating Body is an important part of delivering both the Government's plan to make work pay and the Government's opportunity mission. The Government will today commit to consult in the summer on whether agency workers should be brought into the scope of the SSMB in future legislation to support these missions. Certainly will.
I thank the Minister for giving way. Could he clarify for the House, will the provisions on the school support negotiating body, support staff negotiating body, will it provide a floor as well as a ceiling, or is it going to be a floor on pay? Because there are certainly a number of school leaders, academy leaders, who say actually they want to pay above what government might recommend for support staff, and that this may actually limit them from doing so.
I think this is something that we did debate in detail in the Bill Committee. My understanding is that there will be a floor, but there won't be a ceiling. If I'm wrong about that, I will come back to that. And we absolutely think a floor is needed, given some of the issues in low pay in this country. Amendments to the adult social care negotiating provisions will remove clause 42, thereby removing the power to make a standalone enforcement provision in respect of the agreements reached by the adult social care negotiating body. Enforcement of pay terms under agreements will instead be in the remit of the new Fair Work Agency under Schedule 4 to the Bill.
Madam Deputy Speaker, I recognise that the Minister is rattling off a whole list of amendments that appear to come after the legislation has gone through Bill Committee. Does he not understand that this actually creates a massive burden on many businesses? Would it not be better to actually accept that they've gone a little bit overboard with this bill and start afresh with proper consultation with businesses at ground level?
Well, look, the reason why we're putting so many amendments down is because we've been consulting with businesses and working with them, and that is why we have so much to say today. And it was a commitment of this party to launch an employment rights bill within 100 days of taking office, and I'm proud that we delivered on that, and I'm proud that we've got this bill here today. Of course.
With respect to that consultation, how many small businesses expressed their support for this bill?
Could you name any?
Well, I would refer the honourable member to our departmental press release, where I think there's at least half a dozen business representatives and businesses who have expressed support. And of course, there are many more businesses out there. Indeed, I visited one only recently who supported the bill. Yes.
Will the Minister be kind enough to name one of those businesses on the press release? Oh, you better look at the press release just to check. That'd be kind.
Okay, Co-op, quite a big business. Richer Sounds, Centrica, British Chamber of Commerce. These aren't bit part players at all, are they? Really? Anyway. New Clause 38 seeks to ensure that agency workers in the adult social care sector who do not have a workers' contract within the meaning of employment legislation would nevertheless be able to bring a claim in the employment tribunals or in civil proceedings where a fair pay agreement has been breached. It does this by deeming a contract to exist for this purpose between the worker and the party who pays them. This will allow such workers to bring an unlawful deduction of wages claim or breach of contract claim for a breach of fair pay agreement terms. New Clause 37 and associated amendments will enable the Scottish and Welsh ministers to establish their own separate negotiating bodies and associated framework, and enable their negotiating bodies and the resulting agreements to cover social care workers in both adult and children's social care. Care policy, funding and commissioning is delivered together in both Wales and Scotland. In England, the two workforces, and therefore the policies and delivery, are distinct. As such, it is right for Scotland and Wales to have the powers to set up negotiating bodies which can provide for their systems and workforces as they are now. These amendments and associated consequential amendments will allow the devolved ministers to exercise certain powers in this chapter of the bill with the consent of the Secretary of State, ensuring that the Secretary of State retains oversight of regulations relating to reserved matters of employment and industrial relations. The amendment to Clause 41 supplements the power to make regulations in relation to record keeping. This amendment will enable those regulations to apply to Section 49 of the National Minimum Wage Act 1998 to prevent employers from trying to contract out of their new record keeping obligations. Now, before I wind up, I wanted to address some of the other amendments which have been tabled to the bill, and I wanted to take this opportunity to note in particular the amendments tabled by my honourable friend, the member for Luton North. I am grateful to the work of the Women and Equalities Committee for raising the important issue of miscarriage leave. The loss of a baby at any stage is an incredibly difficult and personal experience, and the inquiry that they've conducted demonstrated a clear gap in support for those who experience pregnancy loss and need time to recover and grieve. And I pay tribute to my honourable friend for Luton North because she has shown great courage in talking personally about her own experiences in this area. And I'm grateful to her and the other honourable members and other campaigners who have spoken on this issue. We have heard them. We fully accept the principle of bereavement leave for pregnancy loss as raised in the amendments, and we look forward to further discussions with the honourable member and noble lords as the bill moves on to its stages in the other place. Bereavement is not an illness, it is not a holiday, and it does need its own special category. I also want to take this opportunity to note the amendments tabled by my honourable friend, the member for Poplar and Limehouse, and the member for Lowestoft. The Government recognises the important points raised by both members and the serious impact that domestic abuse has on society, particularly women and girls. And we strongly encourage employers to support staff who experience domestic abuse. Many already do this through their membership of the Employers' Initiative for Domestic Abuse, which empowers employers to tackle domestic abuse. The Employment Rights Bill includes provisions to make flexible working easier to request, which we know can be of great help to those experiencing domestic abuse that may need to take time from work for appointments for domestic abuse-related matters. The Government has a commitment to halve violence against women and girls in a decade. And I've met with my honourable friend, the Minister for Safeguarding and Violence Against Women and Girls, who this House will know is a dedicated and respected campaigner on these issues. In addition, I have spoken to several honourable members, including the honourable member for Gloucestershire, whose private member's bill I notice had its first reading, about their concerns, sharing many powerful stories from their constituents. I've also discussed this with the honourable friend, the member for Lowestoft, and of course, honourable friend in the Justice Department. Every part of this government will need to contribute towards our ambition to Hodge.
He said a moment ago, when asked by my honourable friend whether there were businesses who supported the bill, and he mentioned the British Chambers of Commerce. But I've just gone to their website, and they say the British Chambers of Commerce has used an evidence session on the Employment Rights Bill to highlight businesses' serious concerns about the legislation and the speed and detail of his consultation. Will the Minister withdraw his comment?
Well, I'm glad the honourable member's got access to the internet. I would direct him to the department's webpage, where this is what Jane Grattan, Deputy Director of Public Policy, said. There is much to welcome as sensible moves that will help ensure that employment works for both the businesses and the individual. This is in response to the amendment, so that is a much more up-to-date comment from the one that the honourable member has indicated. I will just move back to the issue of violence against women and girls, because it is very important, Madam Deputy Speaker. It is incumbent on every part of government to work together to tackle violence against women and girls. This is not a task for a single department or minister. This government is steadfastly committed to delivering the manifesto commitment to halving violence against women and girls, and we will be publishing a cross-government violence against women and girls strategy shortly, and I intend to work with colleagues to make sure that we as a department can do our bit in respect of that. I also wanted to take this opportunity to note the amendments tabled by my right honourable friend, the member for Sheffield Heeley, and the member for Oxford West and Abingdon on this non-disclosure agreements. I have met with advocates in this area and understand the significance of the problems they have highlighted regarding the misuse in some circumstances of non-disclosure agreements. This is an important issue which warrants further consideration. I'm also aware that the government is also pressing ahead with plans to enact the provisions relevant to NDAs in the Victims and Prisoners Act 2024 and the Higher Education Freedom of Speech Act 2023. We take the misuse of NDAs seriously, and we will continue to look further into this to see what we can do. So I know there are a number of members who wish to speak, Madam Deputy Speaker. I will give way one last time.
New Clause 72, in the name of the member for Headingley, focuses on whistleblowing and protected disclosures. This area has been so important in recent scandals, be it the Fujitsu scandal in the Post Office, Lucy Letby, or other public scandals. Could I urge him to look at that amendment and look at the fact that actually imposing a duty on bigger employers to look at and investigate protected disclosures is a vital way of moving forward on that key legislation?
I thank the honourable member for his intervention. This is something I have begun to consider, because we are aware the legislation is now a quarter of a century old and does need looking at in light of the experiences and indeed a number of the scandals that have been mentioned. So we are considering where we go next with whistleblowing legislation. But in conclusion, Britain's working people and businesses are the driving force of the UK economy, and this bill will help create a labour market that delivers for both. This bill will deliver significant benefits to the UK, including better working conditions, more secure work, reducing inequalities and improving industrial relations. I appreciate I've outlined a lot of detail today, but it's important to remember, as is typical with any legislation of this nature, many of the policies will be provided through regulations and, in some cases, codes of practice. We expect further consultations on these reforms to begin later in the year, seeking significant input from stakeholders. I'm grateful for members' efforts to improve this bill and for the debate and scrutiny that we've received so far, and I look forward to hearing further debate this afternoon.
Agency workers, guaranteed hours and rights relating to shifts.
The question is that new clause 32 be read a second time. Shadow Minister Greg Smith.
Thank you, Madam Deputy Speaker. After 21 sessions in the Public Bill Committee, we still see the government bringing hundreds of amendments forward to this bill, which once again highlights that their false political deadline of 100 days to publish it was foolhardy, and they should have taken better time. Fundamentally, this is a bad bill. Whilst it contains many good measures, many well-intentioned measures, they have failed to get the balance right between employees and employers. And whilst I welcome some of the comments the Minister made in his opening remarks, not least on the point that he knows we have agreement from our debate in the Bill Committee on bereavement leave for pregnancy loss that we spoke at length during that Bill Committee, I'm afraid for the vast majority of this bill, the balance has in fact been got wrong. And so the amendments that stand in the names of honourable and right honourable friends from His Majesty's loyal opposition seek to highlight the way that this bill simply goes too far in too many regards, highlight the ways that it is going to affect our economy. It is going to affect the actual number of people in the economy who have a job. It is going to affect the willingness of employers, the actual wealth creators, the people who actually create the jobs, to take on new staff, to grow, to put new product lines in place and to keep employing people. I will give way.
I'm grateful to the Shadow Minister giving way, and I doff my cap to his 21 sessions in the Bill Committee. But therefore, does he shine any light on the fact the Regulatory Policy Committee, when they looked at this bill, said 8 out of the 23 sections were, I quote, not fit for purpose? Has he any more confidence after being in that Bill Committee and the amendments laid before us today that those 8 have been rectified?
Yeah. Well, I thank my honourable friend for his intervention, and I'm sorry to have to report to him that no, I don't have any greater confidence that this bill is going to work. He's right that the RPC identified so much of this bill in the red at severe risk column and, as he said, not fit for purpose. And some of the amendments that I will speak to in more detail in a moment in my name and that of honourable and right honourable friends on these benches will seek to try to further explore the impact that the measures in this bill are going to have on the economy and try and answer some of the points that my honourable friend has rightly outlined. The fundamental position that we find ourselves in, though, is that, as we know, every Labour government leaves unemployment higher than when they started. The difference with this one is that they are actually legislating for that outcome. So I turn first of all to new clause 83 and amendment 283. When we were in government, we banned exclusivity clauses in zero-hours contracts. We know that for many employees on zero-hour contracts, such as students, those with a summer job or other responsibilities, that this works for them. Employees can value that flexibility. This bill imposes a statist, top-down, government-knows-best approach, which will limit flexibility both for employers and employees.
I thank the honourable member for Mid-Buckinghamshire for giving way. I visited the Nelson pub in Farnham recently, and there I met the publican who employs a lot of people on zero-hours contracts, one of whom, in addition to working in the pub, actually works as a paramedic. And that flexibility allows him to do both jobs. These are the sort of people that are going to be impacted by this legislation.
Very good. I'm grateful to my honourable friend for that intervention. He's absolutely right. I'm actually attending a wedding in Farnham later this year, and I look forward to visiting the Nelson and thanking his constituent for that service he also gives as a paramedic. The Well, he promotes me, but I will give way.
I'm very grateful to him for giving way. Is he aware that the TUC's survey clearly shows that the vast majority of people on zero-hour contracts really want regular hours? Can the Shadow Minister respond to that?
So the honourable gentleman makes a point about, in his words, the vast majority. I don't know if it is the vast majority, but in certain cases, yes, of course, some people will want the guarantee of those hours that he talks about. But the point I am making is about flexibility. It is about allowing those for whom it does work. The example I gave around, for example, students, the example that my honourable friend for Farnham and Borden gave, around those for whom this flexibility does, in fact, work. That is not to say that there are many out there in our economy that do seek the change that he wants, but that is not a universal rule. That is not something that should simply be applied to absolutely everyone. And I would gently invite him to reflect on what it does mean for those examples, such as the one my honourable friend for Farnham and Borden gave, and the impact.
Member for giving way. Has he actually read the bill, and does he understand that the flexibility included is the flexibility to ask for guaranteed hours, and if a student or somebody doing a second job doesn't want those guaranteed hours, they don't need to have them?
I'm happy to confirm to the honourable lady that yes, I have read the bill. I have read a considerable number of documents from the House of Commons Library, from many other organisations. I've actually spoken to a lot of businesses in my own constituency, as well as further afield, who I can assure her are horrified at the bill that is coming up. And indeed, the Minister was asked earlier to name a single small business that supported this bill, and his answer was the Co-op and Centrica. And last time I looked, neither of those will be considered small businesses. I will give way one more time, then I'm going to make some progress.
Does it worry my honourable friend that, once again, the government revealed that they're desperately hoping that companies like Centrica do become small businesses?
My right honourable friend makes, in his ever stylish, witty manner, a very good point on that. So, Madam Deputy Speaker, to move on, the Regulatory Policy Committee has given, as my honourable friend said earlier, a red rating to the identification of options and choice of the policy on zero-hours contracts and guaranteed hours in this bill. This means the government has not justified the necessity of clauses 1 to 6. What is the problem the government is trying to solve with these clauses? Why are these clauses needed? We just don't know. The bill, despite literally hundreds of government amendments, remains silent about how these provisions will work in practice, which means the government's assessment that the administrative cost to business that the bill will have in shift and workforce planning is £320 million, and that could well be an underestimate. UK Hospitality raised their concerns during committee, and I quote that the government are intending to leave it to case law and employment tribunal systems to figure out what reasonable notice means. That is an unacceptable way to legislate. Businesses crave certainty and a stable regulatory environment. This bill provides anything but. And the result, as the chair of the CBI has said, is that this bill risks becoming an adventure playground for employment rights lawyers.
My honourable friend is a learned man. He may have seen the Financial Times report that for the first time ever, the number of companies registered at Companies House has actually fallen. Does he think that this bill has anything to do with it, with particularly the not fit for purpose points that have been made with this legislation coming on the horizon?
My honourable friend makes an exceptional point. This bill absolutely categorically will be playing a part in that, along with the budget of broken promises and the tax increases in employers' NI and so on. And I shudder to think what will happen when it actually becomes a law. We understand the parliamentary arithmetic. We understand that the government will force this through. But it is the reason we have tabled new Clause 83 and Amendment 283. So new Clause 83 would require the Secretary of State to conduct a review of the impact of Sections 1 to 6 on the operation of employment tribunals and the ability of employment tribunals to manage any increase in applications resulting from those sections. Amendment 283 provides a commencement block on sections 1 to 6. We believe these sections should not come into force until the review required by new Clause 83 has been approved by Parliament. It will be both businesses and employees who struggle when claims are brought because of the confusion created by this bill. If the Employment Tribunal in one moment, I will happily give way to the Honourable Lady. If the Employment Tribunal is not able to cope with this increased caseload, and members opposite should have their eyes open to the consequences of this badly thought out legislation. Perhaps the Honourable Lady will open her eyes to this point.
Shadow Minister for giving way. These amendments will ensure protections for all of the 2.4 million people in the UK with irregular work patterns, be it 0 hours contracts or agency contracts. Can the Shadow Minister tell this House why he thinks that agency workers don't deserve the same protections as everyone else?
Well, the Honourable Lady makes a point that I think she made in the Bill Committee, and it was good to debate with her and others during the passage of the Bill Committee. I think actually we did have a genuine and robust debate during that. The point I am arguing for is flexibility. The point I am arguing for is a recognition of how the employment market, of how our economy actually works in real life. And to treat everything with one universal rule is going to be a disaster for our economy. And I fear that it will result in fewer people in work, fewer jobs in the economy, and it certainly won't deliver the growth that this government pretends that they want to see happen. How can I resist the Honourable Gentleman?
Gentleman for giving way. Does he not accept, though, that when you look at the productivity rate in this country, particularly versus France and Germany, is it not absolutely down to the expendability of employees in the workplace that we have such a poor rate of productivity?
I don't accept what the Honourable Gentleman, who I greatly respected, we've worked together on a number of issues over recent years, but I don't accept the point that he's making on that. Is there room to improve productivity? Of course there is. There is room to improve productivity across all sectors, all of the time. We wouldn't get a growing economy if you couldn't do that, Madam Deputy Speaker. However, I think what this bill is trying to do is take a sledgehammer to crack the proverbial nut, and to apply a universal rule across all is not going to deliver what I think the Honourable Gentleman quite nobly wishes to achieve within the economy. This is one of those points where potentially, actually, as is always the case in politics, the thing that divides us isn't the end goal or the point at which we want to get to. It is the means to getting there, and I don't think this bill is going to deliver what he wants to achieve. He looks like he wants to come back again. I want to make progress, but I will give him one last track.
The simple point that it is less motivating, less of interest to a company to invest in machinery and plant if it can ultimately change the structure of its workforce or expend them, hire and rehire. That is what is holding us back, and that's why we have the 20% deficit to France and Germany in terms of productivity.
The Honourable Gentleman makes an interesting point, but I don't see businesses out there wanting to expend their workforces or get rid of them or disinvest in their workforces. I think the honourable gentleman is giving a very pessimistic outlook on the way the business environment actually run in this country. Businesses want to innovate, they want to grow, they want to employ more people, they want to make more money. Making money is not something to look down people's noses at. It is a fundamentally good thing that creates wealth and grows the economy and increases the tax base to pay for the services that we all want to see. So I don't share the honourable gentleman's view of the world when it comes to this bill on that point that he is trying to make. I do want to move on to some further amendments, but I will give way to my right honourable friend.
Thank you. I'm grateful to my honourable friend for giving way. I think what is very clear, listening to the debate across the House, Madam Deputy Speaker, that there are those of us on this side that understand business and that also understand and actually come to this place with years of experience. If perhaps the honourable members on the opposite side would stop heckling for one moment, they might start and listen. That if you want to increase productivity, it is about employees. It is also about employers being able to invest in their staff through training, through contracts, through plant and machinery. It's a whole raft of things, none of which you can do if you stifle your businesses with red tape and employment law, or law which is basically about law through the courts. Thank you.
Greg Smith.
Well, I quite agree with my right honourable friend, and I think that the point that goes to the crux of what she is trying to say is the approach to which those of us on these benches look at the economy and the approach that those on the Labour benches and other left-wing benches look at the economy. And that is, of course, the left of British politics tend to view everything through the lens of business being bad, of all employers seeking to exploit their workforces, of this sort of Victorian factory image from a novel of that era, whereas in reality it is that symbiotic relationship between employer and employee that we need to recognise, that actually you don't grow the economy without things working in both interests. And what this bill is seeking to do is to tip the balance too far in one direction, forgetting that that's going to take away the incentive for the employers, the wealth creators, to get on and grow. So, Madam Deputy Speaker, to move on to new clause 84 and amendment 284, on this side of the House, we have absolutely no issue with the right to request flexible working. Indeed, in 2023, Conservatives in government passed the Employment Relations Flexible Working Act. This made it easier for employees to make flexible working requests, gave them a statutory right to do so, and required employers to consider and discuss any requests made by their employee more quickly. And that legislation appears to be working. The Regulatory Policy Committee have said that there is little evidence presented that employers are rejecting requests for flexible working unreasonably. And they... Okay.
Sarah Russell.
I spent 13 years as a solicitor working in employment rights, predominantly for employees, periodically for employers. I can assure you that flexible working is not working for many, many mothers in this country, and that many women are giving up jobs and becoming self-employed because their employers will not agree their flexible working requests.
Greg Smith.
Well, it's good to hear from a real solicitor giving their wealth of knowledge, to this area. And I'm not trying to suggest that everything is perfect and that everything is working well. And I fully accept the point that she makes about many mothers getting either back into the workplace or extending their careers. That is a fair and good point that she makes. But again, this bill is not the answer that she is looking for if she looks at it in more detail. So the RPC gave the government's impact assessment for the flexible working provisions a red rating. That actually goes to the nub of the point. Is there room for improvement? Of course there is. But the impact assessment, Madam Deputy Speaker, for the flexible provisions in this bill is given a red rating, not fit for purpose. So once again, I ask the Minister, what problem is the government trying to solve with Clause 7? Before rushing to pile more red tape on businesses through the bill, did the government consider options such as raising awareness of the right to request flexible working? Our new Clause 84 requires the Secretary of State to assess the impact Clause 7 will have on employment, wages and economic output. One more crack here.
I can absolutely assure him that women do know about the right to request flexible working, and that is not the source of the problems that they are facing.
Greg Smith.
Well, she almost makes the point for me, because I talked earlier about the very point that we introduced that right, and it was working well, but the RPC say the provisions in this bill don't actually do anything for it and are not fit for purpose. So I frankly thank her for her intervention. So our new Clause 84 equally calls to consider the likelihood of the costs of flexible working measures being passed on to employees through lower wages, and examine the likely effect of the right to request flexible working on productivity, wage growth, equality of opportunity, job security, economic activity and employment. New Clause 84 equally requires a report setting out the findings must be laid before each House of Parliament no sooner than 18 weeks after the consultation has been initiated.
Thank him for giving way. He's just said that there may be areas where we could go further on flexible working. Can he explain then why the last government's flexible working task force met just once last year and met just once in the year before? As with the long-awaited employment bill, which never materialised, is it not the case that this government is bringing forward real measures because the last government vacated this territory?
Greg Smith.
The honourable gentleman who we debated at length in the Bill Committee on these matters clearly hasn't listened to what I've said, because I detailed how we did legislate. We did legislate in this area, and yet it is this government that is bringing forward a bill that the RPC, in this respect, has given a red rating and has said is not fit for purpose. So I would gently urge him to look again at this, and where we can agree on areas that could potentially go further or be different to that which is set out in either existing legislation or proposed legislation, to understand the impact that what this bill is actually asking to do will have on the real economy. Amendment 284 would ensure that Clause 7 could not come into force until Parliament had approved that report. So to put it simply, Madam Deputy Speaker, the genesis of this amendment is because the government have not done their homework. They have no idea what they are doing and why. But we do know that these provisions will damage business, and that, in turn, will hurt workers. And we want members opposite to acknowledge that. It will be ordinary people paying the price. So to move on, Madam Deputy Speaker, I want to turn to new Clause 85 and Amendments 285, 288 and 289. Clause 18 in the bill, which makes employers liable for harassment of their employees by third parties, is another example of the government putting more regulation on business without knowing the problem they are trying to solve. The Independent Regulatory Policy Committee has said that the government has not managed to sufficiently demonstrate the need for the third-party harassment provisions in the bill, and have rated this impact assessment once again as red. It should go without saying that on this side of the House we do not condone any form of harassment in the workplace. And when we were in government, we legislated to put a duty on employers to take reasonable steps to anticipate and prevent sexual harassment. That is a horrible, evil crime that is covered in other legislation to protect everybody in this country. So I double underline that we are not condoning that. In fact, we legislated very clearly to clamp down on that evil and heinous crime. But I would be interested in any evidence the Minister has for the prevalence of third-party harassment in the workplace and how this clause might actually solve that, because the government has not produced it so far. I'm going to make some progress then. As I think I've demonstrated, I'm not shy at giving way, and I will come back to the Honourable Lady. The problem is that badly considered law, developed with no evidence base, is likely to cause problems rather than solve them. That is the law of unintended consequences. We are deeply concerned not just about the unclear liabilities this clause places on employers, but on the implications it has for freedom of expression. The Equality and Human Rights Commission has said that the third-party harassment protections raise complex questions about the appropriate balance between third parties' rights to freedom of expression as protected under Article 10 of the European Convention on Human Rights and employees' protection from harassment and their right to private and family life. We are already struggling to ensure freedom of speech at our universities, places that should be guardians of free, opening and challenging debate.
Shame on the government.
I thank him for giving way. It was, of course, my private member's bill which the government supported, but only partly because the third party harassment was scrubbed out of the bill. And I'm very pleased that the new government is reintroducing that bit of the bill. The question is, why is he supporting that employers should prevent sexual harassment in the workplace and demonstrate that they've taken all reasonable steps? But for third parties, he thinks that is something that impacts on freedom of speech. It does not make sense.
Well, I thank the Honourable Lady for her intervention, but if she allows me to continue a bit, I think it will become clear why we are taking the position we are on this, because I will give some concrete examples in a few moments of where the law of unintended consequences will kick in on this particular provision. A 2022 study by the Higher Education Policy Institute found quiet, no platforming, where students decide not to invite otherwise suitable speakers to an event because of their views, was more common than reported cases of no platforming. Speakers quietly no platformed included Alex Salmond, Liam Neeson, Harry Enfield, one that the other side might blink at, Tony Blair, and Peter Hitchens. And this clause, whilst well-meaning, is likely to make matters worse. As James Murray, Legal Director of Doyle Clayton, has pointed out, this clause could well cause difficulties for universities in offering a platform to discuss issues on which those listening may have differing views.
I was absolutely right to draw attention to the problem in universities, and it particularly found form in no platforming speakers that are deemed to be unacceptable or make people feel uncomfortable because their views on, for example, transsexual issues. So Kathleen Stock, a distinguished academic and a feminist, was no platformed in exactly that way because of her view that sex is a biological fact. This clause needs to be examined in that context. And I welcome much about this bill, particularly on trade unions and on zero-hour contracts, actually, as it happens. But I do feel this one area needs to be looked at again by government for the very reasons my honourable friend makes clear.
Smith.
I'm grateful to my right honourable friend, and I totally agree with him that this area does need to be looked at again to ensure those unintended consequences are not allowed to come through that do challenge freedom of speech in this country. I double underline, we have no truck with harassment. We absolutely believe it should be stamped out using the criminal law where necessary to ensure that perpetrators of it are brought to justice. What this bill is doing is opening the door to unintended consequences.
I thank the honourable member for giving way. I'll help him come back to the point. 2 in 3 young women have experienced sexual harassment or verbal abuse in the workplace. It is important that where they are in customer-facing roles, they are protected both from abuse by their colleagues and their managers and from abuse by their customers. This is particularly important if perhaps they're working in a university bar or in another sort of a bar or in a shop or a retail setting. I was very pleased to have taken the first piece of evidence about the nature and extent of workplace sexual harassment when I worked for the TUC in 2015, and I am sad that it has taken us a decade to get to the point where we are saying no more sexual harassment by customers and clients, and the party opposite could have achieved this much more quickly if they had just accepted the private member's bill put forward by the member opposite.
Greg Smith.
The Honourable Lady, I don't think, is actually disagreeing with what I have said so far, because the sexual harassment is clearly a crime. It is already a crime, and any perpetrator of it should be brought to justice. But that is covered by different law. And the point that we are getting to, for example, in a moment, the point that I am getting to answer the Honourable Lady is not a point about sexual harassment or anything else covered in the criminal law. It is, for example, in a hospitality setting where perhaps somebody who is waiting on the tables or serving at a bar overhears a conversation that they find deeply offensive. For example, perhaps around the situation in Israel and Gaza right now, that they find themselves deeply offended by, but that yet this bill would be making... In a moment I will give way to the Honourable Lady. But this bill would criminalise and bring in the banter police and so on, just because people are expressing a perfectly legitimate political view that somebody else finds offensive. I double underline that sexual harassment is absolute.
Sarah Russell.
Madam Deputy Speaker, the Shadow Minister is in danger of misleading the House. Nothing that he has referred to is a crime. Sexual harassment, as dealt with in this bill, is a civil matter dealt with the tribunal court.
I thank the Honourable Lady for her point of order. It was, in fact, I think, a point of debate rather than a point of order. Greg Smith.
Thank you, Madam Deputy Speaker. So, if we can get back to James Murray, the legal director of Doyle Clayton, has pointed out that this clause could well cause difficulties for universities in offering those platforms to discuss issues, as I say, where people have differing views. He said, if we think about a speaker that has been invited, say it's a controversial, gender-critical speaker like Julie Bindel or Kathleen Stock, someone might somewhat disingenuously say that they are an employee of this university and they find what they say to be deeply harassing. The concern is that this will shift the balance away from free speech and universities will be more at risk and be more risk averse as they won't want to be held liable for that third-party harassment. Why do the government want to run this risk? And then there is the burden on businesses, particularly in the hospitality sector. Kate Nichols, Chief Executive of UK Hospitality, he's had a go so far. We may come back later. Kate Nichols, Chief Executive of UK Hospitality, said that the staff in restaurants, bars, pubs and hotels are working in a social environment where there are jokes and people are boisterous. She said, while everyone wants to make sure their staff are protected, I quote, we don't want to be policing our customers, and she is concerned this clause could add undue restrictions. So if someone is working in a pub or a comedy club, for example, there is a high risk that they might hear comments that they don't like. But it is wrong to restrict free speech just because somebody doesn't like something. The unintended consequence of this provision is likely to be a chilling effect on free speech and unclear responsibilities for employers about where they need to draw the line. I'm going to make some progress. I've been on my feet, and I know there's for a long time, and there's a lot of people that wish to speak in this debate. So, in other words, this clause could well function as a banter ban at best and a restriction on academic debate and inquiry. Due to our concern about how this clause will operate, but especially on the higher education and hospitality sectors, we have tabled Amendment 289. This will carve out the hospitality sector and sports venues from Clause 18. These are sectors where we believe the potential for unintended consequences from this clause will be the greatest. It is because we believe that Clause 18 is going to create problems rather than solve them that we have tabled new Clause 85. This requires the Secretary of State to report on this clause. This report must include the extent to which the prevalence of third-party harassment makes the case for the measures in Section 18, include an assessment of the impact of Section 18 on free speech, include an assessment on the likely costs of employers of Section 18, include an assessment of which occupations might be at particular risk of third-party harassment through no fault of the employer, and proposals for mitigations that can be put in place for employers employing people in such occupations. We will require the Secretary of State to lay this report setting out before each House of Parliament And Amendment 285 will prevent Clause 18 coming into force until that report is approved by Parliament. The government needs to go away and think again, and that is what our amendments are designed to achieve. And if the government is not willing to do so, we have also tabled Amendment 288, which would leave this clause out of the bill entirely. So great is our concern about the unintended consequences it could have. Once more.
Since we have been discussing that for the best part of the previous Parliament, can I ask him whether there's a misunderstanding of what actually this bit of the employment bill would say? It's about a preventative duty. It is not about predicting everything that could happen, for example, in the hospitality sector. So all that the guidance is to make sure that everybody knows that their workplace is there to protect people from harassment. That is what an employer needs to do, and what is the problem with that?
I'm not sure the Honourable Lady has firmly grasped what this bill says in that respect. Of course we want to protect everybody in our society. That's the first duty of government. But the real world and the unintended consequences, particularly in the hospitality sector, I don't think the Honourable Lady has fully considered. If I may very quickly, Madam Deputy Speaker, speak briefly to new Clause 86 with Amendments 286 and 287. Clause 21 and Schedule 2 are another example of the government rushing to legislate in an attempt to meet an arbitrary deadline set by the Deputy Prime Minister with chaotic results. Clause 21 will remove the qualifying period for unfair dismissal. The Regulatory Policy Committee again slapped a red rating on the government's impact assessment for these provisions, meaning the government has not adequately justified the need for them. The government has admitted that it does not have robust data on the incidence of dismissal for those under 2 years of employment. In other words, yet again, we do not know if there is even an actual problem with unfair dismissal that this bill is trying to solve. The British Chamber of Commerce have said, I quote, members say that there would be a reduced hiring appetite were this legislation to come in, and that they would be less likely to recruit new employees due to the risk and difficulty, particularly under the day one rights, unless there were at least a 9-month probation period. So our new Clause 86 requires the Secretary of State to assess the impact of the provisions of Clause 21 and Schedule 2, and Amendment 286 requires Parliament to specifically approve this impact before these sections of the bill can come into force. I am mindful of time, and I do not wish to incur Madam Deputy Speaker's wrath, and so I will make progress. But we have also tabled Amendment 287 to remove Clause 21 from the bill entirely. So concerned are we about how damaging this will be to both employers and employees, particularly those who will not get work as a direct consequence of these requirements. New Clause 87 our new Clause 87 seems a perfectly sensible thing to ask for, a simple requirement on the Secretary of State to have regard to the objectives of economic growth and improving the international competitiveness of the UK economy when making regulations under Parts 1 and 2 of this bill. Yet, if passed, it would of course be a wrecking amendment, because the government does not know how it intends to give effect to the provisions on guaranteed hours, on the extension of these provisions to agency workers, the provisions on unfair dismissal, to name but a few. All of that will be left to regulations after this bill is passed, without proper scrutiny from this place. And it will be working people who, of course, pay the price. On New Clause 91, New Clause 91 would clamp down on public sector employers using positive discrimination under Sections 158 and 159 of the Equality Act, where this caused detriment to other employees and to promote merit-based employment practices. Taxpayers rightly expect that their money should be spent well. Part of offering value for money is that taxpayer money should be ruthlessly focused on improving the public services on which all of our constituents rely. That always means hiring on merit. Amendment 290 on the school staff support staff negotiating body is the last of our amendments that I will speak to. In 2010, The then Conservative Secretary of State for Education, Michael Gove, abolished the school support staff negotiating body. The Conservative government had a clear and principled reason for this, that employers should have the flexibility to set pay and conditions locally rather than having a top-down centralised framework imposed on them, to allow school leaders who know better than politicians in Whitehall to innovate, to do what worked best for their schools, their pupils and their employees. Instead of giving employers flexibility to do what works best for them, the government is re-establishing a national terms and conditions handbook, training, career progression routes and pay rates for school support staff, which all school employers will be obliged to follow. We believe the current arrangements for employing school support staff are working well and have allowed for innovation. I've explained that I do not wish to incur Madam Deputy Speaker's wrath, which I fear is close at this point, so I will make some progress, and have allowed for innovation that is beneficial for pupils. We believe that school employers must retain a degree of freedom and flexibility to recruit, develop, remunerate and deploy their staff for the benefit of the children in their community to achieve their particular aims from a school improvement or inclusion perspective, and I urge the government to consider this. There are many, many more amendments that I could speak to, but I won't, Madam Deputy Speaker, other than to say this is a bad bit of legislation. The amendments before us from the government in particular, in many respects, make this worse. They add an already heavy burden to business that will combat growth, that will slap down growth, that will not mean that they achieve the objectives they have set out to achieve in their landmarks and missions and road signs and whatever else it is they have announced. And therefore, I urge the government to look at our amendments, to go back and to tame the worst excesses of this job-destroying bill.
Before I call the Chair of the Business and Trade Select Committee, I just wanted to make it clear I would then be going next to Steve Darling, the Liberal Democrat spokesperson, but immediately after Mr Darling there will be a 6-minute time limit. Liam Byrne.
Madam Deputy Speaker, thank you very much indeed. I'm going to be very brief and just make 3 quick points, and I'm going to do my best to try and salvage a degree of consensus from the conflict that has characterised the outset of the debate. I think that if there are a couple of things that unite us across this House, is that we do all believe in fair play. We do all believe in an honest day's pay for an honest day's work. But the reality is that millions of workers in this country are simply not earning their fair share of the wealth that we produce together. The reality is that if wages, labour income, was the same share of national income as it was back in the 1950s, there would be something like £12,000 a year going into pay packets for every single one of the 33.8 million workers in this country. And so after we've had this decade that has seen 4 million people trapped in low pay, after a decade in which we have had a living standards crisis, it behoves each and every one of us to think more creative and more constructively about how we support workers in this economy earn a good life for them and their family. Now, on our committee, we had the privilege of hearing from some of the best employers in the country, but we also had the duty to interrogate many of those firms which, frankly, were letting down our country. And I just want to highlight 3 examples to light up some of the amendments that are down in my name and the names of honourable and right honourable members, because these are not amendments that I wish to put to the vote, but they are amendments which are probing amendments and on which I think the Minister needs to provide the House with some answers. Let me just start with McDonald's, because I referenced that in an earlier intervention. This is one of the most significant employers in our country. It employs over 200,000 people. 90% of workers in McDonald's are on 0-hours contracts. And it was the BBC investigation, indeed Zoe Conway, the employment correspondent, who on the day of our hearing exposed the reality that hundreds of McDonald's employees were contacting the BBC and the EHRC with allegations of the most appalling harassment. Indeed, we heard the case of a 17-year-old worker for McDonald's who alleged that she was being asked for sex in return for a manager giving her the shifts that they want. How on earth can that be acceptable in today's economy? And yet, when we put this point to the chief executive of McDonald's and said, do you think that the imbalance of power that has flourished in McDonald's because of 90% of your workers being on zero-hour contracts, has anything to do with this litany of abuse, has anything to do with 700 workers contacting their solicitors to bring a case against McDonald's? The answer was no. Absolutely extraordinary denial of the reality. Second, we then heard from Every. Every, as many people know, one of the most significant courier firms in this country, employs tens of thousands of people. Mr. Hugo Martin came before our committee to give evidence and told the committee that all at Every was sweetness and light. We have now received, as a committee, hundreds upon hundreds of complaints from whistleblowers alleging the way that they are cheated and undercut, most recently through the rate cuts, the packet racket, which is still persisting, health and safety abuses at work, intimidation, bullying, harassment, being told time and time again that their shifts will be cut or they will be out the door if they don't work 6 days a week. This is just completely unacceptable behaviour that is happening to our constituents. And then, of course, Madam Deputy Speaker, and here I must be careful of scope, but then, of course, we heard from the company Sheehan, who couldn't even tell the committee whether the products that they made contained cotton in China. We were simply trying to understand whether workers in our country are being undercut by abuse of modern slavery practices abroad. And so I say to the House that although we may have our differences about this bill, we have got to accept the reality that for millions of people in this country, for millions of the people that we are sent to this House to represent, they are being treated in a way that should be unacceptable in a 21st century economy. And of course, what the good employers said to our committee time and time again is that actually they supported the spirit of this legislation. Of course, there were concerns about the detail, and it's good that the Minister has listened. But what they did not want to see persist is a situation that they feared, which is that the good firms are being undercut by the bad. We've got to have a level playing field in this country. That is going to be a necessity if we're going to win a global race to the top. So, Madam Deputy Speaker, Amendments 275 and to 277 in my name actually suggest some amendments to the zero hours regime that the Minister has set out. Actually, I think that we should be abolishing the definitions of low hours in the contracts. I accept the evidence that was given to us by Paddy Lewis, a brilliant General Secretary of USDOR, that keeping that definition of low hours in the contract actually creates the risk of loopholes that will be exploited by bad employers. And then Amendments 278 to 281 are what you might call the McDonald's amendments. So these are amendments that basically urge the Minister to put on the face of the bill a definition of what is reasonable notice, to move shifts, to put on the face of the bill the compensation that should be entailed if there are unreasonable moves in shifts. Because we need to make sure that our workers in this country, particularly young workers, are never again open to the kind of abuse that we have seen unfold at McDonald's. Those days must be consigned to the past. New Clause 80 is what you might then call the Every Amendment. That creates an obligation, a duty on the Minister to bring before this House within 6 months of this bill the finalisation of a review of single status of workers. We heard compelling evidence from the Director of Labour Market Enforcement, who said to us that the government, ministers, civil servants could consult, in her words, until the cows came home. We could put this consultation about the different kinds of definition of worker off forever and a day. And actually, what we need to do is end the kind of abuse that we see at Every now. And so making sure that these loopholes are closed, so that bogus self-employment is no longer a loophole through which bad employers abuse honest workers in this country. That's a requirement that I would like to see the Minister step up to. Finally, Madam Deputy Speaker, New Clause 81 is what you might call the Sheehan Amendment. And this requires the government to update the Modern Slavery Act, in particular Section 54, to ensure that the employment rights which are granted in this bill are not simply undermined by companies operating in this country which are abusing modern slavery legislation. At the time, the Modern Slavery Act was world-leading legislation, but now we heard clear evidence from companies like Tesco's that this country was at risk, in their words, of becoming a dumping ground of bad products produced by workers exploited abroad. We cannot have a situation where this country that led the abolition of slavery is now a country where we have second-class protections against modern slavery in the 21st century. That is not something that we should permit, and so I would welcome a commitment from the Minister as to when the Modern Slavery Act is going to be updated. Finally, Madam Deputy Speaker, we welcomed some of the amendments that the Minister has brought forward, in particular the enhanced protection for agency workers and action on umbrella companies. Those were both recommendations which we carried in an excellent report, our report from the Select Committee to the House, which I commend to all members. But I hope from this debate we can salvage some consensus. This bill is going to go through today. This will be the biggest overhaul of employment rights in this country. Yeah. We've got to make sure that it is something that lasts for the future. And the more that we can do to bring a cross-party consensus around that simple idea that every worker, every constituent in this country should have the right, the power, the freedom to earn a good life for them and their family, the sooner we bring that consensus, the better.
Yeah. Liberal Democrat spokesperson Steve Darling.
Thank you, Madam Deputy Speaker. And the holy grail that all governments seek, of whichever hue, is economic growth. And I think, therefore, it's really important that we look through the lens of economic growth and whether the employment bill actually drives economic growth. I know from my time on the Bill Committee that I spent with the many hours with the member for Buckinghamshire, hearing his oratory for many hours, that we spoke much about productivity and whether this bill would be driving productivity. When I've engaged with people in my community, such as Enlightened HR and Alison Bennett, around what the impact of this bill could be, the destination for her as a HR consultant was very welcome, and we've heard from lots of people who have been consulted on this bill that the destination and the aspirations of this are correct and appropriate, but it's how we get there and whether the government have got the balance right between employers and employees there is really important, because the last thing we want this to do is having a chilling effect on the economy. We're only too aware of how the national insurance contributions that are set to kick in April are already having that negative impact on our economy, and we don't want this well-intended piece of legislation to echo that further. The fact that there are 250 amendments coming before us today at this late stage of this legislation, whilst the Minister says that this is due to levels of consultation and so forth and should be welcomed, of us trimming our sails, if that was the case, why did, and if the Minister is in such listening mode at the Bill Committee, why were no amendments accepted at all by the government from opposition members if they were on listening mode? So I'd welcome some reflections on the wind-up for the Minister there. As Liberal Democrats and Liberal Democrat spokesman for the DWP, carers are front and centre of our world. The fact that we have the population of Portsmouth, effectively 200,000 people a year, walking away from the employment market to take up caring occupations and support what is often members of their families. That's 600 a day walking away. That has the impact of £8 billion a year on our economy that leaves us less productive as an economy. So our amendment as Liberal Democrats around making leave for carers a paid opportunity is something that I would hope that the government would give serious thought to, because making sure that those carers have that flexibility and that breathing space will actually unlock more people for our market of employment. Making carers a protective characteristic is extremely important. We've already heard about harassment elsewhere and discrimination as part of this bill, but that would help support carers immensely. Ensuring that there is also a doubling of pay for those who are taking adoptive leave is extremely important. Driving that there is that support for those people who take those caring roles, such as kinship care, is extremely important. And I would hope that the Minister would take these family roles into account.
Will my honourable friend give way?
With great pleasure.
I'm very grateful to my honourable friend for giving way. Does he agree with me that the government has missed an opportunity to recognise the extraordinary contribution of kinship carers in this legislation? I recently met with a couple in my Bicester and Woodstock constituency who are kinship carers. They acted out of love, but they've had none of the support that foster parents would have had in looking after the children in their care. So does my honourable friend agree that the government would do well to look at including the same employment rights for kinship carers as they currently offer to foster parents?
Steve Darling.
Thank you. As somebody who's adopted myself, I only know too well the importance of that supportive love. And also somebody who's been involved heavily with children's services, Madam Deputy Speaker. I know that often the best care for those children who are in need of loving homes are often not too far away from home, and the more that children's services can be less of a child rescuing service and more of a child support service, the better. So I would strongly endorse what my colleague alluded to there, Madam Deputy Speaker. An area that exercised the member for Mid-Buckinghamshire particularly was around third-party harassment, and I would strongly support the proposals from the government in this bill. Having engaged with young women in Torbay, particularly from Torquay Girls Grammar School, who work in retail and the hospitality industry, they find that harassment in the workplace not a bit of banter, but repugnant in the extreme. And they often will go to a shift with, and they shared with me when I visited Torquay Girls, that they would go to a shift with a sick at the pit of their stomach, feeling sick that they knew that this particular individual would be coming in that evening who would act inappropriately with them, and therefore their managers should have a duty of care towards them, and I welcome that within this bill. I know that there's also non-disclosure agreements that are alluded to with amendments here, and I would welcome the kind words that the Minister have said around that, but warm words do not actually get it onto legislation. So I would ask the Minister to reflect on that, and I'm sure colleagues will intervene on NDAs. Finally, the areas I need to cover are in respect of probationary periods. And as Liberal Democrats, we would really welcome ensuring that it is a 3 to 9 months on the front of this bill. This would ensure that there is less chance of expensive tribunals for employers. We'd also like to welcome the steps that the government have made in respect of statutory sick pay, but we need to ensure that the balance is struck correctly between the burden on employers and positive outcomes for the employees. So in conclusion, Madam Deputy Speaker.
Would my honourable friend give way?
Very happily.
I'm very grateful to my honourable friend for giving way. I'd like to welcome the amendments put forward by the Liberal Democrats, in particular amendments 12, new clauses 12, 13 and 14, which would extend parental rights, and particularly paternity rights, from 2 to 6 weeks in terms of leave, and doubling the amount of pay. Those precious weeks are essential for fathers to bond with their child and to provide additional support to their partners. Would he agree with me that these are essential amendments that the government should accept?
Thank you, Madam Deputy Speaker, and I would agree with my colleague that actually When you go and speak to primary school teachers, the challenges that they particularly face is where there is poor attachment between the parent and the child, and that can have a significant developmental impact on young people. So by giving those greater powers through this bill, one can only drive that great strength of connection between that part of the family unit. So, in conclusion, the reality is that we need to be supporting small businesses and getting the balance right between what the good stuff within this bill is, but making sure we're not punishing businesses, making sure that we're supporting the family, because most of what I've spoken to as the Liberal Democrat spokesperson is the family is the core part of what our society is, and strengthening that will hopefully strengthen outcomes and strengthening our society. My fear is that this is a little bit like Snow White's apple, that it may look extremely good on the outside, but it did send her to sleep. And my fear is that this employment bill is a little like that, where actually it may have lots of promise on the outside, but it could be a sleeping potion for our economy. Thank you, Madam Deputy Speaker.
Peter Dowd.
Thank you, Madam Deputy Speaker. First, I'd like to give my full support to the measures in the bill. They are, without question, some of the most progressive in this area of legislation for decades. My amendment, my new clause 25, seeks to set up a working time council comprising of representatives of businesses, trade unions, government departments and experts on the subject to advise the Secretary of State how such a transition to a 4-day week from a 5-day week would affect employers and employees, and how businesses, public bodies and other organisations should approach such a transition. And virtually every progressive change in employment legislation over the decades has been poo-pooed by the party opposite. And leopards don't change the spots, and we saw that in its spades today, Madam Deputy Speaker. The Minister asked of some witnesses at the evidence session what productivity implications of some of the proposals contained in the bill would be, and the answer from Professor Simon Deacon from Cambridge University was that there was a strong correlation between strong protection, labour protection, and both productivity and innovation. He went on to say, research shows that on average strengthening employment laws in this country in the last 50 years has had pro-employment effects for various reasons. And I know the Shadow Minister was there when he said that. Historically, it's a well-trodden path for some to object to measures that would advance employment rights, even if those rights were of advantage to everyone concerned, whether that was employers, employees and society more generally. So this is especially so in the medium to long term. Legislatures don't just legislate for today, they also legislate for tomorrow. And can I thank the my honourable friend, and my admiration for him knows no bounds for the work he's put into this bill, and of course other members on the bill as well. The primary aim in introducing this new clause is to try to get the debate about the 4-day week off the blocks. I accept that the notion is a challenging one, but it's not a reason to put off the debate. The discussion has to be had. It's over 100 years since the introduction of a 5-day week in different industries. The influence of Henry Ford, not the most radical of people, in the 1920s, in introducing the 2-day weekend for those working in his car factories was a pivotal moment. He argued that it would boost worker productivity and morale, and, of course, it did. The logic of the argument that a shorter week affects business resilience or productivity has been used time and time again. I mean, even as late as 1961, a Factory Act, a requirement to deal with overcrowding to be dealt with, temperature control, ventilation to be introduced, all opposed at the time on the basis of cost. And the same argument was put, as colleagues will know, about the Equal Pay Act. That was the same. It was the same when paid holidays were introduced in 1938. What about the minimum wage? It was going to cost hundreds of thousands of jobs. Well, it didn't, and we all know it didn't. Paternity leave, maternity leave, all eschewed as a cost to industry that damaged it. And did it damage it? No, it didn't. So research from Barclays showed working hours in the UK have fallen 5% on average in the past 4 decades, with British workers now working 27% more hours on average than their German counterparts. Meanwhile, France, Italy, Spain enjoyed a 10% decline in working hours, and yet despite people in this country working longer hours than our competitors or partners, as a nation, we're one of the least productive in the G7. And we've got to do something about that, Madam Deputy Speaker. What about the impact upon employers? Well, I don't want to, but I will give one.
I thank the honourable member for giving way, and maybe I'm preempting the answer he was going to give. I was just going to ask exactly what these measures are, the magic potion that will improve the productivity that are contained within this bill and these amendments.
I'm pleased the honourable lady asked me that question, because it's patently obvious that better working conditions lead to less absenteeism. They lead to more resilience in the workforce. They lead to better productivity. It's not a magic potion. It's what's known as enlightened employment. And maybe the honourable lady would like to read about that. I'll put her in touch with a few people who can talk to her about it if she wants. 71% in that study reported reduced levels of burnout. 54% was easier to balance work with household responsibilities. 60% found an increased ability to combine paid work with care responsibilities. 62% reported it was easier to combine work with social life, and so on, and so on, and so on. So what it seeks to do is to put the issue, as I said, on the agenda. Because, Madam Deputy Speaker, I believe it's inevitable. History shows it that changes in patterns of work, working arrangements, the nature of work and other associated issues, AI, will eventually lead to a 4-day week over a period of time. So let's embrace the change. Let's plan for the change. If we do want to get the country back to work, we do want to get the country working productively, if we do want to get many millions of people without work back into work, well, let's do it as progressively as we possibly can. Finally, Madam Deputy Speaker, if lengthening the time we are asking people to work by an extra year, 2 years, 3 years maybe in the future, the least we can do if we're asking them to work a longer life is to ask them to have a shorter week. What's wrong with that? And is that really too much to ask, Madam Deputy Speaker? I don't think so, and many more employers and employees take the same view. So let's not make an enemy of progress. Why don't we just embrace it? Thank you, Madam Deputy.
Damian Hinds.
Thank you, Madam Deputy Speaker. I rise to speak to the measures on zero-hours contracts and Opposition New Clause 83 and Amendment 283. It's absolutely right that we should pause to consider the effects of these changes on employment tribunals. It's also right we should pause to consider their effect just on employment. And of course there are bad employers. There are those who would seek to exploit. That is a very bad thing, and we should bear down upon them. But there is no reason to believe that these measures the government is bringing forward will achieve that. I suggest that the government wants to get rid of zero-hours contracts, not because intrinsically there is some great problem attached to them, but because of the special place that zero-hours contracts have in Labour mythology. And I want to bring us back to the glory days of the modern Labour Party, when the leader of the Labour Party was the current leader's immediate predecessor, the right honourable member for Islington North. And I see the then Shadow Chancellor is with us here in the chamber today. As it happens, I was the Minister for Employment at the time. Unemployment, when that government came to power, had been 8%. It then rose a little bit to 8.5%. At the end of 2011, and from then on it came down, and it kept coming down and kept coming down. By late 2016 it was under 5%, and it would fall further still. But that didn't fit the Labour Party's narrative. They wanted to be able to say that this reduction in unemployment wasn't real. It was all fake employment. It was low quality employment. That wasn't true, but it didn't stop them saying it. In fact, 3/4 of the increase in employment was in higher skilled occupations. 3/4 of the jobs growth was full-time. And at that time, growth in employment was growing much more quickly than self-employment. And the number one sector for employment growth at the time was, in fact, in construction. But still, they kept saying these were all low-quality jobs that were being created. And the top of the list of the things to call out was the 0 hours contracts. And the then leader of the opposition used to talk about it weekly at Prime Minister's question times. There were a couple of awkward moments, like after his glorious appearance at Glastonbury, when it turned out that the Glastonbury Festival, guess what, was employing people on 0 hours contracts. There was further embarrassment when it turned out that none other than the Labour Party conference, there were people working there on 0 hours contracts. At the DWP, we did some research. It turned out that less than 3% of people relied on a 0 hours contract for their main employment. On average, it delivered them 25 hours work a week. Strangely, they had above average job satisfaction, and most were not looking for more hours. People said the number had grown, but actually that was much more likely because of growing awareness of the term 0 hours contract. In fact, when you think about our history, there has long been far more than 3% of people have had irregular income patterns where they have not had guaranteed hours of work or levels of salary, from casual labour to piecework, catalogue agents, commission-only sales. And at a certain point, it dawned on me, Madam Deputy Speaker, that my own first job had been a 0 hours contract washing dishes, or at least it would have been had there been a contract involved at all. The Honourable Lady.
Thank the Honourable Member for giving way. Would the Honourable Member accept that choosing to take on an irregular contract when you're at the high end of the pay scale with significant professional skills and expectations for the future is very different to the endemic insecurity at the bottom of the labour market, which is where 0 hours contracts are concentrated? 83% of people on a 0 hours contract.
I think the Honourable Lady is in fact making her speech rather than an intervention. I'm sure that will come tomorrow. Damian Hinds.
But of course she is right. Of course those things are different. But in this dawning realisation that I had back then, I started to wonder, well, who else might take 0 hours contracts? And yes, it is true that disproportionately it is young people. Actually, quite a lot of people, a 0 hours contract is a second job. And I'd be interested to hear from the government what their assessment of that is. It turns out that one of the biggest users in the country of 0 hours contracts, when we looked at this in 2016, was none other than the National Health Service. So they could cope with increases in demand. These were people who had a permanent job as well, but as bank staff could then supply other hours when that was needed. Now, Madam Deputy Speaker, for this government, it is totemic to do something about 0 hours contracts because of that Labour mythology. For the unions, there is another reason too. This is classic insider-outsider theory, a shift in remuneration from people who are not in work to people who are already in work. It pushes up the what's called the non-accelerating inflation rate of unemployment. Or, Madam Deputy Speaker, in plain English, it is bad for jobs. And the Chancellor of the Exchequer must know this, because as we all know, the Chancellor of the Exchequer is most definitely an economist. She has worked as an economist, she is trained as an economist, she is an economist. And this is classical economic reality. So who might 0 hours contracts work well for? Well, for any employer with an unpredictable variable need for workers. From the events business that I mentioned to the NHS, which I also mentioned. There are obvious cases also in tourism, in agriculture and food. But also for some individuals. Now, some people may just choose to have that flexibility. Absolutely, over the last few years, it has been a seller's market to go into teaching. But some people have still chosen to become a supply teacher because, for whatever reason, for them that works well. And the other group for whom it may work is those furthest from the labour market who have perhaps been out of work for a very long time, or perhaps they're ex-offenders, or for some other reason, it is difficult to immediately land a a regular full-time job. And especially when combined with universal credit, which, by the way, the Honourable Member for Islington North also wanted to abolish, when combined with universal credit, which could adjust its top-up payment according to how much you earn week to week, can work very well. This legislation is bound to have unintended consequences. We don't know exactly which ones they will be, but I will suggest they could include suppressing seasonal peaks in employment for tourism in the summer, but also at Christmas time, because employers won't want to take on the liability from the reference period. It could deter people from second jobs. That will be bad for growth. It could mean people move from contracted employment to self-employment or casual work. It could mean a move from permanent contracts to temporary contracts. And yes, it could hit our National Health Service and other important public sector employers. Madam Deputy Speaker, I don't doubt that this piece of legislation will be good for unions, but it will be bad for the economy and bad for growth, and it will be especially bad for those people in the hardest circumstances who so badly want to get back to work and for whom this kind of contract can also be that important first step.
Louise Haigh.
Thank you very much, Madam Deputy Speaker. And can I begin by congratulating my right honourable friend, the Deputy Prime Minister and the Employment Minister for all their incredible work in bringing forward this landmark piece of legislation. Can I also pay tribute to my honourable friend, the member for Oxford, West and Abingdon, who is co-sponsoring New Clause 74 with me today. This is the first speech, Madam Deputy Speaker, that I've given as a backbencher in nearly 10 years. And one of the few benefits of elevating oneself to the backbenchers is the ability to speak much more routinely on behalf of my constituents and those without a political voice. And the amendment that I rise to speak to today is literally about the voiceless. It is about those who have been legally silenced in the name of organisational and personal preservation. New Clause 74 prohibits employers from entering into non-disclosure agreements with workers in relation to complaints of sexual misconduct, abuse, harassment or discrimination. It mirrors very closely legislation passed in Ireland recently that bans NDAs in these circumstances, but allows them at the express consent of the victim, and legislation has been passed in multiple US states in relation to sexual harassment. NDAs have a perfectly legitimate use in business to protect commercial confidentiality and trade, but they are frequently misused in order to bully people into silence when they have already suffered at work. We know of the most high-profile cases, from Harvey Weinstein to Mohammed Al-Fayed, only because their brave survivors risked breaching their NDAs. But these agreements are far from confined to celebrity abusers. They are being misused and exploited on a vast scale. The campaign Can't Buy My Silence, led by Zelda Perkins, who helped expose the abuse of Harvey Weinstein, has also uncovered multiple scandals in the higher education sector, which led to action by the former government to ban the use of NDAs in that sector. We sadly know in our own Labour movement that trade unions have been accused of using confidentiality clauses in settlements, which have the same chilling effect as NDAs. I have been told stories.
Would the member be kind enough to declare her union interests from her register of financial interests? I believe there's a £10,000 donation.
That is not a matter for the Chair, but it is a point for the member. Louise Haigh.
Very grateful for that point of order. I'm, of course, very happy to declare my register of interest, just as I am in the process of criticising a trade union. Trade unions have been accused of using confidentiality clauses in settlements which have the same chilling effect as NDAs. I have been told of stories that should be on the front pages of newspapers, such as the man who was accused of rape, who signed an NDA and was paid off. His alleged victim only found out years later that that had been the case, while she was still working in the same workplace. Media organisations like ITN have come under recent criticism as former employee Daisy Ailiff said, women who work for ITN have tried to report harassment and discrimination, but soon after doing so found themselves suddenly out of a job and bound by non-disclosure agreements. Another former employee of ITN, upon seeing Daisy speak out, realised that his experience was far from unique and has asked that I use parliamentary privilege today to speak about the confidentiality clause that he was required to sign. He's asked that I not use his name, so we'll call him Mr. B. Mr. B joined ITN in 2008 on a scheme called Enabling Talent, which aimed to recruit more disabled people into the organisation. He suffers from a condition called functional neurological disorder, which has a number of symptoms, including non-epileptic seizures or dissociate seizures, which he describes as zone-outs or blackouts. In 2008, ITN made a number of reasonable adjustments for him, including help with note-taking, a key to the first aid room, and disability leave when required in order to avoid these stress and fatigue-induced seizures. He states that at the time he could not fault his employer for the support that they gave him. He left ITN to pursue his career elsewhere and returned in 2017 when he again declared his disability and made a request for similar adjustments. Despite multiple requests for the kind of help that he had received before, none were forthcoming. Instead, he suffered severe bullying and discrimination, including pressure to widely disclose his disability to his colleagues. The situation got so bad that his zone-outs and blackouts became increasingly frequent, and after suffering from one seizure at work, he was required to apologise to those that had witnessed it. He was repeatedly accused of lying about his disability and told his issues were nothing to do with his disability, despite joining ITN on a disability inclusion scheme. Mr B took ITN to tribunal, incurring tens of thousands in legal costs. He settled, but was required to sign a confidentiality clause. His health has deteriorated so badly that he now uses a wheelchair 50% of the time, and following the loss of his job, he was, for a period, made homeless.
Would my friend give way?
I'm very happy to give way.
Would she agree that in cases like that of Mr B, there is no public interest and no interest for anyone apart from the guilty parties to keep these things secret, and that's why it's important that NDAs aren't used to hide problems that employers have and they should sort out?
I'm very grateful to my honourable friend for that intervention, and he's absolutely right. There are many organisations, including the BBC, that as a policy do not use NDAs. Because imagine suffering that kind of treatment at work, losing your job, losing your health, and then being banned from explaining to another potential employer or even your closest friends what has happened to you. It makes it next to impossible to recover from the experience, very difficult to find work again, and vanishingly unlikely that the organisation will face up to its wrongdoing and enact change. For Mr B, for the survivors of monsters like Mohammed Al-Fayed, and for the thousands of victims across our society who have been legally required to suffer in silence, I hope the House can agree that such agreements have no place in modern society.
Absolutely.
And if it can happen in organisations like ITN, whose literal job it is to expose injustice, or in trade unions, whose job it is to protect workers, then it can happen anywhere. Organisations in these instances, no matter who they are, will circle the wagons and protect themselves rather than the victim, and by doing so, they protect abusers. That is why we must simply remove the tools of their abuse and end the use of NDAs in these circumstances. I'm very grateful to the Minister for his response earlier and for confirming that it warrants further consideration. But can I press him a little further on exactly how we can see progress? And we must see progress. It is sickening that across this country, women and men will have suffered abuse in their workplace, and instead of action against the perpetrator, they are the ones that are shamed and silenced, ganged up on lawyers and sentenced to a lifetime of regret.
Call Sir Ashley Fox.
Thank you, Madam Deputy Speaker. As a member of the Public Bill Committee for this bill, I was surprised by the number of amendments that the government tabled to its own legislation at committee. Hundreds of amendments demonstrating how badly this bill was drafted when it was first proposed. It was clearly a bad idea to commit to introducing such a major piece of legislation within 100 days of the election, but I guess that was the price of trade union money to fund the party opposite. And having spent 21 sessions in committee, scrutinising this bill line by line, we now find ourselves with another vast number of government amendments once again, but this time with only 2 days to scrutinise it. Most of the amendments in that package are the government's amendments. The amendment paper is thicker than the original bill. Now, this is a bad bill. It pushes up the cost of labour, it makes our flexible labour market less flexible, and will increase unemployment. But, Madam Deputy Speaker, there is one amendment, new clause 30, which I am pleased to propose. This adds special constables within the scope of Section 50 of the Employment Rights Act 1996 and would give them the right to unpaid leave to perform their duties. Special constables are volunteers. They give their time at no cost to the taxpayer to help our police forces. Specials have existed in some form ever since the Special Constables Act of 1831, which allowed justices of the peace to conscript volunteers to combat riots and social unrest. The Special Constabulary, as we know it, was established by the Police Act of 1964, which gave Chief Constables the authority to appoint and manage special constables. Today's specials carry all the same legal powers as their full-time counterparts, both on and off duty. They put themselves in harm's way without payment to keep our society safe. Today, the Special Constabulary, an institution that has served this nation for nearly 2 centuries, faces a crisis. The number of volunteer officers has fallen by 2/3 in the last decade. In the past year alone, we've seen a 20% drop, and many police forces now face significant gaps in their special constabulary ranks. This isn't just a temporary dip, it's a long-term trend. There are multiple factors at play, but clearly becoming a special isn't an attractive proposition to too many potential recruits. I believe we must act now to ensure the Special Constabulary continues to play a vital role in policing for generations to come. And it is in this context that I bring forward my amendment to the Employment Rights Bill to amend Section 50 of the Employment Rights Act 1996. For those not aware of Section 50, it allows those undertaking a number of community roles to request unpaid time off work to perform their duties. On that list are magistrates, local councillors, school governors, members of the Environment Agency even. It seems strange to me that we exclude those prepared to keep us safe from that list of community-minded citizens. Of course, some employers are understanding and already try and support officers on their staff. When ASCO, the Association of Special Constabulary Officers, wrote to the Minister calling for him to back these changes, he responded that the employer-supported policing scheme was being promoted to increase the number of specials. But this is simply not enough. A survey completed by ASCO last year showed that over 60% of specials are not supported by their employers. It is currently lawful for employers to refuse time off for specials. Now, the riots last summer demonstrate the benefit of having a flexible police force. Given the government's focus on promoting neighbourhood and community policing, increasing the number of specials seems like a good choice. This measure will not cost the taxpayer a penny. It simply puts special constables on the same footing as other volunteers. Now, this amendment has been signed by honourable and right honourable members from almost every party represented in this House. It has been endorsed by 10 police and crime commissioners. Importantly, Assistant Chief Constable Bill Dutton, acting in his capacity as the National Police Chiefs Council lead for the Special Constabulary, has provided his written support to include special constables under Section 50. I believe this amendment would help the recruitment and retention of many new special constables. It would make our streets safer. It would also finally recognise the work of the specials and put them on the same footing as the thousands of other people in the country who are allowed time off work to complete valuable civic duties. And it's in that spirit that I'd ask the Minister to seriously consider whether the government would accept New Clause 30. Thank you.
I call Matt Weston.
Thank you, Madam Deputy Speaker, and I refer members to my register of interests and my union membership. The legislation before us today is truly historic. It is totemic in its scale. It is the biggest upgrade to workers' rights in a generation. I commend my honourable friend and the team for the work they've done. Not only does it deliver work for working families, but it also delivers for the whole country. It will lead to higher productivity, higher wages, and ultimately economic growth. These reforms are unashamedly pro-worker and pro-business, and this is in sharp contrast to the past 14 years, where we saw low pay, low productivity, and low growth in the economy. Shockingly, productivity grew by just 0.2% per year between 2010 and 2020. And since 2011, we've seen insecure work rise nearly 3 times faster than secure work. Whether it be the 800 P&O workers who were sacked over Zoom without notice, the retail worker whose shift gets cancelled last minute and now can't afford their weekly food shop, or the 9 million people who are not protected from unfair dismissal. That is 1 in 3 workers not protected from unfair dismissal in this country. It cannot go on. I just want to talk briefly about some of the measures in the bill. Day one rights. This is a serious boost for millions of people. 9 million workers have less than 2 years' service with their employer and thus do not enjoy the protections from unfair dismissal. So I'd welcome some clarity, specifically around the initial period of employment and what specific time frame it would apply to and what does it exactly mean. Also, I would urge the government to look at what support is available for some smaller firms that are concerned about the impact it may have on their costs, and look at what more can be done to guide companies through these changes. Zero-hour contracts, of course, is endemic across our economy, and so many people with those contracts are given such little notice of a cancellation of the work when they may have already made provision for childcare or for travel arrangements. When I just look at industrial relations, and I think that one of the important elements from the legislation is setting the new framework for industrial relations. What we heard on the Business and Trade Select Committee session was from so many good employers such as Jaguar Land Rover and British Aerospace, where the work that they do with the unions to create the right employment practices across their businesses. But by contrast, we also witness the mistreatment of workers and denial of basic workers' rights at Amazon, where there is clear problems in the workplace. I also think the work or the proposal for the Fair Work Agency, which of course is welcomed by unions, but also progressive businesses, is a very positive move. I would just, as we heard in our Business and Trade Select Committee, the need for the government to resource that agency adequately because it is so important. If I could just turn, Madam Deputy Speaker, to some of the amendments that I support, and just heard from my honourable friend about new clause 74. And I would just reference a particular constituent of mine, Mrs. E, who was the victim of harassment in the workplace, the victim to a prolific individual in that workplace who was protected by the management, and ultimately she had to leave the organisation, and ultimately he left too. But this is such a disadvantage, such a problem, and this is one of the issues that this legislation must address. And then I want to talk just about new clause 81, and which references modern slavery, when we heard from Sheen and the sorts of problems that company brings because of the fact that companies in the UK are being disadvantaged by modern slavery and the practices of businesses operating elsewhere. But if I could, Madam Deputy Speaker, I just want to highlight a bit further on productivity and the points I was referencing to the Shadow Minister. And what I think is important with this legislation is not only the great benefits it brings to employees, to workers, but also greater responsibilities to employers. But with tighter employment legislation, as you see in France, as you see in Germany, ultimately leads to greater productivity. Both those countries seeing up to 20% advantage in terms of their productivity versus the UK. And that is why we've seen such a stagnant economy in the UK the last 10 years. This legislation, Madam Deputy Speaker, is another reminder to the people of this country that only this party can deliver for working families. Less uncertainty at work, less insecurity at work, and putting more money in people's pockets. I would just urge the government to look at the Fair Work Agency, as I was mentioning earlier, particularly the definitions of reasonable notice, moved and short notice, and clarity on how many weeks the initial and subsequent reference periods would be. And in conclusion, Madam Deputy Speaker, I think this is a colossal piece of legislation, so important in this decade. It brings about real change, and that is what this party is going to deliver for working people, boosting productivity and ultimately growing the economy.
Moran. I rise to speak to new clause 74 in the name of my right honourable friend from Sheffield, Heeley, who I pay tribute to. The backbenchers are very lucky to have her. But may I also pay tribute to Mr B, whose story she so movingly told. Now, this campaign to redress the power imbalance to those offered non-disclosure agreements in cases of sexual harassment, bullying and discrimination has been many years in the making. It transcends organisations and it transcends party. And I want to pay tribute to members past and present of all colours who have been a part of this campaign for so long. I was pleased to hear from the Minister from the dispatch box that we hope to continue to make progress, but I hope to urge him to go further, faster, for very good reason, because it's long past time that this just stopped. And I want to start by revealing a never-before-told story, another one from ITN. Now, never before revealed, of course, because it's covered by a non-disclosure agreement, which means I will be using privilege to reveal the details of it. And before I begin, it's worth saying the victim is not alone in this. There have been others from ITN. We've heard one today. I understand there are 7 out there, and there have been investigations done by ITN's board itself who are intent on change. And this victim is very clear. She doesn't want to cause them problems, but she wants MPs to understand the effect this continues to have on her life and why we need to act quickly. So this young woman was in her mid-20s when she landed her dream job at ITN. She quickly became trapped in what we understand to be a coercive, controlling sexual relationship with an older male editor. He would hurl wild accusations at her and accuse her of affairs with colleagues. She ended up suffering with panic attacks as a result of the relationship, and before Christmas 2019, she finally had the courage to end it. And when she returned in January, she was demoted, and her hours reduced, and so was her pay. The first editor, she told, warned her to stay silent. She said, "You don't want to be one of those women who always moan about being wronged." She then confided in a more senior editor, and things got worse. She told her, "It's not like he ever hit you. It's not like you ever had to go to A&E with broken bones." And she returned to work every day for the next year. It took them months to agree to an HR investigation into what happened, and they only agreed on the condition that she would also be investigated. HR found they couldn't assess the complaint as it was criminal in nature, but at the same time found them to be unfounded. Well, that makes no sense. And it was around this time that she raised a question at an ITN Women Empowerment Forum in front of all staff. This was during the pandemic, and she simply asked the question, what support is there for women who report alleged sexual harassment in the workplace? Within an hour, her email was cut off. HR summoned her to an urgent meeting. Her primary offence, it would seem, was asking for help. And from that moment, she was suspended without pay. Now, she'd been completely cut off from almost all support networks for about a year. ITN told her that she wasn't allowed to tell anyone, except the police, to be fair, what was happening. But even her best friend had to sign an NDA to attend a meeting to support her. The NHS offered her group therapy for her anxiety. She felt she had to decline because the organisation insisted she stayed silent. And her lawyer said the organisation was trying to starve her out in negotiations over her exit. This took years. By the time we got to the settlement, she'd already racked up £70,000 worth of legal fees. I will, of course.
I know from experience that is in fact one of the practices of employment lawyers who work for employers to go onto Google Maps and look at the houses in which the complainants live so that they can assess what level of assets they are likely to have and whether they are likely to be able to afford to continue their defence to tribunal and or whether or not they could be offered a smaller amount of settlement. Does she agree with me that NDAs are providing cover for this?
So much for her intervention, and yes, absolutely, this is exactly the kind of behaviour that we need to just put to a stop. So she did eventually reach such a settlement, but it was extremely one-sided, and she panicked because the NDA didn't just gag her, but also her partner, her best friends, and her parents, and not the men or the senior execs involved in the harassment that she'd faced. It didn't just cover business matters, and it's worth saying, we are not seeking to stop confidentiality agreements when it comes to business matters. That is not what we're seeking to do here. But what it did cover was everything painful she had endured. Her mental health spiraled and she ended up in hospital. And every day she was in a hospital bed, the lawyers sent her automatic reminders to sign her NDA. So this was a woman at her most vulnerable. It is entirely wrong that she's been put in that position. And it's worth saying, almost none of that NDA is enforceable. If it was actually taken to court, it would fail. And what's in the Victims' Bill makes it clear that she should be able to have got that support. But the fact, we are kidding ourselves if we think these aren't still being used and still being issued. They are. And that is why we need, on the face of this bill, whether it's now or in the Lords or wherever, we need to put a stop to it now. Now, many years on, following an investigation into the treatment of these workers at ITN, she does believe that that organisation is trying to change, and she's grateful to those executives from within who are pushing for reform. Now, the latest update is that they are willing to renegotiate her NDA, and that is very laudable, but she should never have been put under one in the first place. And those protections should be everywhere. Now, we are facing a weird situation that we've created in this House, because in the Higher Education Freedom of Speech Act, there is provision which was put forward as a Labour amendment, which was then taken on in the Lords by the Conservative then government, that says that these kinds of non-disclosure agreements are not allowed, but only in higher education settings, because that was the scope of that bill. Now, I'm an Oxford MP. How is it making any sense at all that I might have a constituent protected from these kinds of non-disclosure agreements if they work for the university, but if they work for any of the university spin-outs, for example, they're not? We have this problem now. I will, of course.
I thank the member for what is a powerful speech, and I pay tribute to the people who shared their experiences. But does the member also agree with me that the people that we're talking about are people with means and with support networks? And actually, if we don't have these protections, then we don't have protections for the most vulnerable in society, and that's why getting these laws right is so important.
I thank him very much, and they are indeed incredibly brave. And what we're trying to show today is that it's men, women, it's discrimination, it's sexual harassment, and it's ubiquitous, it's happening everywhere, and it's happening now. We are not seeking to try and, silence those. And in fact, if a victim wants one, it even says in this amendment, and it would say it on the face of the bill, that if a victim would want an NDA for whatever reason, that they would be allowed to have it. So what this amendment simply seeks to do is to redress this gap. How is it right that in some establishments, sometime soon, workers will be protected, and in others they aren't? This is the time for the government to sort this out. And what the amendment says is not even exactly how they should do this, but that the protections afforded to all workers anywhere should be the same as those afforded in universities. It says from enactment they've got 6 months to sort it out. That should be plenty of time. Arguably, they should be able to tackle this with something in the Lords, which would then give them a bit of extra time to be able to do this now. And I would urge the Minister to not wait for some other bill or some other time. I welcome the words from the dispatch box. They are meaningful. But I would also urge him to look back, and I appreciate it wasn't this government, it was another one, but we've heard this before. This campaign has transcended party and transcended years, it's transcended parliaments. We're making slow progress, and meanwhile these victims continue to be hurt day after day, and every day that these NDAs endure, which are often in perpetuity, that hurt and that trauma continues. So please, let this be the government in which we put these kinds of abuses of non-disclosure agreements where they belong, in the trash can. And we finally afford the protections that we are about to give to all university workers, to every single employee.
I call Imogen Walker.
Madam Deputy Speaker, as per my register of interests, I'm a member of GMB, and my union membership has given me reassurance for many years that I have backing if I need it. And I am conscious that though in this place we may be listened to when we speak up, for too many people, insecurity and lack of respect at work are an everyday experience. And in addition, businesses have suffered under the failure of the previous government to act where reform was needed. Not in this area alone, of course, but today we are speaking on the relevant amendments, and we can come back to their other failings another day, or perhaps more than one other day, because this is the time for action, and we are the party of business. So, coming to the amendments, we say that everyone should have a contract that reflects the hours that they work. There is a place for flexibility, of course, but people need to sort out transport and childcare and plan their household budgets. So we will ensure that agency and low or zero-hour contracts work for both sides, businesses and workers, because for too long, zero-hour contracts have too often been at the expense of people who are just trying to make a living for themselves and their families. We will put a stop to that. Moving on, a day's work deserves a fair day's pay, and giving the Fair Work Agency the power to bring civil proceeding and issue penalties is an important move. Now, the vast majority of employers respect the rights of the people who work for them and have nothing to fear from this. In fact, they will welcome the fact that the playing field is being levelled. Their good practice, they do tell us all the time, must not be undermined by the unscrupulous minority. We also say that everyone should be free from harassment when they are at their place of work. And the message that honourable members opposite are sending to, amongst others, the many thousands of young women who have been harassed at work when they object to this protection is appalling. In contrast, we believe that everyone deserves respect at work, whatever the industry that they work in. And I would like to reassure, amongst others, workers in the hospitality and retail industries that they do matter and that they do deserve better and that we are on their side. And where issues do happen, it is to everyone's benefit to resolve it quickly. We will fast-track decision-making and back it up with robust fines. This helps businesses and workers. It minimises stress, cost and delay. I'm very pleased that this bill is being welcomed by many of our leading employers, including, we've mentioned them already, Centrica. I know them well. They have a training academy in my constituency of Hamilton and Clyde Valley, and their chief executive, Chris, is fully supportive of this legislation. It's not just the right thing to do, but a foundation for high growth, high skills economy, and the progress that our country needs. Because a stable workforce will help both employers and workers. The chaos of repeated strikes has damaged businesses and services and left our country reeling. The party opposite may be instinctively opposed to empowering ordinary people, but on this side of the House, we say that these are the people that keep our country going, and they have the full support of this government. Thank you.
I call Chris Law.
Madam Deputy Speaker, and I beg to move new clause 75 and speak to other new clauses and amendments in my name. In its manifesto a year ago, the Labour Party committed to, and I quote, strengthen statutory sick pay, remove the lower earnings limit to make it available to all workers, and remove the waiting period. Well, while the removal of the lower earnings limit and the waiting period are welcome, the fact remains the UK statutory sick pay does not meet the needs of working people. The miserly increases to the rates are far from the transformative change that Labour promised and will not help to deliver a healthier population and growing economy. Indeed, Madam Deputy Speaker, it's only a few years ago the Minister, in a debate with the Health Secretary during the COVID period that we lived through, asked repeatedly the Health Secretary if he could live on the statutory sick pay, which has just been increased after 5 years to £2. So to be clear, the UK is lagging behind its provision of SSP, offering one of the least generous systems in the OECD. While the Labour Government is proposing a rate of £118.75 per week, or 80% of their average weekly earnings, whichever is lower, numerous other European countries such as Austria, Germany, Iceland and Luxembourg either provide full salary payments or cover a portion of earnings ranging from 50 to 90%. Amendment 272 would bring the UK in closer alignment with other OECD countries. Madam Deputy Speaker, with limited coverage and relatively low rates, many workers, particularly low-income and part-time employees, are left without sufficient financial support when they fall ill. This gap in sick pay provision impacts workers' well-being, exacerbating financial stress during illness, and can discourage people from taking the necessary time off to recover. It contributes to poorer health outcomes, undermining longer, healthier working lives across the UK population. Surely no one in this House wants this to continue. Indeed, the Roundtree Foundation states the most effective way of strengthening sick pay is by increasing the rate There are numerous amendments to this bill which would do so, including my own clause, new clause 76, which would gradually increase the rate of statutory sick pay over the next 5 years, taking it to at least 80% of rate of the national living wage, and others which propose SSP to be higher of a prescribed rate of percentage of the usual weekly earnings. Moreover, a WPI economics shows that sick pay reforms could result in a net financial benefit to this country of over £4 billion. I also found that the positive effects of sick pay reform would particularly help the increasing proportion of the British workforce managing long-term conditions and ensure that fewer workers fall out of the job market entirely. As an example, Madam Deputy Speaker, many people with multiple sclerosis need to take time off work for reasons related to their condition for varying lengths of time. Some people with MS are well supported by their employer through occupational sick pay, and of course we support that, and can take the time off work they need on full pay. When people with MS can get the financial support they need while they're off work, they can often stay in work longer as they can better manage their symptoms in the long term. This needs to be the same for those with MS and other long-term conditions who rely on SSP. New Clause 75 would require the Secretary of State to consider this, the aim of properly reforming this outdated and inflexible system. Changes for those with such conditions could include SSP being paid at an hourly rate rather than a daily rate to enable people to work half or part days on a gradual phased return to work, or change the restrictions on how people can claim and use SSP so it's fairer for people with fluctuation conditions by extending eligibility timeframes. However, I sadly suspect the Labour Party is looking to slash welfare spending, as has been reported today. 700,000 disabled people being pushed into poverty will be no joy to many, and of little interest in making such supportive and progressive change. But I look forward to hearing from the Minister. Madam Deputy Speaker, the Labour Government's lack of gumption in their approach to SSP is illustrative of the timidity they've approached this employment rights bill with. Yes, it makes improvements to the rights of working people, and yes, it reverses some of the worst excesses of the Tory government, but it could have done so much more. Where is the straightforward system to find a single status of worker to replace the maze of confusing classifications designed to limit protections that continue to exist? Where are the increased provisions for collective bargaining to alleviate low pay? Where have the promises of the right to switch off designed to ensure better work-life balance disappeared to? This was the opportunity to legislate to entrench employment rights to ensure a fairer deal for workers and healthier and more equitable and more productive economy and society. Unfortunately, this bill is still left wanting. So can I ask the Minister if you'll look at these new clauses and amendments if the Labour Party is serious about its manifesto commitments? Thank you.
I call Lorraine Beavers.
Thank you, Madam Deputy Speaker. I welcome the report stage of this bill, and I proudly declare my membership of Unite and the CWU, and I refer to my register of interests. This bill will see the biggest upgrade to workers' rights for a generation. It is an agenda for change that is desperately needed. Working class people keep this country cared for, they keep our streets clean, our shelves stacked and our public services running. But the imbalance of power in our workplace is plain to see. The P&O scandal was a testament to that. This bill represents a crucial first step in redressing that imbalance, especially Amendment 80 on sick pay. It strengthens both collective and individual rights and puts more money in the pockets of working people. I therefore welcome the Government's amendment to the bill, ensuring everyone gets sick pay from the first day they are ill, including those previously excluded for earning too little. Currently, there are around 1.2 million workers excluded from statutory sick pay altogether. And the present 3 days' wait is extremely hard for those on low pay who often budget on a week-to-week basis. Me and my husband were these people who lived week to week and dragged ourselves into work when we weren't well. Because if we didn't work, we didn't eat when my children were small. The bill rectifies this, is extremely welcome.
The pandemic exposed just how inadequate current levels of sick pay are. I would therefore urge the Government to ensure as many workers as possible benefit from the measures in the bill. In particular, I would ask that the Government look at what they can do to increase the rate of statutory sick pay over time, as we currently have one of the lowest rates of sick pay across the developed countries. And I hope the Government continues to consider the impact of the removal of the lower earnings limit to ensure everybody benefits from the measures in this bill. Overall, these changes will be transformative for working people in my constituency of Blackpool North and Fleetwood. As a working class woman from the council estate, it does my heart good to be able to stand in this place supporting changes that will make the lives of working people better, giving them the rewards they so deserve.
I call James Wilde.
Thank you very much, Madam Deputy Speaker, and I pay tribute to all the members who served on, I think it was the 21 committee sessions, and obviously their job was made harder by the fact that this was rushed legislation brought forward purely to spare the blushes of the Deputy Prime Minister who'd made promises to the trade union barons who fund her party. And as a result, we've seen the large number of amendments that we're discussing today. And it's also the case that while the Government has consulted during the passage of this bill, it doesn't appear to have listened to employers very much. And honourable members should be aware of the unintended consequences of these measures and this bill. But turning to the amendments, given the Government's apparent priority is growth, new Clause 87 is an essential addition. Many of the powers in the bill will be implemented through regulations, which clearly the House, employers and employees do not have any detail of. The approach again shows the rushed nature of the legislation, common throughout passages of other bills with regulations we passed in draft while the clauses implementing them were considered. That hasn't happened in this case. So therefore it's wholly sensible to require that when making regulations, ministers must have regard to the international competitiveness of the economy. As honourable members know, the Government inherited the fastest growing economy in the G7. But since then, what's happened? Their actions, their words have stopped growth stone dead. So as well as competitiveness, the Government should take into account economic growth in the medium and long term. That's essential. And my concern, Madam Deputy Speaker, is the Government is treating businesses like the mule in Buckaroo, loading on more and more costs and obligations. But anyone who's played the game will know that it's inevitable there will be a reaction and the mule will buck. And in economic terms, that means fewer jobs, higher prices, lower wages. And the Government's own impact assessment gives a cost to business of £5 billion a year. That simply cannot be absorbed by companies, so new Clause 87 would offer some protection. And many honourable members have spoken about the extension of employment provisions to day one, and I recognise the extension of unfair dismissal is well-intentioned. However, the reality is this increases the risk to employers of taking people on. The Federation of Small Businesses has said the increased risk will inevitably deter small employers from taking on people for fear of facing an employment tribunal simply because a new recruit turns out to be unsuited to the role. That's bad for people, it's bad for jobs, it's bad for investment and it's bad for growth. So new Clause 86 requires the Secretary of State to assess the impacts of extending the provisions in Clause 21, with Parliament having to approve them. This parliamentary lock is about protecting the chance young people, ex-offenders, other vulnerable groups have to join the workforce, as otherwise firms may simply not take a chance on them. And part-time work will particularly be hit by this bill. And of course, these measures are on top of the Government's £25 billion a year jobs tax, which is making 750,000 jobs in the hospitality sector subject to employer national insurance for the very first time, £1 billion cost for that sector. And these are the very type of flexible roles that are well suited, for example, as my right honourable friend mentioned earlier, for people who are on long-term sickness benefits who might be looking to move back into the workplace. And the bill undermines all of that. And the third area I want to focus on is around flexible working and the provisions on guaranteed hours, and in that context, new clause 28 tabled by the government. Here, I think, again, it is worth listening to business leaders who've warned about the unintended consequences. The Chief Executive of Currys, for example, has said guaranteed hours measures will penalise younger workers and millions who benefit from flexible hours, making such jobs less viable and businesses less competitive. You don't need to be a retailer or even an economist or a lawyer to know that stores and leisure and hospitality businesses have seasons. It's particularly the case in my North West Norfolk constituency. So companies have to plan to have the right size of workforce at different times of the year. And these measures damage that by... I will give way.
It appears to be being quite commonly overlooked on the other benches that flexible working will still be available for people through fixed-term contracts. Does he agree that these can be used to manage seasonal fluctuations?
Simply pointing to the words from Currys' Chief Executive, who employs thousands of people across the country. I'm not here to tell them the form of contract to have. I'm not sure it's the job of the Honourable Lady to tell those employers which contracts they should be offering their staff. But it's certainly the case that they'll be removing the flexibility. And the government is doubling down by extending those to agency workers. And the flexible contracts that are valued by the staff, we've heard contributions from this side talking about the benefits of that, will be undermined by this bill. And having a flexible labour market is an important part of securing a growing economy. And under the last government, we managed to achieve that whilst also extending employment rights. But the clear danger from this bill, the warnings from the Federation of Small Business and others, who represent the people actually providing millions of jobs, is that this will make it harder to employ people. It will increase the risks and the costs. And rather than striking the balance that my honourable friend, the Shadow Minister, spoke about, the government's produced measures which, taken together and on top of the Chancellor's tax-raising budgets and nearly doubling the business rates for hospitality, retail and leisure businesses, create a significant cost and regulatory risk. That's why we oppose this bill and the action the government is taking to hike taxes and increase regulation that makes us less competitive.
I call Alistair Stratton.
Speaker, and I draw members' attention to my register of interest and my trade union membership. Now, for far too long, our economy has been stuck in a low-growth, low-wages, low-aspiration situation. For far too long, we've allowed some of the best employers, some of the best businesses in our country to be undercut by more unscrupulous employers who, unable to compete on competitive advantage or on productivity, have only been able to do so through levelling down working conditions. That simply cannot be right. We've heard in committees, we've heard in this House, we've heard right across headlines for many years now some of the heartbreaking examples of some of the worst scandals that this has enabled to perpetrate. But truthfully, there's not a person across our society who's not currently losing out as a result of our failure to tackle this issue. And for all of honourable members' comments on the opposition benches about the pace that we're moving on this issue, maybe we wouldn't have to be moving at such pace had they done more on it. Oh, absolutely.
I just wondered if my honourable friend would agree with Julie Abraham, CEO of Richer Sounds, who says that happy colleagues are likely to be more productive, and that also leads, importantly, to reduced stock loss and higher staff retention, which in turn, and I quote, minimise recruitment and training costs, not to mention disruption to established teams.
My honourable friend Blackman, and I could not have put it better myself. Research is really very clear about the strong link between good working conditions and good productivity and the wider economic benefits that brings, which is why I'm really grateful to everyone who's played their part, from the Minister to members on the Bill Committee, and particularly actually with some sympathy to those who have to endure some of the tropes you've been listening to today, to make sure that we've got such a big and comprehensive package today. Because there are some really strong amendments that we're debating today. Now, I want to focus on one in particular that touches a constituent who came to my surgery recently, which is new clause 32. Now, literature around the harms of zero-hours contracts, the impacts they have not just on productivity, but on poverty, on workers' conditions, on their health and mental health, are really compelling. But without noting the human impact, you're missing half the story. At my constituency surgery about 2 weeks ago, I was joined by a gentleman who'd been working for 4 years on a zero-hours contract at the Royal Mail. For 4 years, he'd not known week to week, month to month, year to year, what hours he'd be working and how much he'd be earning. For 4 years, that meant he'd not been able to plan his day-to-day life, plan his other commitments, plan his training that he was trying to do in further education to build out his skills to better himself. For 4 years, his life had been narrowed by the precarious reality of the exploitative application of zero-hours contracts by those who should know better. Now, for that reason, I'm so glad that this government, in its manifesto and in the bill brought forward to this House some time ago now, brought forward a commitment to take on zero-hours contracts and to give people, where appropriate, that right to request a contract and the right to request fixed hours. But my constituent without this amendment would have been missed out, because while he works at the Royal Mail, he's employed through an agency. And without these protections and the extension to these protections brought forward by this new clause, he would have lost out, like many others right across the country. So I'm very glad that we're being complete in our approach to this and making sure that we do not miss out the very many employees currently working for agencies from this really important protection. Now, there are lots of other important amendments that we've been debating, and I'm sure we'll be debating too. And I was very glad to hear such warm words from the Minister in his opening remarks about the very important amendment brought forward from my honourable friend, the member for Luton North and Bedfordshire neighbour. It's impossible not to hear from her testimony about bereavement, not to speak to parents who've gone bereavement, and recognise the very simple reality that to be bereaved is not to be sick, and that our leave system should recognise that as such. So I'm very glad to hear from the Minister from the front bench today that this government will be looking to make sure we can work with the honourable member and others across this House who I know have campaigned on this issue for a very long time to make sure we can recognise that reality going forwards. Alongside that, there are a number of very other important measures in this bill too. I could, in 3 minutes, do justice to very few of them, so I want to focus on just one, which is Clause 12 and making sure that we remove some of the barriers to new dads taking up paternity leave early on in their employment. Now, it's a well-recognised fact that we have some of the worst paternity leave entitlements across Europe at the moment. And while shared parental leave sounds great as a concept, you don't have to look far to notice that actually its uptake is shockingly low and shockingly skewed to the highest earners. I'm very glad that we're taking a small but important step to recognising that we need to do more to boost access to paternity leave as part of this bill. And as part of the upcoming parental leave debate and the government's review of parental leave that I know will be coming forward later this year, I know there'll be a lot of colleagues right across this House who will be keen to engage with the Minister to understand how we can go further, not just in allowing fathers to have that crucial early time with their parents, with their child, but also breaking down the very gendered nature of parenting that is currently baked in to our statutory provision around parental leave. There are so many important measures in this bill and so many important areas where we know we'll need to go further. But fundamentally, today is a day where I'm absolutely full of pride, Madam Deputy Speaker, to see a government, finally, after far too long of inaction on the opposite benches, taking the issue of workplace security, productivity and the well-being of people in some of the most vulnerable forms of employment right across the country seriously. I'm proud that they're standing up for my constituent and many people like him right across the country. I'll be very proud today to be supporting this bill. Thank you.
I call Alison Griffiths.
Thank you, Madam Deputy Speaker. In the last 30 years, I've worked in businesses of every size in numerous sectors, from consumer goods to cybersecurity, insurance to cloud infrastructure. I may not be a lawyer, but I feel well qualified to comment on this bill. But the government needn't take it from me. If only they'd listened to the businesses I've spoken to. As Vice Chair of the House of Commons Business and Trade Select Committee, my fellow committee members and I have spent many hours listening to evidence on this bill from employers, trade unions and industry groups. And as a select committee, we toured the country at the end of last year, collating evidence and hearing from a wide range of sectors. And in my own coastal constituency of Bognor Regis and Littlehampton, I've spoken to numerous businesses, many of whom are impacted by the vagaries of seasonal trade and inclement British weather. A consistent message emerges, from businesses at least, if not from the trade unions. How can a government that claims that its primary focus is on delivering growth be so tin-eared to the views and needs of the very businesses, entrepreneurs and indeed employees that are fundamental to creating this growth? The government has boasted of delivering this bill telephone directory thick within its first 100 days. This is not sensible governance. Indeed, a telephone directory of amendments is testament to that. But one of the most damaging provisions is the abolition of the 2-year qualifying period for the unfair dismissal under Clause 21, allowing employees to question failing probation or a trial period in their contract. From day one, employees will be able to take their employers to court. Our Conservative Amendment 287 seeks to remove this clause entirely because it disincentivises businesses from hiring, knowing that they cannot let an employee go, even if it's not working out. The government expects entrepreneurs and businesses to take the risks necessary to drive growth. Indeed, that is what they expect and want to do. But this clause adds unnecessary risk and is likely to be to the detriment of job seekers. This clause will further marginalise those who would already be considered risky candidates. Of course, I'll give way to my honourable friend.
I thank the honourable member for giving way. She and I serve on the Business Select Committee. What I would say is that the statistics show us that of young people, the vast majority don't have 2 years service, so have no protection from fire at will, US-style fire at will policies. In hospitality and in catering, industries that she has massive concern for, vast numbers have no protection from fire at will, overnight firing for no reason with no process, and this bill will outlaw that. I know she supports fair process and fair reasons for firing, and I hope that she will support this bill today.
Griffiths.
I thank my honourable friend for her intervention, and you know that I will always support fair process. But the point that I was leading on to make is that this clause will basically mean that it is more difficult for employers to take on prison leavers, care leavers, candidates with a non-traditional CV, career changers, and young people just looking for that first job, that first rung on the ladder. Because it's these people who won't be given a fair chance, as employers will see them as too risky. And I hope she will see the risks inherent in her clause. I will certainly give way.
I'm very grateful for the Honourable Lady for giving way, and she's making a very powerful point. I used to be an employer. I was an entrepreneur for about 15 years. We employed over 1,000 people. Does she agree with me that it's exactly those people who are a bit of a risk because they've got something which isn't quite right in their CV, they're a high-risk hire, those are the people who are not going to get jobs as a result of this legislation?
I thank my honourable friend for a very powerful point. And I think anyone who has ever looked for a job themselves, and I think people in this chamber will probably count themselves among the better qualified in the looking for work population. Anyone who has ever looked for a job will know that most employers of any kind don't want to take a risk. And so if we make it even harder for them to employ people who are at a base point a risk, it will not serve their purposes. So the government's own impact assessments suggest that the direct effects of this bill alone will cost UK businesses an additional £5 billion annually. But this £5 billion estimate most likely understates the true cost, as it only accounts for administrative burdens, whilst ignoring the broad impact on hiring, business costs and strike action. Key factors like reduced hiring due to zero-hour contract limits, increased strike activity and greater liability from employment tribunals claims, as outlined in this bill, are dismissed as too hard to calculate, making the assessment highly questionable. Which is why today I will be supporting the amendment for new clause 86, which will require an impact assessment to be carried out on clause 21. And it's why we proposed new clause 83 and amendment 283 to ensure that the bill's provisions on zero-hour workers would not come into force until a comprehensive review of the impact of this bill on employment tribunals had been assessed and approved by Parliament. Moreover, Clause 18 places a new duty on employers to prevent third-party harassment. Protecting employees is unquestionably important, and no one should doubt the sincerity of members on this side of the chamber to that. I will certainly give way.
I thank the honourable member for giving way. Would she, like me, agree that it's right that 1.3 million low earners who find themselves ill should receive statutory sick pay for the first time? I represent a coastal seat which has got a tourist sector like her, and as a consequence I've got significant low earners. Would she agree with me that we need to be backing them?
I thank my honourable friend for his intervention. What I would say is that I refer to my earlier comments on making sure that we don't disincentivise employers, and secondly, to point to the flexibility that is needed for both employers and employees. So Amendment 288 seeks to exclude hospitality providers and sports venues from these provisions, recognising the impracticality of holding employers accountable for every interaction in these environments. It is simply not practical to think that every publican, landlord and bar owner, small business owners, would be liable for any harassment that happens towards their employees in a pub, bar, nightclub or festival. May I finish the point and then I'll happily give way? Amendment 285 would require an impact assessment to be carried out on Clause 18. And of course, businesses and business owners should embed good working practices and guidelines to combat this abhorrent behaviour. But it's impractical and undesirable for government to legislate nationally for every sector and business. I will give way.
The Honourable Lady appreciates that there is a defence here if an employer has taken all reasonable steps. It's only reasonable steps.
Sorry, I think we've made enough progress. I urge the government to reconsider, withdraw this bill, work with businesses, unions and workers to create a fair and balanced approach, and one that prioritises the political interests.
I call Lee Barron.
Madam Deputy Speaker, I first want to refer members to my declaration of interests, and I've said it before and I'll say it again. Due to the virtue of my last name, I am the only legitimate union baron in this place, and I'm absolutely proud of it. It's an honour to speak again on this bill, and I want to commend this government for bringing it forward. We made a commitment to working people before the election, and we're following that through. I want to start off by welcoming the government's amendments on agency workers. In my constituency of Corby and East Northamptonshire, we have more employment agencies than any other town in Northamptonshire, and now seeing that those who work agency jobs will receive fair treatment in terms of pay, working hours and job security is to be welcomed as we aim to create a better local economy for the people of Corby and East Northants. Yeah, sure.
I thank my honourable friend for giving way to a powerful speech. And me and the member for Corby and East Northamptonshire are neighbours. And as he will know, there's been a lot of growth in Northamptonshire and increased distribution in the area. And therefore, this amendment will make a massive difference to both of our constituents.
It will indeed. And I thank the honourable member for Kettering for making the point so well with me. In terms of sick pay, this has been a huge move as far as the government is concerned in relation to bringing 1.3 million people to get sick pay for the first time, and we need to welcome that. We might need to have a look at some point in the future if there has been a drag downwards in terms of some of the people around the lower earnings limit, but I certainly think that we should welcome it as a step in the right direction. But it's not just about legislation. We've got to change the jobs market and the perception on work that some people have in modern Britain. There are still some who don't recognise the value that working people bring. I had a meeting last week with a parcel delivery company called Avery. They operate in all of our constituencies. They described the employer-employee relationship as master-servant.
I want to turn around and say that that kind of view of working people is absolutely dated. They said that if they changed the status of their workers, then they would want, their words not mine, their pound of flesh. Whilst we've got people who treat working people in such a way and describe them in such a way, then we have to bring in legislation to make sure that they can't treat people like that. Working people aren't servants, and they should be treated with the dignity and the respect that they deserve. It's a fundamentally wrong, crass and outdated way to view employment in modern Britain, and as long as there are still those who think like that, then we need to make sure that we change things for the better, and this bill goes a long way to doing that. But the question I often ask myself is, why is it that those who want economic growth think that the way in which we make economic growth is through insecure work, minimum wage rates, 0 hours contracts, where you don't know from one week to the next how you're going to support and what you'll earn to support your family? Work should be the route out of poverty, not a lifetime trapped in it. And this bill is a step in the right direction to make sure that that's what it becomes once again. I chair the all-party parliamentary group on modernising employment. At the last session we had, we heard from Zelda Perkins from Can't Buy My Silence in relation to non-disclosure agreements. Her testament makes it absolutely clear that we need more done in this space. And if there is room through this bill to do that, then I would urge the government to take those amendments on that were described earlier on. The APPG that I chair looks to the future of work and what good employment looks like. At the end of the month, the APPG is going to look at good work, the New Deal and this bill. We'll look at the full effects that this bill brings to see how we take forward the benefits and transfer them into the modern world of work. In the 21st century, modern employment should look like security of work, well paid with progression opportunities to keep families out of poverty. This bill goes some way to do that. In conclusion, I urge all members to support this bill. It bans exploitative 0 hours contracts, and I will make the point that somehow saying that what we're trying to do is going to stop flexible working is for the birds. That's not the case. We had flexible working long before we had 0 hours contracts. We survived then, we can survive now, and we'll survive into the future. If you live and work, no. If you live and work in Spain, or if you live and work, no, or if you live and work in the Republic of Ireland, or if you live and work in the Republic of Ireland, they're banned. You can't use them. Now, don't tell me them countries haven't got flexibility. They have. We'll survive in the future like we survived in the past without exploiting working people, because you don't grow your economy by exploiting working people, and this bill goes some way to stop that. So it bans exploitative 0 hours contracts. It increases protection from sexual harassment. It introduces equality menopause action plans. It strengthens rights for pregnant workers. It makes flexible working the default. It strengthens bereavement leave. It improves pay and conditions through fair pay agreements. It provides day one protections from unfair dismissal, and it establishes the Fair Work Agency to make sure all employers are playing by the same rules. And it will deliver the jobs for the future, which will benefit working people in Torbay and East Northants, and I'm proud to support it.
Sir Alex Shelbrooke.
Thank you, Madam Deputy Speaker. And let's sort of focus on new clause 83 first in opposition's name. Start with the Honourable Lady for Hamilton and Clyde Valley, who I think I'm just catching before she goes. And she said that a fair day's work deserves a fair day's pay. And indeed, the member for Birmingham, Hodge, and Solihull also said, we all agree that an honest day's work deserves an honest day's pay. And a lot of the speeches there have been focused on the banning of 0 hour contracts and the argument being made that people deserve to make sure that they have know what their contracts are, know what they're going to be paid, know that they're going to be treated properly. And I find it disturbing, therefore, and one of the reasons I think that this bill is rushed and falling down goes back to a question I put to the Secretary of State at the start when we started this process on this bill about why are there not unpaid internships in it. And so when we're looking at the bill, which is focusing so much on 0 hour contracts in this debate today, The reasons behind that I find difficult to equate to why you would leave a whole section of society out of this bill who can work for up to 12 months without any pay. Now, Madam Deputy Speaker, I don't understand how something that has been in Labour manifesto after Labour manifesto, and may I say, Madam Deputy Speaker, that I brought forward in every term I've been in this place a bill to ban unpaid internships. My government didn't want to do it, despite Prime Ministers making promises at the dispatch box when I first raised it. The party opposite, and there are members sat there who stood on those manifestos, always said they would do it. Now here's this great bill which was trailed in the general election, which is being promoted by the party opposite, and yet there's nothing there. So I'm making this appeal now for when this bill goes to the other place next, that this has to be looked at, because this is wrong. All of the debates today about opportunities for people. What opportunity lies to people like myself and my sister as well, who had to work and earn a living to be able to do what we have gone on to do? That we couldn't have spent 12 months working in London unpaid. That this fundamentally undermines what I'm hearing opposite about what this bill is set up to do in creating equality, when there's a whole section of society who still are just not being addressed, that they can't be paid. Now, I do think that's wrong. And therefore, when we talk about New Clause 83, about a review and seeing what happens at employment tribunals, this review needs to be wider, and it needs to understand that if the aim is to create that equality is not being created. So let me move on to something I mentioned to the Minister at the start. I'm grateful for the answer he gave me at that point, which there are, as presented in the bill today, all of the clauses around parental leave, bereavement leave, and may I pay tribute to the Honourable Lady for Luton North for the dedication she's given to this subject, and it's a great testament to her. It is very brave to bring her own experiences in, and I pay tribute to her. That we're not dealing with all aspects of menstrual health, and I really think, again, it's something that will need to be addressed in the other place, because I'm talking specifically, as I mentioned at the start, about endometriosis. It is a crippling disease for people who have it. I was proud to host an event just last Thursday talking about endometriosis, and I don't think people can really recognise just how debilitating this disease can be for people in the workplace, who deserve the same regard as anything around menstrual health, with the menopause strategy, etc. Again, I find it to be a big hole in this bill. I am trying to take what the government wants to do on face value. I think there's many, many flaws in this bill, and they've been outlined by my front bench and by several members on this side. But I'm trying to say where I think there are significant gaps. You know, the Honourable Lady for Sheffield, Heeley and others have been talking about non-disclosure agreements. And I thought in there, something said by the Honourable Lady for Sheffield Heeley showed where some of the flaws in the psychological and emotional abuse clause come. Because she made the example that the person who was suffering at work and had an incident in front of colleagues was made to apologise to their colleagues. Now, I think that should be examined slightly further and dug into, because why would you have to apologise to your colleagues? They must have complained that it was distressing for them. This is where I see some of the unforeseen circumstances of the wording of psychological and emotional abuse. That is not to say that I don't care. I think the member for Torbay and East Northamptonshire said many things that actually I could agree with. Okay. But please don't say that this side of the House doesn't care about abuse in the workplace. So I give way to my honourable friend.
I thank my honourable friend for giving way. Does he think some of the problems in this bill that he's identifying is because it's been rushed through this chamber?
I do. And I'm trying to make that as a serious point, because this is a big bill. It's one of the flagship pieces of policy for the government, and to bring that many amendments to the floor, I heard somebody from a sedentary position say earlier on, well, there's 12 hours. but that doesn't make up for the 21 days that were done in committee to examine the bill piece by piece. I do feel, as other members have said, that it has been rushed for political purposes. And, you know, I would say that the reason we have these debates is to explore these issues, is to try and make legislation a better piece of legislation. And I do think that I'm trying to be constructive in the comments I'm making as to where I see the flaws and highlight the unforeseen consequences, because I do worry when we see the non-platforming of people at universities, when we hear all of the issues we've heard around people saying that they feel emotionally put upon by it, just and having trigger warnings on things. That I think that's just an abuse of. I think that's just an abuse of some of the protections that were tried to put in place. And I think there are people who will try and abuse this particular clause. Now, what I'm saying to the government and the minister is, can the legislation be tightened up around those words?
Richard Bergen.
Thank you, Madam Deputy Speaker. Always a pleasure to follow my close neighbour from the other side of the House, and I really welcome this bill. It needs to be put in the historical perspective. For so much of recent decades, with the exception of the last Labour government, every time we've seen an employment rights bill virtually, or a trade union bill, it's been an attack on trade union rights, an attack on workers' rights, whereas this bill makes a real difference in advancing the rights of working people, because working people in this country have been kicked around for too long. And it's right that we don't accept a situation where we think it's fine for our workers in this country to be some of the easiest to sack in this continent and some of the easiest to mistreat in work in this continent. Workers in our country deserve better employment rights, and this bill sets about putting that into place. I give way to my honourable friend.
Matt Donald. For giving away. You will have heard constantly, in response particularly to the P&O disaster, that there was going to be an employment bill from the other side when they were in government. They've criticised this government to do what they promised, to bring in a bill within 100 days. Would you agree with that?
I certainly would agree with my honourable friend, and they never got round to it. All we had really from the Conservative Party when they're in government about that P&O debacle was kind of crocodile tears or statements of sorrow from the dispatch box. That just doesn't cut it. In terms of this bill, it contains important advances such as establishing bereavement leave, introducing equality menopause action plans, over 1 million people on 0 hours contracts benefiting from the guaranteed hours policy, 9 million people who have been with their employer for less than 2 years benefiting from the right to claim unfair dismissal from day one. And I do want to address it. It seems to escape the understanding of many of the members opposite that this doesn't mean employers can't dismiss people. It means they can't dismiss people unfairly. So what the opposite side are arguing for is the right for employers to dismiss people unfairly, because the only way, as it stands, that you can claim unfair dismissal from day one at the moment, before this legislation comes in, is if it's a discriminatory dismissal. So, to be clear, as it stands, an employer could, 6 months, for example, into someone's contract of employment, say, I'm sacking you because I don't like people who wear green jumpers. I'm sacking you because I find your voice irritating. That's true, because they would be unfair dismissals, and people, as it stands, don't have the right not to be unfairly dismissed until they've accrued 2 years of service. I think the party opposite needs to come clean about that. Before I move on to my own amendment, I want to welcome many of the government amendments, but also welcome amendments put in by backbenchers from this side, including the many important amendments put down by my honourable friend, the member for Middlesbrough and Thornaby East, who's done such a good job in developing employment policy in opposition. The important amendment on sick pay, or more important amendments put down on sick pay by my good friend, the honourable member for Bradford East, and the honourable members for Walthamstow and Luton North who have put down such important amendments. In relation to my amendment, it's Amendment New Clause 6, and what it does, it rights what I consider to be historic wrong. The last Labour government brought in the groundbreaking Equality Act 2010, an act that we can all be proud of. As part of that, there was the statutory discrimination questionnaires. And when I was an employment lawyer before becoming a Member of Parliament, I almost lose track of the amount of times that we used statutory Equality Act questionnaires, statutory discrimination questionnaires, to smoke out discrimination in the workplace, whether it be discrimination in relation to age, disability, sex, race, sexual orientation, pregnancy and maternity, gender reassignment, religion or belief in marriage and civil partnership. But it also, and I bumped into an old colleague on a train who's a trade union lawyer actually, he made the point that statutory questionnaires also, I make no apologies for having a friend that's a trade union lawyer. I think these people need to get out a bit more. But he made the point as well, that actually it would show when there wasn't a claim that was going to have a good chance at succeeding at an employment tribunal, help to manage potential claimants' expectations and thus lead to either a claim that wasn't meritorious, not being pursued, or being settled. But it helped to smoke out discrimination in workplaces, helping not just the particular individual employee, but helping to tackle discrimination against workers more widely in that workplace. And the truth is, in 2025, when we see some of the rhetoric from politicians in this country and around the world, it's as important as ever that we have the mechanisms in place to tackle discrimination in workplaces across the country. So that was part of the last Labour government's pioneering Equality Act 2010. Shamefully, the Conservative-led government in 2014 abolished statutory Equality Act questionnaires as part of their attack on workers' rights. And in their consultation, the response was 83% of respondents said it was wrong to remove this important mechanism for workers to unmask and tackle discrimination. 83% of respondents, yet the party opposite, whilst in government, aided and abetted by some of their erstwhile friends, ploughed ahead in any event. So the reason I've put down New Clause 6 is because I think this is an important opportunity for our new Labour government to right the wrong done by that Conservative-led government and reinstate what was a very important advance in our last Labour government's 2010 Equality Act. And I look forward with interest to hearing the Minister's response to this later. If the Minister won't accept this amendment to this bill, I'd invite the Minister to come forward with a proposal to reintroduce statutory discrimination questionnaires as soon as possible in the future. It made a real difference. It actually helped some claims going to tribunal that shouldn't have gone to tribunal, but also, more importantly, it empowered workers to smoke out discrimination in their workplaces, not only to their benefit, but the benefit of their colleagues in the workplace and to the benefit of wider society. We need it now, we need it in 2025. I look forward to the Minister's response later.
I call Lisa Smart.
Thank you very much, Madam Deputy Speaker. And there are a great many very important employment-related issues being discussed today. But I rise in support of New Clause 16 because, as it stands, self-employed people are not entitled to statutory adoption pay. This creates a substantial economic barrier for prospective adopters, and without this support, the selfless act of adoption is being made harder. New Clause 16 would fix this. A constituent of mine, Kirsty, is a self-employed mother who discovered the significant gap in the financial support system whilst exploring the possibility of adoption. Kirsty and her husband have a son, Charlie, who is a bright-eyed 4-year-old with an unshakable love for trains. And he often talked about how much he wanted a little sibling to be his assistant train driver. After a year of trying to conceive a second child, Kirsty and her family decided that opening their hearts and their home to a child through adoption was the best option. However, one of Kirsty's close friends, also self-employed and in the process of adopting, informed her that she was not entitled to the same financial support through statutory adoption pay, throwing her plans into doubt. Unlike biological parents who qualify for maternity allowance or employed adopters, who are eligible for statutory adoption pay, self-employed adopters like Kirsty fall into a financial support void. And while statutory guidance allows local authorities to make discretionary means-tested payments equivalent to these allowances for the self-employed, such support is not guaranteed, and local authorities have no legal duty to provide it. And in fact, a Freedom of Information request by the charity Home for Good revealed that 34% of local authorities lack any policy for providing this financial support. And even worse, 90% of self-employed adopters, when they were surveyed by the APPG on adoption and permanence back in 2022, reported that their social worker never advised them about these discretionary payments and the possibility of receiving them. Now, adoption provides children with the opportunity to thrive in a permanent, loving home, often completing a family, as I have had the great pleasure of seeing for myself in my role as a proud adopted auntie. And I am confident in my belief that members across the House will agree that self-employed people are no less suited to adopt than anyone else. Despite the increase in the number of children in care, the number of adoptions in the UK has halved since its peak in 2015, and this is completely unsustainable. The enormous and growing pressures that face our foster care system will only worsen if the number of adoptions continues to decrease. As at 2024, in December in 2024, there are 4.39 million self-employed people across the UK. And if we began removing these barriers, these financial barriers, and empowering those who are self-employed through guaranteed financial support for adoption, we could begin to reverse these worrying trends in the number of adoptions. And that would allow willing adopters like Kirsty and her husband to be financially able to do so. The financial case for supporting adopted parents is compelling. Research by the Consortium of Voluntary Adoption Agencies UK shows that in 2021, adoption saved the UK economy £4.2 billion through improvements in children's health, education and employment prospects compared to the outcomes for children that remained in care or other placements. The CVAA has also found that at least £1.3 million worth of value is created when each child is adopted, underscoring the societal and economic benefits of increasing adoption numbers. I have raised this glaring gap in the financial support system several times in recent months. I've raised it with ministers in a very constructive debate in Westminster Hall and with the Leader of the House, who recommended I table an amendment to this bill. The Honourable Member for Hitchin mentioned the upcoming review of parental leave, and I'm sure the Minister will mention in summing up, but I really encourage the Government to support the amendment to grant entitlement to statutory adoption pay to the self-employed, new clause 16. We should be removing any barriers to adoption so that brilliant potential parents can adopt and some of our most vulnerable children can join their forever families.
I call Michael Wheeler.
Thank you, Madam Deputy Speaker. I would like to refer the House to my entry in the Register of Interest and my proud membership of USDOR and the GMB. It was an honour to serve on the Public Bill Committee for this historic piece of legislation. This bill represents a watershed moment, a turning point for working people in our country. Working people who for too long have been left behind in an economy plagued by weak employment rights, stagnant growth and the soaring cost of living. The measures contained within this bill represent a meaningful intervention in our broken labour market, looking to promote good quality jobs that offer dignity, security and respect to working people. As someone with a proud background representing workers, I wholeheartedly support the bill's spirit and provisions, and I believe it will meet Labour's promise to deliver a new deal for working people, a new deal that will make work pay. Whether it's banning exploitative zero-hours contracts, ending the scandal of fire and rehire, or protecting employees from unfair dismissal from day one, this bill will promote good, secure employment and a workforce that finally feels valued. It recognises trade unions as the force for good in the workplace that they are, encouraging positive, productive and harmonious partnerships between companies and unions.
The evidence we heard in Bill Committee made it clear that many of the Bill's measures enjoy broad support from employees and employers, such as modernising family-friendly rights to meet the needs of today's workers and the creation of the Fair Work Agency, which will protect good employers from being cynically undercut by unscrupulous competitors. Madam Deputy Speaker, let me now turn to statutory sick pay and Government Amendment 81. During the pandemic, it became clear that SSP is in desperate need of reform, and I am therefore delighted that this bill removes the 3 waiting days and the lower earnings limit, delivering greater financial security to the working people when they need it most. However, an issue remains. Setting the amount a low-paid worker receives while off sick at 80% of their wages has the unintended consequence of reducing sick pay for those who earn at or slightly above the lower earnings limit. Low-paid, long-term sick workers will be the most effective. I believe that this is an oversight, one that is contrary to the spirit of the legislation, and I would call on the Minister to close this gap. Madam Deputy Speaker, turning now to the right to regular hours contract. The proliferation of one-sided flexibility throughout the workforce has been one of the most damaging labour market developments of the last 14 years. It has left workers vulnerable to sudden changes of income as their hours are changed from week to week. The right to a regular hours contract is therefore one of this bill's most important provisions. However, limiting this right to those on a specified number of hours, such as 16 hours a week, unnecessarily excludes those above the threshold from benefiting from the right, whilst giving employers a perverse incentive to give additional hours when available to those who already have more hours. Madam Deputy Speaker, I raise these points not to be critical, because I believe that what we have in front of us is a magnificent piece of legislation, one that is testament to the power of collaboration and consultation, and I want as many people as possible to benefit from it. Jobs are the cornerstone of our lives, and this bill takes giant strides forward, ensuring that people's jobs are fulfilling, that they are protected whilst at work, and that they take home enough to make ends meet. This bill restores fairness to the balance of power between employers and employees, and it is good for workers, good for productivity and good for growth. It is therefore good for business too. I would suggest to the House that anyone serious about fairness at work and increasing living standards would support this bill. I would like to finish... I'll happily give way.
I thank the honourable member for giving way. He talks about this bill being good for growth, but does he have any concerns at all for the government's own assessment that says it will cost £5 billion to businesses? Can he express any concern at all about the impact on growth, the downward impact on growth that cost will have?
Michael Wheeler.
I think that a bill that promotes good, secure work across the economy is something that we shouldn't shy away from. Absolutely. And I believe, if I am correct, that the figure referenced represents 0.5% of the costs of businesses. So no, I am not concerned. Madam Deputy Speaker, I would like to finish in a slightly odd place. Benjamin Disraeli believed that his government's active role in passing legislation that benefited the working person would, and I quote, gain and retain for the Conservatives the lasting affections of the working classes. Clearly he failed in that endeavour, and One Nation Tories are now a vanishingly scarce presence on the opposite benches. I would ask all the honourable members opposite, with their opposition to this bill, when did the Conservatives give up even trying to be on the side of working people?
I call John Cooper.
Thank you. If growth is the intended destination, as my friends in Dublin would say, you can't get there from here. For this bill, so long on amendments, so short on detail, cannot be reconciled with this government's stated mantra of growth, growth, growth. By their own estimate, the bill will cost business £5 billion, so easily dismissed by the honourable member for Worsley and Eccles. £5 billion is a serious amount of money. So the only growth is in the amount of red tape in which this will snare businesses. It's why I speak in favour of Amendment New Clause 87. This requires the Secretary of State to have regard to the objective of the international competitiveness of the economy and its growth in the medium to long term. The Secretary of State for Business must surely recognise the importance of this. After all, I saw him just days ago in a slick video with cuts quicker than the shower scene in Hitchcock's Psycho, boasting of working abroad together to deliver growth at home. Now, I love a fantasy film as much as anyone, but the Secretary of State is in danger of jumping the shark with this level of sophistry, stretching credulity beyond snapping point. For growth at home is feeble now, and this bill is its enemy. So lacking in detail is this bill, clearly scrambled together to beat the government's own first 100 days deadline, that it is the equivalent of a parliamentary blank cheque. Sign here and we'll fill in all those pesky details later, handing sweeping powers to the Secretary of State. That, Madam Deputy Speaker, is a cage without a key into which we are being asked to walk. I have seen this before with the SNP's woeful prospectus for Scottish independence in 2014. Scots were bright enough to see through the smokescreen then. Will members across the House be sharp enough to discern the dangers here? Delighted to give way.
Does my honourable friend agree with me? It's quite clear that the government hasn't done the work in order to get the bill in the right position and the right place for it actually to have been introduced into this House in the first place, which has been exemplified by the committee stage and how much drafting had to be done at that, and it should have been stopped at PBL, never been allowed to get to this floor.
Well, I agree completely with my honourable friend, and he is a very experienced parliamentarian, and he knows full well that to arrive at this stage with, as we've heard from other members, a telephone directive of amendments is quite an incredible situation. But how could any self-respecting Secretary of State for Business and Trade stand over the anti-growth regulations contained, but not confined to parts 1, 2 and 4 of this bill? Even a trainee solicitor can see that these strip out flexibility for both employees and employers, makes it less likely that people, especially young people, especially people with a sketchy background, will be hired for that all-important first job. Whether your employee writes if you haven't got a job. Madam Deputy Speaker, as someone who bends his elbow, I am familiar with the occasionally coarse atmosphere in pubs. My daughter took a part-time job in a bar while studying at university, but I see nothing useful for her in the bill's bid to make employers liable for third-party harassment. It's why I also support our amendment to exclude the hospitality sector from this onerous clause. Aside from the fact that my daughter was well capable of dealing with the rare, rude, sexist and obstreperous client under existing laws, this clause risks the bill becoming a snooper's charter, a busybody's dream. If our Amendment 289 falls, the public bar will no longer be the cockpit of free speech, but placed in the purview of the censorious and the malicious gauleiters of orthodoxy. Set as we are in a sea of troubles amid global turmoil, are Labour really so afraid of off-colour jokes or the barstool crank with outre political views that they will establish the banter police? Madam Deputy Speaker, one of my criticisms of the Holyrood Parliament in Edinburgh is that it passes never mind the quality, feel the width legislation in a bid for self-justification. With this bill, that accusation could rightly be levelled at this government too.
I call Stella Creasy.
Thank you, Madam Deputy Speaker. I will be proud to see this bill progress through Parliament and to develop accordingly, and that is what the amendments before us offer us the chance to do so. May I pay tribute to my good friend from Luton North and the work that she's done, and also she's not in our place, the member for Sheffield, Heeley and Oxford Abingdon West, for the work that they are doing. In the short time available to me, I want to move formally New Clause 7. New Clause 7 reflects a manifesto commitment made by the Labour Party, which said explicitly that the current parental leave system does not support working families. Millions of people across this country will recognise that that is the case. New Clause 7 is about putting meat on the bones of that commitment, because it is long overdue. We are behind the curve in this country in how we treat dads, and I want to thank everybody who has signed this amendment, because it sends the message that we care about our fathers in this country. Paternity leave in the EU, we have the worst, as the member from Hitchin, who's no longer here, pointed out, in the entire of the European Union. 2 weeks, just enough to realise the meconium is going to stop and that you might eventually get 3 hours sleep in a row at some point. There is a good reason our economic competitors treat our dads better. 16 months in Sweden, rather, 8 months each for each parent and 3 months protected for the dad. France, Spain, Norway, Luxembourg, at least 6 weeks. Japan, a year. Why do they do that? Because dads make a difference. Yes, this bill will give them a day one right to paternity leave, but just 2 weeks. And 1 in 5 dads in this country don't take any leave at all, 35% of them, because they can't afford to do so. They need a paid and protected right in their own right to benefit from paternity leave. It benefits them and it benefits their kids. It's better for the mental health of the father. It means they take fewer sick days. There's all evidence to prove this. And it's also good for the kids. And it's also good for the mums. We need to end the battle of the sexes when it comes to childcare, because research shows that women really cannot win. Even when we don't have kids, because of maternity discrimination, we pay the price. We all know of employers who don't employ women in their 20s and 30s because of the risk that ladies do babies. The challenge with this legislation, which rightfully strengthens maternity discrimination powers, is that it could inadvertently reinforce that message if we don't bring forward legislation to support fathers. Well, I'm glad the members opposite are supporting. I wish they were voting with us tonight on this. The gender pay gap does exist in this country, but it's basically a maternity pay gap because the motherhood penalty is all too real. By the time of a first child, a woman's wages are a third below a man within 20 months. You might say that's to do with working part-time, but that's even when women return to the front. 1 in 9 mums has been dismissed, made redundant or forced out. Women are considered 10% less competent in the workplace when they become mums, as if juggling things makes you less able to do things rather than more. Childless women, 8 times more likely to be promoted. Conversely, dads are considered more committed, 5% more than non-dads, because we expect them to be in work paying for their children rather than helping to look after them. I don't want to deal in caricatures, I want to deal in hold-card cash in the time available to me, because above all, supporting paternity leave in its own right and leave for the other parents in relationships is good for the economy, because it helps boost women's participation and productivity. Countries with better paid parental leave have a smaller gender participation gap in their economy, and all the economic benefits that brings. Closing that gap could bring £23 billion into our economy, 1% of GDP. Yes, I will give way.
Thank the honourable member for giving way. She's talking about the benefits of her amendment to fathers. But does she accept that the effect of this bill is negative and harmful to everyone when it's stripping £5 billion away from businesses and is harmful to the economy? So it's no good that her amendment is helpful for fathers if the net effect of the bill is bad for everyone through the damage done to the economy.
I wish the honourable gentleman had actually been listening. I just pointed out that dealing with the gender pay gap would bring £23 billion to our economy. And that's exactly how we pay for this, because this is a cost-neutral proposal. Newsflash to those who haven't worked it out, mothers are already paying for this childcare in their lower wages, their lower opportunities, their lower progressions. Women's salaries hit by 33% after the birth of that first child. Women are doing 450 million hours of unpaid childcare in this country. It equates to £382 billion worth of work, twice as much as men. A consultation, a review could actually be explicit about looking into these issues and how we share that cost and that benefit fairly so that both men and women can equally contribute to our society, equally look after their children. A consultation and a review could actually be explicit that it is looking at self-employed parents. After all, there's nearly 1 million self-employed dads in this country who pay £1.1 billion in national insurance contributions. They don't get any parental leave at all. And don't tell me that shared parental leave is the answer. We know that it's not. Only 2% of dads have taken it in the 10 years it's been available because it's not paid. That's why we've got to be explicit that any review looks at the pay that needs to go behind parental leave, as well as protecting it. Those on the lowest incomes don't take parental shared leave at all. More parental paid leave has been claimed in London alone than in Wales, Scotland, the North West or the North East combined. And above all, this is about our kids. Because God knows we love them all dearly, but all of us can understand why 20% of divorces take place in the first 5 years after you've had a child. Because of the unequal situation we put families in and the pressures that that creates. The mum and dad guilt. And we have a choice in this place in whether we move this issue forward, whether the government actually makes a proper commitment with a proper timetable and a proper involvement of Parliament and the Women and Equality Select Committee about how we deal with mum and dad guilt. And all those people who will say, well, I struggled, so should you. That is bad for the economy. It's bad for our kids. It means you don't get the time to work out the quirks of your children as a father. So mums end up being the ones who know better how to cut the sandwiches, which means that mums end up being the ones who do more of the childcare and dads get pushed further and further away from their children. If we get this right, if this government is serious about supporting families, and I believe they are, but they need to show us the detail on this, then actually every family, because they come in all shapes and sizes, every parent, whether the father, the non-birthing parent, the mother, will have the time to be the best parent and the best contributor that they will be. That's why these policies are massively popular with Conservative and Reform voters. If only the Reform MPs were here to do something for men for a change. That is why it makes a difference for us to do this now. This change is long overdue. I really hope that ministers are listening to why it matters to show that there is a commitment to this, and I look forward to hearing to what they have to say in response to this clause.
I have to notify the House, in accordance with the Royal Assent Act 1967, that the King has signified his royal assent to the following acts: Supply and Appropriation, Anticipation and Adjustments Act 2025, Crown Estate Act 2025. I call Gregory Stafford.
Thank you very much, Madam Deputy Speaker. It's always a pleasure to follow the King. I rise today on behalf of my constituents in Farnham, Borden, Hazelmere and Liphook, who are opposed to this fundamentally anti-business employment's right bill. I think nothing has highlighted more clearly than today's debate the old adage that where we think the Labour Party are wrong, they think we are evil. And there has been nothing that comes from that side of the chamber which has given any consideration to the absolutely correct concerns that my honourable friend, the Shadow Minister, raised in his opening remarks. This bill, which has been bodged together both at committee stage and again today in this chamber, is simply put together in order to assuage the union paymasters that fund so many of the Labour members on that side. This is a bill that highlights Labour's complete misunderstanding of how to help business, their employees and, of course, the economy overall. A government that talks about growth but legislates to destroy it. This government claims to be pro-growth and pro-business, yet this bill does precisely the opposite. The Institute of Directors has warned that it will lead to slower growth, deter investment and bury business under an avalanche of unnecessary regulation. Even the government's own impact assessment, which has been mentioned on a number of occasions on this side of the House, concedes that business will face a staggering £5 billion in additional costs, an economic straitjacket that will choke innovation and job creation. And what honourable members on the other side seem to have failed to realise, that being pro-business, as we are on this side of the House, is being pro-worker, because if businesses do not exist, there will be no one to employ workers. In my constituency alone, we have over 5,000 businesses, the vast majority of which are small and medium-sized enterprises. Many of these operate in the education, retail and hospitality sectors, sectors that rely on flexibility to survive. Yet this bill's attack on zero-hour contracts threatens to wipe out opportunities for students, for part-time workers and those juggling multiple jobs to make ends meet. I'll be very happy to.
I'm grateful to my honourable friend for giving way. Amongst the 5,000 small businesses in his constituency, has he come across one who has actually said that they're in favour of this bill or lobbied him to vote for it?
Well, my honourable friend from Spelthorne makes a very good point, and I would say this to the Minister. I am very happy for him to come to Farnham and Borden, or Hazelmere or Liphook, or indeed any other of my villages, to meet all of the people who tell me what a damaging effect this will have on their small business. Because, as my honourable friend from Spelthorne points out, the simple fact is this government has not consulted with small business properly, because if they had, this bill would be scrapped. I think of the University for Creative Arts students who rely on the flexible work, the NHS paramedic in Farnham picking up those extra shifts at the Nelson pub that I mentioned earlier. These are real people whose livelihoods are at risk because of this bill. And that's why I support new Clause 83 and Amendment 283 on zero-hours contracts and employment tribunals. UK Hospitality has been clear that for 90% of their workers on zero-hour contracts, this is their preference. The sector relies on these contracts to manage the fluctuating demand, and removing this flexibility could devastate those businesses and lead to job losses. There is no job security if you don't have a job. The House of Commons library briefing actually supports this, and it confirms that zero-hour contracts provide essential flexibility for both employers, but most importantly, employees. And that's why I support new Clause 83 and Amendment 283, which demand an impact review on employment tribunals concerning zero-hour workers before the government recklessly legislates against them. The Chartered Institute of Personnel and Development has already made it clear banning zero-hour contracts will hurt the very workers that this government pretends to protect. But yet again, ministers plough ahead, blind to the economic damage that they're about to unleash. Madam Deputy Speaker, moving on to Amendment 286 and new Clause 86, unfair dismissal and business confidence. The government's proposal to grant employees the right to claim unfair dismissal from day one is another reckless intervention, and one which is raised with me by small businesses day in and day out. Amendment 286 and new Clause 86 seek to introduce an impact assessment before Clause 21 and Schedule 2 comes into force. Without this, we have to be clear, businesses will be discouraged from hiring in the first place. Flexibility in employment is not one-sided. It benefits both workers and their employers. Similarly, the right to request flexible working must be assessed properly. New Clause 84 and Amendment 284 rightly demand that the Secretary of State assesses the impact of Clause 7 before it comes into force. Rushed policy making will not help workers or businesses. It will create uncertainty and drive investment away. And that is why I think it is essential that we accept new Clause 87 in the name of the Shadow Secretary of State, because we have to do an impact assessment on how this is going to affect businesses. Madam Deputy Speaker, I feel the clock may not have started on me again, so I will draw. In which case, I shall carry on then, Madam Deputy Speaker. I'm conscious of my honourable friends wishing to speak as well. In conclusion, this government seems to have learnt nothing from history, and we've heard history lessons, most of which seem to take us back to the 1970s on the opposite benches. But economic success does not come from shackling businesses with red tape or giving trade unions unchecked power. It comes from fostering an environment where employers can hire, invest and grow.
I call Steve Witherden.
Thank you, Madam Deputy Speaker. I'm proud to declare my membership of Unite the Union and the NASUWT and refer members to my entry in the register of members' financial interests. Before I was elected, I was a teacher for 20 years. Today, as we welcome this transformative legislation, I am thinking of my former students. Their lives will be significantly improved by better wages, stronger workers' rights and a fairer economy. I welcome this bill, which will drastically limit the exploitative use of fire and rehire. Just outside my constituency, but affecting many of my constituents directly, over 500 Oscar Mayer workers are striking against the company's appalling use of this practice. By creating a new right to claim automatic unfair dismissal if you are re-employed on varied terms to carry out the same duties, this bill takes a vital step towards dignifying employees with security and autonomy. I will.
I thank my honourable friend for giving way. He's giving his trademark passionate speech. I wonder if he would agree with me, as a former teacher myself, that actually by removing the hire and rehire, it actually will give the young people that he used to teach the confidence that when they go into the workplace, they will be looking at careers and not just jobs.
Steve Witherden.
Can I thank my honourable friend for his intervention, and I wholeheartedly agree with everything he has said just then. Thank you. I'm also pleased to see the Government's amendment encouraging greater employer compliance and increasing compensation for workers subjected to fire and rehire by raising the maximum period of the protective award from 90 to 180 days. My tabled amendment, 329, seeks to protect against this harmful practice further, ensuring that any clause in an employment contract allowing an employer to change the terms without the employee's consent would be unenforceable, especially in cases of unfair dismissal related to refusal to accept changes. This would further help redistribute the power imbalance between employers and employees, which currently allows low wages and poor working conditions to become commonplace. The bill also takes crucial steps towards banning exploitative zero-hours contracts, ensuring that all workers have predictable hours, offering security for their day-to-day lives. I am pleased to see amendments extending these protections to agency workers. All of us have felt the effects of a system that has left so many behind. Flatlined wages, insecure work and falling living standards. So it is not just my former pupils, but millions across the country who will benefit from the biggest upgrade to rights at work in a generation. I am proud to support our Labour government in this historic step towards better quality employment across the country, and I look forward to the full delivery of the plan to make work pay. Diolch yn fawr.
I call Alison Bennett. Thank you, Madam Deputy Speaker. I rise to speak in support of NC10, which would make carers' leave a paid right. We have an opportunity to give carers in employment a fair deal right across the country, while also bolstering our economy. The Government has an opportunity to build on the Carers' Leave Act of 2023, introduced by my honourable friend, the Member for North East Fife, and take the next step in providing working carers with the flexibility they need to juggle work and care. Carers UK estimates that the value to the economy of carers being able to work is £5.3 billion. And when I've met major blue-chip employers like Centrica and HSBC and their employees who have benefited from those corporations' carers' policies, they are clear that having those policies in place that supports caring is not only good for the employee, but makes them better employees for the employer. And the employers really benefit from having those members of staff who absolutely support them and are able to do their best for their families. Backing our Liberal Democrat amendment to make carers' leave a paid entitlement would therefore not only be the right thing to do on a human level, it would also support the Government's growth agenda. Madam Deputy Speaker, for a government on a mission to spend less while also delivering growth and better living standards, this is a no-brainer. We must be doing everything we can to help those carers that can and want to work to do so. Currently, the Government has simply indicated it will review the implementation of carers' leave and consider whether there is a need to change the current approach. I urge the Government, in the strongest possible terms, that change is needed and the time is now. Those 2.8 million people who juggle a job and caring responsibilities are going above and beyond to care for those they love, while also contributing to our economy. And for many of those carers, they are on low incomes, they're often women, and they can't afford to use their right to carers' leave unless it becomes a paid right. We must acknowledge their work with a fair deal for them. I know that this is something those carers I've met in my constituency of Mid-Sussex deserve, and they deserve better. We must be adaptable to the changing needs of our population, whilst also seeing the benefits. This really can be a win-win, Madam Deputy Speaker. My Liberal Democrat colleagues and I are also pushing for an amendment to make caring a protected characteristic. When applying for jobs, equality monitoring forms do not ask whether someone has unpaid caring responsibilities. There is also no direct requirement for simple, reasonable adjustments for carers in the workplace. I feel this would make all the difference, again encouraging those who might otherwise leave employment to stay, making our economy more resilient. and protecting their own family's finances, because we know that being a carer makes you much more likely to fall into poverty. Carers UK's research also tells us that almost half of all those who left employment early to fulfil a caring responsibilities say they would have stayed in employment longer had carers' leave on a paid basis existed. It seems clear to me that paid carers' leave helps carers, it helps those they care for, and it is good for our economy. I hope the government can see it with the same clarity and do the right thing in supporting these vital Liberal Democrat amendments. Thank you.
I call Sarah Russell.
Thank you, Madam Deputy Speaker. I need to highlight to the House that I am a member of Community and Outdoor Trade Unions and refer you to my register of interests. I'd like to speak to various bits of this legislation today. There's so much in it, and I know that so many of us on the government benches, backbenchers, are really, really pleased with what we're bringing forwards. But the first part of the legislation that I want to address is Section 22, which is where we are going to bring forward in future legislation more protections for women who are pregnant, on maternity leave and in the period immediately following their maternity leave. And I spent the last 13 years representing large numbers of women who were either being made redundant when they were pregnant or on maternity leave or trying to come back from maternity leave, or who suddenly their employer just woke up one morning and decided that they were underperforming, often within 24 hours of them announcing their pregnancies. I literally had a client who had been brought into the company, headhunted, totally stellar, doing incredibly well, got promoted, and as I say, he literally announced her pregnancy and within a week she's on a performance plan. And HR explained to her that because they were, kind and didn't want to do that to her while she was pregnant, that they would very generously offer her a settlement agreement, so she didn't have to go through it. Lots and lots of perfectly decent people don't really understand why it is that they're losing their jobs, and it's because they're pregnant. Pregnant then screwed are finding that 12.3% of women who have a baby have been either sacked, constructively dismissed or made redundant whilst pregnant, on maternity leave or within a year of their maternity leave ending. It's a really, really widespread problem. So it's fantastic that we've got Section 22, which will bring in the potential for the Minister to bring forwards steps to expand the protections available. And what I'd really like to know is how quickly we can do it, because I know that there are pregnant women out there who need that protection literally today.
I will. I thank the Honourable Member for giving way, and on this point, she's giving a very eloquent speech and has great expertise in this area. On the reported cases of dismissal of pregnant women or new mothers, does the Honourable Lady agree with me that it's dramatically underreported because of the use of NDAs in a lot of companies whilst they're taking action against pregnant women or recent mothers?
I mean, I could talk about NDAs at some length, and I don't have time to today. They are definitely problematic, and they are definitely concealing the extent of the problems that women suffer when they announce their pregnancies. The second element that I really like within this legislation is about us improving the right to request flexible working. Those on the benches opposite have questioned why we would do this. I think the answer is that part-timer is still a term of abuse in this country. And whilst that's still something that people say fairly regularly within workplaces and popular parlance, we still have a problem. And so this legislation should help to improve that. They have also talked quite a lot about Section 17 and the third-party harassment elements here. And I just think it's worth getting into some of the detail. So there is a defence to failure to protect your staff from third-party harassment if you've taken all reasonable steps to prevent that harassment occurring. Employment tribunals have been interpreting the meaning of the word reasonable for a very, very long time. And in a discrimination claim, there is a three-part judiciary, essentially. There's a judge with legal experience, there's someone with some employer experience, and someone with some employee experience, sometimes from a trade union, but sometimes elsewhere. So when they talk about all reasonable steps, it is only reasonable steps. It's not every single step in the entire history of the universe that anyone could ever dream up or imagine. A lot... Please do.
Giving way, because she is speaking very powerfully on this. Does she agree that this amendment is used by the Conservative Party to condone something that is offensive, despicable, and they're trying to defend the indefensible.
I completely and utterly agree with her. And I think that actually a lot of what is coming from the other side is scaremongering. A lot of the discussion behaves as if employees with unfair dismissal rights were kind of unexploded bombs. All the people I represented did not want to bring tribunal claims. They just wanted to have been treated fairly and reasonably in the first place. They were typically extremely distressed by their experiences. Quite a lot of them, their mental health had deteriorated really substantially in the course of what they'd gone through. So I don't think that when people have unfair dismissal rights a little bit sooner, that they'll all just be rushing to employment tribunals the moment something goes slightly wrong in their workplace. I think what most people want to do every morning is get up, go to work, do a decent job, get paid for it and go home. And I think that's what we will continue to see after this legislation passes, is most employers want to look after their employees perfectly reasonably. And most employees want to do a perfectly decent job. And that's what will continue to happen. I will give way.
Member for giving way. I've been rather unsuccessful this afternoon finding someone on the government benches who has concerns about the £5 billion cost to businesses this bill will bring. Can she express concern over the £5 billion cost and downward pressure on growth that this bill brings, according to the government's own assessment?
My primary concern is that those on the benches opposite are talking about employees as if they are, as I said, unexploded bombs, and they're talking about employers as if they are unlikely to ever recruit anyone ever again. And I just don't believe that to be true. I think most employers will do a really sensible assessment of whether or not having that additional member of staff is going to bring benefit to their business, and then they'll recruit them. Thank you. So I think it's really important, though, that what we do make sure we do is that we cut through some of what is disinformation and scaremongering, that we make sure that when we bring this legislation forward, that ACAS has a good set of information ready to go, as they actually have really great information online already. I'd encourage employers who are worried to look up on YouTube ACAS information videos, look at their fact sheets, and that we make sure that it is really clear to people that they've got access to sources of free advice, which is important for small business, for them to be able to see clearly what is and isn't required of them. Because I think that the position being stated here is bluntly exaggerated and quite damaging in so doing.
I can't lick Timothy.
Thank you, Madam Deputy Speaker. I'd like to speak in favour of new clause 105. The labour abuse it seeks to address is the wrongful use of substitution clauses by gig economy workers. And to guarantee fairness and justice in the labour market, it's crucial that there's transparency which can be delivered through the introduction of a comprehensive register of all dependent contractors. This will help ensure employment rights are upheld and pay is not suppressed through illegitimate competition, but it will also support the enforcement of right-to-work checks. Unlawful employment of migrants with no right to work here is not good for taxpayers, British workers or migrants who follow the rules. And yet substitution clauses allow what have become known as Deliveroo visas, industrial-scale abuse of our immigration and labour laws. Before addressing the substance of my amendment, I'd also like to commend new clause 30, proposed by my honourable friend, the member for Bridgwater, and which I have myself signed in support. This change to the bill would give employees who are special constables the right to take time off to carry out their police duties. This is a right that other volunteers in public service receive, such as magistrates and councillors. Turning to my amendment, ministers have said that they will consult on employment status and moving towards a two-part legal framework that identifies people who are genuinely self-employed. I support this ambition, and I'm grateful to the Minister for his warm words during the committee, but my amendment provides a way to resolve a particular abuse and hold big employers in the gig economy to account. There are 4.7 million gig economy workers in the UK, including 120,000 official riders at Uber Eats and Deliveroo, two of the largest delivery companies in our country. For years, we've heard stories of the rampant labour market and visa abuse and fraud committed by contractors related to these companies. From late 2018 to early 2019, there were 14,000 fraudulent Uber journeys, according to Transport for London. In addition to Uber and Deliveroo, Amazon and Just Eat have been linked to labour market abuses. and much of this abuse has been through the legal loophole created by substitution clauses. Amazon tells its couriers that it's their responsibility, and I quote, to pay your substitute at any rate you agree with them, and you must ensure that any substitute has the right to work in the UK. It is a dereliction of duty to pass the responsibility of compliance with criminal and right-to-work checks onto these workers. But these companies clearly have an interest in maintaining a status quo where undocumented migrants are taking the lowest fees in the delivery apps. Data from the Rodeo app shows the effect of this abuse on riders' order fees. Just Eat riders saw their fees drop by 14.4% from £6.53 in 2021 to £5.59 in 2023. There was a 3.4% drop for Uber Eats order fees during the same period, falling from £4.36 to £4.21. And Deliveroo has blocked its order fee data from being published. These figures are not adjusted for inflation, and it's clear to see how paying conditions have worsened for riders. By undercutting domestic workers, British workers, and exploiting those with no legal right to be here, companies are privatising profits and socialising the costs. Promises from these companies to introduce tougher security checks have not made the problem go away. We should all be appalled by this state of affairs, because nobody should be above the law. During random checks 2 years ago, the Home Office found 2 in 5 delivery riders who were stopped were working illegally. That same month, 60 riders at Uber Eats, Deliveroo and Just Eat were arrested in London for immigration offences, including working illegally and holding false documentation. Last month, Deliveroo sacked over 100 riders who shared their accounts with illegal migrants. But this is only the tip of the iceberg, and insurance companies report unauthorised riders involved in motor and personal injury cases. This is happening because undocumented migrants are renting rider accounts for between £70 and £100 a week. Profiles have been bought for as much as £5,000. The iPaper found over 100,000 people on Facebook groups where identities have been traded for years, including one group which gained around 28,000 members in less than 18 months. Illegal migrants using social media apps to rent accounts and share information are using social media apps to rent accounts and share information on a significant scale. Today we only have figures from press investigations, but you can find copious examples across the internet with ease. Legal workers have reported problems to the police and the Home Office, but this has fuelled tensions as they compete for orders and even led to violent clashes between legal and illegal riders in Brighton and London, including physical beatings and damage to bikes. People working illegally for these big companies are working longer hours, round the clock for lower fees, and never knowing when their last payday might be. They use group chats to share information and evade Home Office immigration raids. We don't even know how many substitute riders there are at any given time for these companies. A spokesman for the app drivers and couriers union says, and this is a quote, "This loophole allows some bad people to come through. They are not vetted, so they could do anything."
Well, my honourable friend to give way.
I certainly will.
I thank my honourable friend for giving way, and obviously my honourable friend hopes the government will be able to step in to support this amendment. What do you think would be stopping the government from taking the action to support this very sensible amendment straight away?
Well, I don't see why the government shouldn't support this amendment at all. In fact, it seems to be quite an obvious example of labour market abuse, but the difference with lots of the provisions in this bill is that it doesn't directly benefit trade unions who pay for the labour market. Absolutely. And I was quoting the app drivers and couriers union and what they said, and sadly we know that there have been many sexual assaults and attacks committed by substitution workers. What this amendment proposes is the robust regulation of substitution clauses. Amazon, Uber, Deliveroo and the rest would have to do their due diligence and, just like everyone else, ensure all their riders are who they say they are and have the right to work in this country. Introducing such a change would reduce labour abuse, protect our communities and deliver a fairer labour market.
I call John MacDonald.
Thanks, Madam Deputy Speaker. I refer to my register of interests and also, I suppose, just to inflame matters more. I'm the chair of the R&T Parliamentary Group as well. Next Monday is the 3rd anniversary of the P&O scandal. Some members may recall what happened. 800 R&T members largely turned up for work and they were sacked by video, and many of them were marshalled off their vessels by trained bouncers, guards who dealt with them roughly. After that, there was a reaction right the way across the House, if I recall, and across society, that this was repellent and shouldn't happen in a civilised society. And the Labour Party then gave the commitment that it would introduce legislation that would install in law the Seafarers' Charter. And that's exactly what this bill is doing, so I welcome it wholeheartedly and congratulate the Minister for doing it. But as you can guess, we see this as just the first step, because there's so much more to do, particularly within this sector, where there's still exploitation going on, and where, in compared with shore-based workers, many of them are exploited still. Within the legislation itself, new clause 34 introduces, it's a government amendment, it extends the protective award from 90 days to 180 days. We were looking for an uncapped award, to be frank, because what P&O did is they built into the pricing the fines that they were going to take as a result of their unlawful behaviour. So it didn't matter to them. They simply priced it in. In addition to that, we were looking for injunctive relief. And I thank the government for now entering into discussions about injunctive relief. If you recall, many employers can get injunctive relief on the tiniest error by a union in balloting procedures, but workers can't. And what we're asking for is the level playing field. And we were hoping the amendment would be brought forward to the bill today, but it isn't. We're hoping the government will enter into those discussions and go further. But certainly.
I wonder if my honourable friend recalls the evidence of Peter Hepplethwaite, the Chief Executive of P&O, to the Business and Trade Select Committee, where he openly flouted and made it clear that he deliberately broke the law and had no regard for it. Was he as horrified as I was to see that in this House and disappointed at the lack of response from the party opposite?
I think even across the House, actually, it took a long while to recover from the anger at the behaviour that he had in front of the Select Committee in that way. He was acting with impunity because he'd been able to price these sorts of fines in. And it was a cross-party view that we were angry about that behaviour. And that's why the Charter is so important to us. And that's why injunctive relief open to unions, trade unions, would give us an adequate starting point of getting some form of justice. There are a whole range of other issues that need to be addressed. And amendment, in terms of Section 47 of Schedule 4, the government is introducing the ability to monitor the behaviour of companies. Harbour Masters monitoring some of that as well, with declarations that they're abiding by basic health and safety practices, because some of the practices in the past are terrifying, to be frank. But what we want to do is say, actually, health and safety is more about than just some basic health and safety legislation. It's also about rosters, how long people are working. And we still have some of our ferries contracts where people are working for 17 weeks without break at the moment. So we want to ensure the regulations cover rosters. In addition to that, we want to see it covering holiday pay, sick pay, pensions, and ratings training as well, so that we can start getting some form of accountability within this sector. And I say it's not much to ask for. You know, we give the shipping owners, we've given them £3 billion worth of tonnage tax exemptions. And actually, we gave it in return for the employment of British seafarers. I don't think we've got a single job as a result of that £3 billion. So there's a need now to have proper regulation within this sector. Can I say one of the amendments I put forward is just for the government to stand back once a year and bring a report to this House on how the work is going on in terms of the implementation of this legislation, but also updating about what's happening with regard to the implications of maritime law and the International Labour Organization conventions and the impact on this sector in particular. A lot of the debate around this has been around the ferries. We want to ensure it applies to all vessels, not just the ferries. So one of the things that was brought forward by the Labour front bench at the time at the seafair, when we were dealing with the seafarers' wages legislation, was that if a ship came into a harbour 52 times a year, this legislation would apply. Now, unfortunately, I don't know why, that's been extended to 120 times a year. That means thousands of these workers will lose out as a result. It won't be applied to them. So I'm asking the government to let's have another conversation about that and see whether or not we can revert to what was the original position of the Labour Party those years ago when these scandals happened. There isn't much time, but just very, very briefly, I'm interested in the extension of sectoral collective bargaining right the way across the economy, starting with doing it with social care. But I have to say that what I've seen from the proposals in the legislation, it doesn't look like sectoral collective bargaining to me. It looks like simply an extension of pay review bodies. In fact, in the legislation itself, it's saying any agreements within those organisations cannot legally be accepted as collective bargaining. And what I'm worried about is I'll just give the example. In the legislation, it's not clear about who appoints and how the members of the negotiating body are appointed. What we were expecting would be 50% employers, 50% trade unions. I put an amendment up to try and secure that. And it's the same. We think that the negotiating body should elect its own chair, not be appointed by the Secretary of State. We want these to be independent and successful, because I see this as the first step in rolling out sectoral collective bargaining in so many other sectors of our economy, because it's desperately needed because of the lack of trade union rights and low pay that there is. This is a good first step, but there's a long agenda to go through. So I look forward not just to this legislation coming through, I look forward to the Honourable Gentleman bringing Employment Rights Bill number 2 in the next 18 months.
Thank you, Madam Deputy Speaker. I rise to speak in support of new clause 74 in the name of the Right Honourable Member of Sheffield, Heeley. I pay tribute to her and, of course, to my friend, the Honourable Member for Oxford West and Abingdon, who have championed these issues for a long time. New clause 74 looks to ban non-disclosure agreements that prevent workers from making a disclosure about harassment, including sexual harassment. And we have talked about sexual harassment in the workplace for the last 5 hours, I think, or 4 hours. NDAs were initially designed to protect trade secrets by restricting the sharing of certain information. But in recent times, they have taken on an entirely different and quite sinister role. NDAs have essentially become the default solution for organisations and individuals to settle cases of misconduct, discrimination and harassment, keeping the extent of such incidents unaccounted for. Incorporating clear provisions to ensure transparency in cases of harassment would strengthen protections for all workers. Data from the Can't Buy My Silence campaign has revealed that some deeply worrying statistics about the misuses of NDAs. In a survey of over 1,000 people who experienced harassment and discrimination in the workplace, 25% reported being forced to sign an NDA, while an additional 11% stated they cannot say due to legal reasons, implying they also signed an NDA. 4 times as many women as men sign NDAs, and NDAs are used disproportionately against women of colour. During committee stage, the Minister said that the government had reservations about changing the law in this way, as there may be unintended consequences. I struggle to understand why the government is committed to banning universities from using NDAs in cases of sexual misconduct, harassment and bullying, but has not committed to extending these protections to other sectors. Clearly, NDAs are being used in a totally different way to what they were designed to achieve. We must stop this before more victims are silent, and I've heard the Minister saying earlier that at least he's looking at what this new clause is trying to achieve. Madam Deputy Speaker, despite my concerns around the misuse of NDAs, this bill as a whole has many very positive provisions, and particularly importantly, it finally legislates for protecting workers from third-party harassment. This is something I brought forward in my original Workers' Protection Act, which recently became law. However, amendments to my bill in committee in the House of Lords, but also by the Conservative Party, were blocked, so that such liability was not created, that protection from sexual harassment in the workplace by third parties, and we have already discussed it several times this afternoon. I'm most pleased that the government has now committed to making workplaces safer through this protection, because that is what it's all about. Creating safer workplaces is good for everyone. including businesses, despite what the party next to me are saying about this. A study by Culture Shift found that 66% of businesses believe preventing sexual harassment is very important. 66% of businesses. I don't know what members here are talking about their inboxes being full. I have not seen a single email of a business writing to me that they're worrying about protecting their own employees from third-party harassment. But according to WorkNest, 3/4 of employers are still concerned about protecting employees from harassment by third parties. They are concerned. Businesses are concerned that they cannot protect their workers from third-party harassment. Clearly, businesses want these protections included in the bill. Too many people still suffer from third-party harassment at work. Amendment 288, trying to remove these important provisions, is plain wrong. Employers have a duty to ensure the safety of their employees, not just from other employees, but from other third parties who may interact with them in the workplace. This responsibility should be part of their broader commitment to workplace safety. And if the Conservative Party was truly committed to a world without harassment and sexual harassment in the workplace, why are they still condoning offensive language and behaviour as banter and free speech, rather than taking a step to supporting businesses and protecting workers from sexual harassment in the workplace, as proposed in the law? Again, I'm grateful that the government has now completed my Workers' Protection Act as it was intended a year or two ago. Although I remain concerned about the misuse of DNA, and I welcome many provisions in this bill, I'm proud to walk through the no lobbies when we are coming to vote on Amendment 288, and I hope that all right-minded people will join me in the no lobby. Thank you.
Jessica Satter.
I refer the House to my entry in the Register of Members' Financial Interests, and I'm a proud member of the trade unions USDOR, Unison and GMB. And I'm also proud to have worked at a domestic abuse charity for 6 years. That is why I rise today to speak in support of new Clause 22, tabled in my name and with the support of colleagues across the House. I'm an officer of the Domestic Violence and Abuse All-Party Parliamentary Group, the secretariat of which is ably provided by Women's Aid. And I've brought this amendment forward following evidence presented to the group and with the drafting support of the law firm Hogan Lovells. This new clause would require employers with 5 or more employees to publish a domestic abuse policy outlining the support they provide to workers who are victims of domestic abuse. 2.3 million people, predominantly women, experience domestic abuse each year. This is not a niche issue. It is one that pervades every level of society, often with devastating effects. We know, for example, that around 100,000 people in the UK are at high and imminent risk of being murdered or seriously harmed by an abuser. Some members may wonder how domestic abuse relates to employers and question whether this new clause is necessary. To them, I say domestic abuse is a workplace issue. Up to 75% of women who experience domestic abuse are targeted at work. We know that perpetrators often harass women at their workplace with phone calls or by arriving unannounced. Abusers can also be colleagues. Research by the TUC found that 16% of victims surveyed said that their perpetrator worked in the same place that they did. Jane Clough, for example, a 26-year-old nurse, was stabbed 71 times in 2010 by her former partner. An ex-ambulance technician outside the hospital where they had worked and met. Victim survivors need and deserve more support from their workplaces, and this is an issue a number of trade unions and the TUC have campaigned for, alongside domestic abuse charities, the Domestic Abuse Commissioner and survivors themselves. One survivor told domestic abuse charity Safe Lives, "Everyone at work knew. They must have done. I wished someone had said something, asked me how I was. I think if my manager had known what to do or say, she would have liked to help. But the conversation just seemed too hard, perhaps." It is important to note that the previous government introduced guidance on this issue alongside the Domestic Abuse Act 2021, But without a mandatory duty on employers, it remains a lottery as to what support victims can expect. The Employers' Initiative on Domestic Abuse estimates that only 5% of employers have a policy. Domestic abuse, of course, also has a financial impact both on victims and the organisations that they work for. Over 1 in 5 women take time off work because of abuse. And 86% of victims say that abuse negatively impacts their work performance due to them being distracted, tired or unwell. Abuse stunts career progression, and research undertaken by Vodafone and KPMG has found that the potential loss of earnings for each victim is £5,800 a year. This clearly has severe knock-on impacts for businesses and the economy. In 2019, the Home Office estimated that domestic abuse cost the UK economy around £14 billion a year in lost economic output. A mandatory domestic abuse policy is therefore pro-worker, pro-business and pro-growth. Indeed, a study in New Zealand found that introducing domestic abuse protections in the workplace there has cut the costs to businesses and led to increased levels of productivity. Embedding domestic abuse in the ethos and practices of companies here in the UK is a vital step that I'm happy to say some organisations have already taken, led by the pioneering Employers' Initiative on Domestic Abuse, which supports over 1,800 businesses, large and small, that collectively comprise over a quarter of the UK workforce. I'm glad that companies like Sainsbury's, Argos and Poundland already offer employees paid leave to enable victim survivors to attend medical or legal appointments or to seek safe accommodation. But we need all workplaces and all victims covered. Victim survivors deserve far more support than they currently receive, and workplaces are often the only safe place for victims to seek support and safety. But a culture of shame or stigma, fear of not being believed, or even a concern about losing their job due to disclosure is failing victims and should be seen as a key duty which would secure their health and safety. I'm grateful to the Minister for his remarks acknowledging the Government's commitment to victims of abuse in the forthcoming VOG strategy. But we would like to see something more, at least a task force of domestic abuse charities, employers and trade unions, with input crucially from survivors and the Domestic Abuse Commissioner. That would complement the VOG strategy, and we need a much clearer commitment from the Department to move this important issue forward. I look forward to working further with ministers across departments, the Honourable Member for Gloucester on his 10-minute rule bill to introduce paid domestic abuse leave. Victims of domestic abuse cannot wait. Thank you.
I call Afra Brandreth.
Thank you, Madam Deputy Speaker. I'd like to draw attention to my register of interests. As honourable and right honourable friends on these benches have already said, the flaws in this bill are numerous. The impact will be to damage businesses and ultimately employment opportunities. And so I'm deeply concerned about the consequences for our economy both nationally and in my constituency of Chester South and Eddisbury. This government has said that it wants to grow the economy, but this bill penalises and stifles those that do just that. Businesses of all sizes, investors and entrepreneurs. These are the people who grow our economy. And only if we grow our economy can we invest in our much-needed public services. Only then can we give the significant increases in investment for defence that are needed more than ever at this time. We ought to be empowering businesses to deliver growth, yet this bill adds burdens on business to such an extent that by the government's own admission, it will cost the economy up to £5 billion annually. Probably much more than this, because I believe that's a fairly conservative estimate. Survey after survey has shown that business confidence is through the floor. And of course, I don't need a survey to tell me that, because my inbox already has a steady stream of local businesses reaching out to share with me the detrimental impacts of the budget and their concern about the impact from measures that will be brought forward from this bill. Every week, I'm visiting and meeting with business owners across Chester South and Eddisbury, and the message is consistent and clear. How can the government expect to grow the economy when it penalises the growth creators? I want to speak to Amendment 288 as tabled by the opposition that I think offers a reasonable and pragmatic compromise to mitigate against the unintended consequences from placing a duty on employers to prevent third-party harassment in the hospitality sector. And I have listened to the debate so far on this closely, so let me say strongly that harassment of any sort is absolutely wrong, and I do not for one moment condone or excuse harassment in any way in the hospitality sector or indeed in any area. The reality, however, Madam Deputy Speaker, is that in a pub, in a restaurant, in a social setting, a hospitality setting, things may be said that are not always acceptable. And as has been made clear, this is not condoning sexual harassment. This is setting out that we simply cannot legislate for people's words or language in every context. We must have free speech. Surely it is reasonable to protect our landlords and restaurant owners in the hospitality sector and make provisions within this bill, if it has to pass at all, and exempt them from this. It cannot be fair that we expect landlords to be responsible for every conversation that takes place in their premises. It is also important for me to make clear from the many landlords and restaurant owners across Chester South and Eddisbury that I've met since becoming the MP, whether it be Woody, who runs the Swan in Tarpley and the Lion in Malpas, or Jarina at the Resoy and the Bull's Head, that employee welfare is a top priority for them. I know that they do everything they can to treat staff exceptionally well and to protect them from third-party harassment. They want their staff to be safe and secure, but by making such businesses liable for other people's behaviour and language is a step too far and will detrimentally impact our hospitality sector. So as I conclude, Madam Deputy Speaker, let me reiterate my deep and fundamental concerns with this bill as a whole. I will not be supporting it today. There are amendments that have been tabled by the opposition that will improve the bill, and I hope these will be supported because they are pragmatic and give a glimmer of hope to businesses in what is otherwise very damaging legislation. So when members on the opposition benches vote today, I hope they'll consider the consequences of this bill and how it is detrimental to growth, something the government has sought to pursue.
I call Sarah Owen.
Thank you, Madam Deputy Speaker, and I refer members to my register of interest and the fact that I'm a trade union member. This government was elected on the promise of the biggest boost to workers' rights in a generation. That is exactly what this bill will do. The previous government oversaw a system that left working people paying the price for economic decline, insecurity, poor productivity and low pay. Measures in this bill will make a serious difference to working people's lives. 9 million people benefiting from day one protection against unfair dismissal. Around 4,000 mothers returning from maternity leave who are dismissed each year, they will be protected. And 1.3 million people on low wages will receive statutory sick pay for the first time. In Luton North and elsewhere, these rights will make a real, meaningful difference to people, especially those in new jobs, on lower incomes or in insecure contracts. Now, as a former care worker, I know that the fair pay in adult social care, bringing workers and employers to agree pay and conditions across the whole sector, will be transformational and is long overdue. During COVID, when many carers risked their lives and their families to care for others, the last government handed out claps, bin bags for PPE and sent carers off to food banks. This government is delivering the recognition that social care is skilled, valued and vital to a thriving society. Yeah. Now, Madam Deputy Speaker, I'd like to speak in my role as Chair of Women and Equalities. Our committee's report in January showed the need for bereavement leave following pregnancy loss. My wholehearted thanks to all who gave evidence and led to our report and the amendment which followed, and all of the members who have supported it since. Thank you very much, and from across the House. But especially to the brave women who shared their experience of losing a pregnancy with our committee. All of them had the option of only sick leave. Every single witness said it was time for change. Sick leave to grieve the loss of pregnancy is not appropriate. Firstly, it means that women workers were left fearful that HR processes would kick in following accrual of sick leave. Secondly, it reinforced the feeling, wrongly, that there was something wrong with them, or something wrong with their bodies. Thirdly, It made them feel unable to talk about their miscarriage with both their employers and their colleagues in the way that it should be, as if it was something shameful to approach their boss about. From small businesses to big business like the Co-op Group and TUI, many employers already offer bereavement leave following miscarriage, as well as the largest public sector employer of women, the NHS. They all show that doing the right thing is good for workers and good for business. And now I am so pleased to hear the commitment from the Minister today to work with the other place to see miscarriage bereavement leave realised. This Labour government would become only the 4th country in the world to recognise the need for bereavement leave following miscarriage. That is truly world-leading. It would be a leading light in a world that seems to be taking a backward step in women's rights. Although this is not paid, as outlined in the amendment, this is a significant step forward. It doesn't just provide rights, but goes a long way into furthering how we talk about pregnancy loss in society as a whole. That miscarriage is no longer ignored, that it's no longer stigmatised as a sickness. People have been moved to tears of joy, relief and raw emotion, that their loss is now acknowledged and things will change. Later tonight, in the privacy of my home, I'll probably be one of those too. Madam Deputy, I will give way.
Can I commend the Honourable Lady for her passion, for her compassion as well, for her honesty, for her delivery of this subject matter through government, through the Minister tonight in this chamber. We all recognise the Honourable Lady's commitment to this task that she has set herself to achieve in this chamber. Tonight this government will deliver that for her. I welcome it as well, because as the Honourable Lady has, and all of us have in this chamber, we've lost loved ones, we've had mothers who have had miscarriages, sisters who have miscarriages, we have family members and workers who have had miscarriages. All those things have happened, and those are the reasons why the Honourable Lady has something special tonight. We commend her for it.
I thank the Honourable Member from Strangford for that kind intervention and for many members' support throughout the years. I had experienced pregnancy loss whilst being an MP, and I have to say the kindness of fellow colleagues in this place really got me through. But I do have to say that at no point did any of them wrap their arms around me and say, "Get well soon." They all said, "I'm sorry for your loss." And I am so glad that today the Minister is committed that the law will reflect society's view around miscarriage. Madam Deputy Speaker, I'd like to thank the DBT team for meeting the challenge set out by the Women and Equalities Committee, especially the Minister. Some of our committee members, or each of our committee members, are committed to this and were enabled by our excellent clerks. I want to thank the members who have supported my amendment and our amendment, and to the campaigning work of so many people, because many people in this, many members have been very kind and have expressed gratitude to me for tabling this amendment, but actually this is a team job. This was teamwork and campaigning that spans many, many years. Campaigning work from inspirations like Mylene Class, my friend, the member for Sheffield Hallam, the former member Angela Crawley, to brilliant organisations like Miscarriage Association, Tommy's, SANS, Pregnant and Screwed, and all of their supporters. But I want to say a special thank you to Vicky and her team at Miscarriage Association. Both professionally and personally, you are a voice for so many during their darkest times. Thank you. This change means that the law will finally catch up with society's views on pregnancy loss. It is a giant leap forward in the recognition that miscarrying is a bereavement, not an illness, and workers will legally have the right to grieve.
Lawrence Turner.
Very much, Madam Deputy Speaker. It's a particular pleasure to follow my former colleague and honourable friend and member for Luton North. What she has said today will have a special resonance, I think, with many people who are following this debate in this chamber and beyond, and she has done a valuable public service and we thank her for it. Madam Deputy Speaker, as is customary, I draw attention to my declarations and registered interests and my membership of the GMB and Unite Trade Unions, and because time is limited, I'll restrict my comments to Opposition Amendment 290 on the School Support Staff Negotiating Body, or SSNB. This amendment seeks to disapply the SSNB's statutory remit in respect of both academies and local authority maintained schools, and in that respect it is substantially different and more damaging from the similar amendment which was brought forward at committee stage. If it was carried today, it would have the effect of reducing protection for many school support staff workers who are in employment today. The vast majority of school support staff workers are already covered by collective bargaining, almost 80% directly, more indirectly. But the existing agreement, the National Joint Council, does not serve support staff or employers well. Last year, teaching assistants were paid just £17,400 on average. 90% of these workers are women. I have spoken to some who have relied on food banks and payday loans to make ends meet. There are 1,800 school support staff workers in my constituency of Birmingham Northfield, and they deserve better. Most schools struggle to recruit for these roles, according to research by the National Foundation for Educational Research, and at one point during the pandemic, teaching assistants were the second hardest role to recruit for after HGV drivers. This is not just about pay. As the Harper versus Brazel case showed, substantial liabilities exist for employers as well, from unclear and outdated terms and conditions. And as the Confederation of School Trusts said, representing academy employers, the time has come to move school support staff out from under the local government negotiating umbrella. Indeed, the request from school employers was that the bill establish a floor, not a ceiling, and this point was addressed at committee stage. We might then ask why this amendment has been brought forward. It is in contradiction to the amendment that the opposition front bench brought forward in the Children and Wellbeing Schools Bill committee. And it was the party opposite, after all, that put the School Teachers Review Body on a statutory footing back in the early 1990s. So why will they not support the same step for school support staff? They are not seeking to amend the bill, similarly in respect of the Adult Social Care Negotiating Body, despite the similarities between the two policies. So I fear that the answer is that school support staff, the majority of people who work in school, are suffering from the soft prejudice of unequal knowledge and interests that divides the workforce into professionals and ancillaries. This outdated attitude should be confined to the dustbin of history where it belongs. It was rejected in this place almost 20 years ago when the process that became the SSMB began. This is not a measure whose time has come. It is long overdue, and I wish to say a little about the importance of this measure for SEND. Classroom-based support staff spend the majority of their time supporting SEND learners. They are essential to schools' models of inclusion.
Would my friend give way?
I'll be glad to give way.
I thank my friend for giving way. He's given an excellent speech and referring to a really important group of people. As a former teacher myself, as I mentioned quite often, I recognise the huge importance that school support staff provide to the classroom. Would he agree with me that they don't just support learners, they actually support teachers too, and actually have a wider influence on the school community?
I do agree with my humble friend, and I think he makes a very important point. And when we look back at the national agreement in the early 2000s, which led to the expansion in school support staff roles, the justification was that they would alleviate pressure on teachers and add to the quality of teaching in classrooms. And that is exactly what school support staff workers in my constituency and his do every day. Yeah. So, Madam Deputy Speaker, these roles are essential for SEND support, but the contracts that these people are employed under are so squeezed that no paid time is available for professional development or training. In other words, we cannot resolve the SEND crisis without contract reform. And we cannot achieve that contract reform if the drift and delay that is the legacy of the 2010 decision to abolish the school support staff negotiating body continues. So I do urge the opposition, even now, to think again and not push this amendment to a vote. In the time that is remaining, I wish to say a few words about the provision in respect of hospitality workers and their right not to be subject to third-party harassment. When the Honourable Member for Bath, who was formerly in her place, brought forward her private member's bill in the previous Parliament, that bill contained the same provisions which have been advanced now. At the start of debates in the House of Lords, the extension of that protection to all reasonable steps was supported by the government of the day. In Baroness Scott, leading for the Conservative Party, said that these measures would not infringe upon freedom of speech. In fact, they would strengthen it. Madam Deputy Speaker, the Conservative front bench was right then and they are wrong today. In conclusion, this bill is incredibly important. Employment law in the United Kingdom has tended to advance by increments. This bill measures progress in strides. I am proud to have had some association with it through the Public Bill Committee stage. I thank the departmental team who were part of that process and the other members of the committee, and I'll be proud to vote in favour of the extensions to the rights in that bill when they are brought forward to a vote tonight.
Forgive me. Andy MacDonald.
Thank you, Madam Speaker. As a proud trade unionist, I refer the House to my entry in the Register of Interest. Today marks a truly historic moment, the most significant expansion of employment rights in more than a generation. And I want to extend my congratulations to the Secretary of State and the Deputy Prime Minister for their efforts, as well as express my enormous gratitude to the Employment Rights Minister, the member for Ellesmere, Port and Bromborough, for his time and engagement with me over recent months in discussing the measures in this bill. I also wish to acknowledge the dedication of the Bill Committee members, as well as the countless trade union officers, academics, Labour Party members and staffers who have worked tirelessly for decades to bring us to this day. This is a milestone we've long strived for, and on a personal note, I extend my sincere thanks to the Prime Minister for entrusting me, while in opposition, with the responsibility of delivering Labour's Green Paper, the New Deal for Working People. I speak in support of the Government's amendments and will touch upon my own tabled amendments selected for discussion. Specifically, Madam Deputy Speaker, I support Government New Clause 32 and Government New Schedule 1, which extends guaranteed hour protections to nearly 1 million agency workers. This is a crucial step, aligning with my own Amendment 264, and I'm pleased to see the Government taking this forward. The TUC has rightly emphasised that for these rights to be effective, they must apply to all workers, including agency workers, is essential to prevent unscrupulous employers from circumventing new protections by shifting to agency staff. Exploitative tactics by a minority of employers designed to avoid responsibilities and deny workers job security remains a deep concern. And this is precisely why I've consistently advocated for a single employment status. I tabled New Clause 61 because I believe that establishing a single status of worker is a necessary step to ending unfair employment practices. The Government's Making Work Pay Next Steps document, published alongside the bill, states its intent to consult on moving towards a single worker status. At second reading, I noted that we cannot truly eradicate insecure work until we establish a clear and unified employment status. Since then, the Director of Labour Market Enforcement, Margaret Beales, told the Business and Trade Select Committee that the whole business of employment status needs to be addressed. She further noted, "You can probably consult until the cows come home on this issue. It is about time to do something about it." The TUC also urged a rapid review of employment status to prevent tactics like bogus self-employment from proliferating as employers respond to new rights. I welcome the Select Committee's recommendation that the Government must prioritise its review of employment status and address false self-employment so that these reforms roll out alongside this employment bill. I also acknowledge the amendment tabled by the committee chair seeking to establish a deadline for this consultation. I urge the Government to accelerate progress on this front, but take reassurance in the fact that this issue is well understood at the highest levels. Now, turning to collective redundancy and the unacceptable practice of fire and rehire, ACAS reported in 2021 the use of fire and rehire tactics by employers is prevalent in the UK and has increased since the pandemic. Nearly a fifth of young people say their employer has tried to rehire them on inferior terms during it. Many will recall how P&O shamelessly broke the law, choosing to pay compensation rather than comply with their legal obligations because they calculated that replacing their workforce with cheaper labour would ultimately be more profitable. I welcome the Government's consultation on collective redundancy and their introduction of new Clause 34, which doubles the maximum protective award for unfairly dismissed workers to 180 days' pay. While this may deter some employers, I question whether it is a sufficient deterrent to prevent further abuses. The TUC has raised concerns that merely doubling the cap still allows well-resourced employers to treat their breach of their legal obligations as the cost of doing business. Instead, they propose a stronger deterrent, the introduction of interim injunctions to block fire and rehire attempts, an approach I sought through new Clause 62. Mick Lynch, the outgoing General Secretary of the RMT, told the Bill Committee that unions should have the power to seek injunctions against employers like P&O. He rightly pointed out that the power is all with the employers and that unions currently lack the legal means to stop mass dismissals before they happen. My amendment offers a solution giving employees immediate redress through an injunction if they can show their dismissal is likely to be in breach of the new law. This would ensure they remain employed with full pay until a final ruling is made. I encourage the Minister to address this issue in his response and to indicate an openness to considering injunctive powers within this Parliament.
Will the Honourable Member give way?
I will indeed.
The Honourable Member has played such an important role in the development of these policies, making a really wide-ranging speech. Could he reflect upon the importance not just of individual rights, but also collective rights in his remaining remarks?
I'm grateful to my honourable friend for that intervention. He highlights a critically important issue, that this is about making that shift and the reversal of the decline in selective collective bargaining. We should be looking for the ILO standard and as per the European Union to get to 80% across the piece. But I also note the concerns of the TUC and Unite regarding government new clauses 90 to 96 around the one establishment issue and urge them to engage with the unions on these issues. In closing, Madam Deputy Speaker, much has been said about wealth creators, but there needs to be a recognition that working people are wealth creators and they are entitled to their fair share. The Chair of the Select Committee calls for consensus. At the core of this discussion has to be that good, well-paid, secure, unionised employment is good for our constituents, our businesses and for our economy. And this Employment Rights Bill, this crucial bill, is an essential step along that road to a brighter economy and a brighter future for all our people.
Imran Hussain.
Thank you, Madam Deputy Speaker, and it's an absolute honour to follow the Honourable Member for Middlesbrough and Thornaby East, and I know the whole House will join me in thanking him for all the work he's done in shaping the bill before us today. Madam Deputy Speaker, the Employment Rights Bill, which I am also proud to have played a small part in shaping, represents a once-in-a-generation opportunity. This bill is a testament to the values we stand for: a fair day's pay for a fair day's work, dignity, protection and bargaining powers for workers, and a safety net for the most vulnerable when they need it most. Madam Deputy Speaker, there is much to celebrate in this bill, as we've heard from excellent contributions in the House today, and I also put my name to many of the excellent amendments that we've heard honourable members speak to today in the House. And I do feel all of those are designed to strengthen this excellent bill further. However, I will focus my remarks, time not permitting, on my amendments in respect of statutory sick pay. As we all know, and as has been said very eloquently in this House today, time and time again, the current system isn't just insufficient, it is completely and inexcusably broken. We have the worst system in Europe, frankly shameful. Workers are entitled to just 17% of the average weekly wage. Yet, Madam Deputy Speaker, the cost of living doesn't suddenly plunge 83% when workers are sick. Their rent, their energy bills, their grocery tab, nothing else is discounted. So why does SSP remain such a paltry sum? Being forced to survive on £118.75 a week, if you're lucky enough to get that in the first place, leaves workers exposed to financial hardship. It forces many to make the difficult decision to go to work when they are unwell. Therefore, it is quite right in this bill the government has put forward major and necessary and much welcome reforms. Removing the 3-day waiting period so that workers are entitled to sick pay from day one of illness, extending sick pay to all workers by removing the lower earnings limit and implementing a fair earnings replacement percentage of 80%. These reforms will directly benefit over 1 million low-paid workers, a disproportionate amount of whom continue to be from BAME, women and young people. Now, Madam Deputy Speaker, there is much more we can do to strengthen this bill, and that is why I have put forward 2 amendments that I believe will strengthen this bill and ensure that no worker is left behind. My first amendment, Amendment 7, calls for sick pay to be aligned with the national living wage. Let me begin by making it clear that uprating SSP is popular with businesses as well as workers. 6 in 10 employers agree that the rate is simply too low for workers to survive on. We know this because the poverty rate amongst those claiming SSP is more than double than among the overall working population. So my amendment makes it clear if you are working full-time, you should not be paid poverty wages when you are unwell. And no one should have to choose between their health and their financial security, which is why my amendment would immediately raise SSP to around 67% of the average weekly wage, putting us on par with many of our European counterparts. The second amendment, new clause 102, is about ensuring fairness. Now, whilst it's welcome the government's proposed system, the reality is that 300,000 workers may actually end up worse off than they are today. Those who earn slightly above the current low earning limit of £123 up to £146 per week would receive 80% of their earnings, which is lower than the SSP rate they would receive today. Madam Deputy Speaker, we cannot allow anyone to be left behind. Whilst it's true that removing the waiting periods puts more money in people's pockets from the beginning of the illness period, workers taking over 4 weeks off due to long-term conditions, going through cancer treatment or recovering from serious operations and suffering from mental health crisis will face the biggest losses under the new system, which is why I will do.
I thank my honourable friend for giving way. Does he agree with me that the research finding that the cost of presenteeism to the private sector of mental health alone is £24 billion a year shows that reforming our statutory sick pay is the most pro-prosperity, pro-productivity policy that we can pursue?
Absolutely. My honourable friend is absolutely right, and he makes the case brilliantly in terms of some of the nonsense arguments that we've heard from the opposite benches today with regards to productivity. It is absolutely the right thing to do, but also it will lead to much improved productivity, a better, healthier, happier workforce, and much better for the employer as well. And I thank him for that. Madam Deputy Speaker, it is why my amendment ensures that every worker receives at the very least the same amount of sick pay they would have done under the current system and not a penny less. So I urge the government to support these amendments, which are very much in the spirit of this legislation. And I know I will give away. I will give away.
congratulate him and his colleagues for advancing this bill 8 months into their mandate. We're in the remaining stages. In Northern Ireland, 13 months after restoration, the proposed NI Good Jobs Bill hasn't even been moved, and doubt is growing that it will in fact pass in this mandate. And once again, workers and businesses in Northern Ireland are paying the cost of dither and lack of ambition. Does he agree with me that those same barriers to people on sick pay were also applied to women on maternity leave? And would he support in principle my amendment, new clause 23, to raise to the living wage standard statutory maternity pay for the later parts of maternity for women who work?
Absolutely, and my honourable friend again makes the case brilliantly, and I absolutely would in principle support that like I do, because the challenges are exactly the same. And I said in the beginning of my speech today that many of the amendments, if not all, certainly not the ones from the opposite benches, but the ones, reasonable ones from these benches, are constructive and designed to improve this bill further. And that brings me on to my point. You know, the Honourable Minister and I have had great pleasure in working together for many months on this, and therefore he will know that I come to this with an absolute position of sincerity to strengthen this bill further. And of course, while I'm fully understanding of the fact that Amendment 7 is a probing amendment, and I know that that one will not be voted through the lobbies today. However, I think it does reflect the ambition that we should rightly have, because it is shameful, frankly, Madam Deputy Speaker, that we are one of the lowest when it comes to statutory sick pay, and that we are in the situation we are in, and our partners across Europe quite rightly are much better than us on this. But the second amendment, new clause 102, I would ask the Minister to seriously consider that, and whilst again that does not ask for any immediate action today, what it does ask the Government to do is come back to this House in 3 months to report back that nobody will be worse off as a result of these measures. And I don't think that is ever an intended consequence of the Government's excellent measures that they have put forward. So I look forward to my honourable friend and further engaging with me further on that. Finally, Madam Deputy Speaker, I want to end by paying tribute to the millions of workers who are the backbone of our economy. It is my hope that with the amendments we have proposed today, we can take significant steps towards a society that rewards workers instead of punishing them, that treats them with dignity instead of malice, and when no one must choose between their health and their livelihood.
Ian Byrne.
Deputy Speaker, I'd like to place proudly on the record that I'm currently a member of Unite and GMB, and I refer members to my register of interests. And Madam Deputy Speaker, I would like to take the opportunity to pay tribute to my good friend Terry Jones, a brilliant Scouse trade unionist who sadly passed away this morning and supported this bill wholeheartedly. In the 45 years after Margaret Thatcher began her war on trade unions, this bill is hugely welcome and long overdue. It's a step to turn back the tide and strengthen the power of workers. In a former life before this place as an industrial organiser for Unite the Union, I saw how difficult it was to build industrial strength in workplaces with restrictive legislation supported by previous governments of all colours. This bill will hopefully begin at long last to turn back that tide. Members have already discussed key measures in this bill, and there is so much to welcome in this bill. And I congratulate the Employment Minister for his efforts in getting the bill to this place, and I also congratulate him on his team taking 2 points off Arsenal, which helped no end on Sunday. This is not the end of this bill, though. This needs to be the beginning in the renewal of trade union rights, because if we want to tackle the injustices done to the working class, from low pay and poverty to sordid inequality, we need to empower the institutions that were founded to fight for the working class. And be in no doubt about the scale of the problem. 60% of those who use the 9 food pantries we run across Liverpool are in work, including public sector workers, from nurses to DWP workers. Let that sink in. 60% of those relying on emergency food aid are in work. That tells you how broken the labour market is for so many people Economic growth goes hand in hand with fixing this broken economic settlement, hence the importance of this legislation today. I will focus my comments this afternoon on the amendments we are discussing today, but for the record, I want to note that being debated tomorrow with 2 new clauses I have tabled about upholding trade union rights in outsourcing. My amendments for debate today, Amendments 326 and 327, are aimed at strengthening protections against unfair dismissals, but in my brief time, I want to focus on amendments tabled by colleagues. My friend and colleague, the member for Middlesbrough and Torbay East, has tabled a series of crucial amendments to strengthen this bill, and he also deserves a huge amount of credit for getting this bill to this place. This includes amendments 265 to 267, which enhance this bill's provisions against zero-hour contracts. These contracts leave workers with precious little control over their lives, allowing bosses to dictate shifts with little or no notice and leaving workers vulnerable to gross exploitation. It's no wonder workers overwhelmingly prefer regular contracts. For example, when Witherspoons introduced the option of guaranteed hours for its workforce, 99% of workers opted for guaranteed hours, with just 1% choosing a zero-hour contract model. These amendments would help ensure that when we say we are banning exploitative zero-hour contracts, we actually mean it. The member for Middlesbrough and Torbay East has also tabled new clauses 62 to 65, strengthening the bill's protections against the disgraceful practice of firing me higher. I have seen in my own family the devastating impact this cruel practice has in destroying livelihoods. My brother was a victim of firing me higher at British Gas. This immoral practice should never ever again be able to be used by rogue employees as a weapon against the working classes of this country, and I fully support this strengthening amendment. And finally, the member for Bradford East has tabled Amendment 7 to raise statutory sick pay to the national living wage, and new clause 102 to guarantee workers don't lose out under the new fair earnings replacement proposals. We should have learned from the pandemic that no one should be forced into work when they are ill. These amendments and others help to make that reality, and I really hope the Minister and the front bench are listening. There's devastating consequences of Thatcherism's assault on working class communities and trade unions are seen in towns and cities across the country. Once vibrant industrial towns are hollowed out, industries destroyed, with insecure work replacing well-paid unionised jobs. This never-ending doom loop must be broken if we rebuild communities that at the moment feel forgotten, betrayed and abandoned by successive governments since Thatcher. This bill must be a decisive step in breaking away from that failed settlement and finally building a country that works for us all.
Lola McAvoy.
And I refer the House to my declaration of interest. I'm a proud trade union member, and in my career I've campaigned on more rights for support staff in schools, teaching assistants, better bargaining rights for care workers. I've campaigned for people to have contracts that reflect the hours they work, and I've campaigned for statutory sick pay from day one. So I am really proud today that this bill will deliver all of those things for working people up and down the country and much, much more. I'm rising to speak on the issue of parental leave, and this has come up through many amendments to the bill today and across the House. I've spoken on the terrible inequality of dads' rights and paternity pay 3 times in this chamber since I was elected in July. In my maiden speech on the International Men's Day debate, and again on the debate on this bill in October of last year. So I really welcome clauses 11 and 12 and clauses 20 and 22, which support dads' rights and will encourage more men to take their paternity leave entitlements. In the last Parliament, my gallant friend for Barnsley North introduced a private member's bill which came into force in April 2024. This bill, the Protection for Redundancy, Pregnancy and Family Leave, extended the protected period from redundancy for parents. The protected period is the length of time that a member of staff must be offered an appropriate suitable post should their job role be at risk of redundancy. This protected period applies to the mother for 18 months after her child is born. It applies to adoptive parents for 18 months after their child arrives in England, Scotland or Wales from overseas or the date of the adoption placement starts. And this protection applies for 18 months to those taking more than 6 weeks of shared parental leave. These are the only groups of parents that are included in this extension to the protective period. dads taking paternity leave are left out. Dads may benefit from these if they adopt a child, which is great. They may benefit from these protections if they take more than 6 weeks of shared parental leave. But dads who take paternity leave have no such protections, and this is obviously wrong. In Darlington, dads and mums raise parental leave and dads' rights on the doorstep all of the time. Pregnant and Screw estimated that 74,000 mothers a year lose their job whilst pregnant or taking maternity leave. It's absolutely appalling, and my gallant member's bill in the last Parliament will absolutely act to protect women from this utterly awful motherhood penalty. My gallant friend was right to take action to protect working mums, but I urge the government now to take action to extend these protections to dads in the upcoming parental leave review. Clause 21 of this bill directly amends the same part of legislation to offer further protections to pregnant women. This is absolutely right. Once again, the additional rights extend to mums, parents taking adoptive leave, and parents taking shared parental leave. Rightly, we want those people to be protected. They also extend to bereaved families, bereaved fathers, which is important as well, but they don't extend to those taking paternity leave. So, in anticipation of the argument that dads can benefit from adoptive leave, in anticipation of the argument that dads can benefit from shared parental leave, I just want to outline why it's not working as a policy or a law currently. So 5% of dads take shared parental leave, and that's because it's a bit of a gimmick. Firstly, the second partner, mostly the father of the child, is more likely to take a smaller share of the shared parental leave, which is often less than 6 weeks and therefore wouldn't qualify for additional redundancy protections. Further to this argument, shared parental leave itself is a policy that is tough on mothers. Mothers who want to go back to work should absolutely be able to do so. If they want to go back early and not use their full maternity rights, obviously we support that. My views are not in conflict with the rights of mothers. They are in addition and in support of them. Shared parental leave is an anti-mother policy. That's why only 5% of fathers and partners take it. Fathers, mothers and babies need time together. They need time to bond, time to heal, time to adjust to the earth-shattering experience of becoming a parent together. What's happening in practice is that dads, often the breadwinners, go dutifully back to work, sleep-deprived and under heavy societal pressure to provide for and protect their new families. He's got to keep that job, and that's because so many women are facing maternity discrimination. I absolutely appreciate the effort and scale of this landmark legislation, and I appreciate the vast-reaching scope of the measures in it. It will improve many, many lives, and I'm a pragmatist, and I'm hopeful that we can get an increase in paternity pay, but for now, I'm simply asking for parity for paternity for dads' rights. 72% of the public support more protections for dads, but only 1/3 of new dads take paternity leave. Something's badly wrong here, and I urge the Minister to listen to the campaign group Dad Shift, who say that an estimated 4,000 dads who take paternity leave a year lose their job because of it. My generation and those younger than me are the keenest yet for more family time, but their primary concern has got to be paying the bills. The rate of paternity leave, the huge swathes of discrimination of returning mothers, and the lack of protections mean that dads can't even take what they're entitled to, and we've got to change that. I'm proud of this bill, I'm proud of our government, and I'm very hopeful for dads.
Yeah. Holly Billington. Thank you, Madam Deputy Speaker. And I refer the House to my entry in the Register of Members' Interests and declare that I am a proud member of the GMB. I stand today, Madam Deputy Speaker, to speak against the Amendment 289, which takes away the duty for employers to permit, would take away the duty for employers not to permit harassment and make sure that it did not apply to the hospitality sector or to sports venues. The first time I was harassed at work was when I was 14 years old, waiting tables at a charity event. The second time was when I was 16, in a bistro, except this time I was being paid for the experience. After that, it was when I was a student working in a bar, and then when I worked in a canteen, then in a warehouse, and it is because of this experience, one shared by people of both sexes and all ages, but particularly the young, and particularly women, that across this country, that I was, I'm not going to lie, absolutely gobsmacked by the amendment tabled by the Shadow Secretary of State for Business and Trade to the Protection from Harassment Clause, which would exclude those working in the hospitality sector or sports venues. Madam Deputy Speaker, the Conservative Party is arguing
that some kind of harassment is okay. That if you're working in the hospitality sector or in a sports venue, it's fine. Tories seem to believe that if you go to a pub, your right to harass bar staff is greater than their right not to be. Now, I have to say, I think this is quite an extraordinary thing to argue for, but I'm glad they're at least being honest with us. Jobs in hospitality are often insecure work on low pay and reliant on tips. In Margate, Ramsgate and Broadstairs, thousands of people work in jobs like this. So I don't see why it would be deemed acceptable for them to be harassed in a job, but not if they worked in an office. Yes. I'll give way to the gentleman and then to the lady.
I thank the honourable member for giving way. I should refer to my register of interests, and I'm a proud member of the GMB. Will the right honourable member agree with me that actually even more concerning is calls from the opposition benches, particularly the former Home Secretary and right honourable member for Fareham and Waterlooville, who is calling for the Equality Act to be scrapped, which would mean that sexual harassment would be completely removed from the workplace, and also equal pay. This is a really troubling agenda from the party opposite, and it's in keeping with this amendment, I believe.
I'm grateful to my honourable friend for that intervention, and it is indeed a very, very worrying direction of travel from the party opposite. Now, on these benches, we think you shouldn't be allowed to harass any workers. I honestly did not expect this to be a controversial aspect of the bill to the party opposite. And maybe I'm being uncharitable, so I'd really appreciate if the Shadow Secretary of State, who is now in his place, could answer a few questions. When did it become a Conservative Party policy to allow staff to be harassed? Why does this only apply to staff? I just want to continue with these questions and then I'll give way to the Honourable Lady. Why does this only apply to staff working in hospitality and sports venues? And why does this not apply to all workers? Why is it all right to harass bar staff but not office staff? I'll give way to the Honourable Lady.
Thank the Honourable Member for giving way. I know she hasn't been in the chamber for most of this debate, so she will have missed many of the discussions where my honourable friends explained the nuance of our position on this, and that is the law of unintended consequences, that publicans and nightclub owners should be responsible for policing the words of their customers. That is clearly not a tenable situation. But what I will repeat is the words of all of my colleagues on this side of the House, that sexual harassment is abhorrent. We do not condone it in any shape or form, and I ask her to withdraw the insinuation that anyone on this side of the House has any truck with such behaviour.
I'm very grateful to the Honourable Lady for her contributions. I would like to emphasise that I listened in a lot of detail to the opening remarks of the debate when we were talking, when her colleagues were talking about Amendment 289, and I heard very clearly, for example, some confusion about whether sexual harassment was actually a crime or a civil offence. So I won't take any lessons from the party opposite about their understanding of employment law, or indeed what is considered acceptable when you are at work. So, Madam Deputy Speaker, this amendment, I have to say, is utterly disgraceful. I'm proud this Labour government has brought forward a bill to stop workers being harassed wherever you work. It's just a shame the Conservative Party doesn't agree. Now, the Right Honourable Gentleman thinks it's wrong that pub landlords, and indeed the Right Honourable Lady apparently, will now be, it's wrong that pub landlords will now have to be responsible for having to kick out customers. He's talking about it being a banter ban. But pub managers have always known the importance of keeping rowdy behaviours in limits and protecting their staff and customers from being pestered or made the unwilling butt of so-called jokes. This law, no, I will not give way. I will not give way. This law will strengthen their hand. In the words of the greatest pub manager of all time, Peggy Mitchell, to the proposers of this amendment, get out of my pub.
Quite. Dr. Gibbons-Sunder.
Thank you, Madam Deputy Speaker. What a speech to follow. I can't quite claim to be Peggy Mitchell, but I'll absolutely try to live up to that particularly brilliant remark. I rise today, Madam Deputy Speaker, as a proud member of the GMB. I happily refer members to my register of interests. And today I rise to speak to the amendments relating to Part 3 of the Bill, new clauses 37 and 38. These amendments will strengthen the bargaining power of social workers and by doing so create a stronger working relationship between employees and employers. A stronger relationship that both sides will invest more in. That means higher wages for those who look after our parents, and it also means more training and a healthier social care workforce. Both sides invest more, both sides benefit more. Pro-worker, pro-business, pro-growth. That is what these amendments and that is what this bill will achieve. Now, before entering this place, Madam Deputy Speaker, I was a trade union rep. And I worked with my colleagues to help stop a 33% pay cut in my workplace. Workers speaking as one voice, it meant a happier and more productive workplace. One voice to work with employers, one voice to set out what it means to increase productivity. That is why this bill is a pro-growth bill. Madam Deputy Speaker, I move now to the specific amendments. Social care workers are amongst the lowest paid in our economy. 1 in 6 are legally paid less than the minimum wage. Little proper certification, reward, or recognition for skills means there is little training. Poor conditions mean that almost half suffer from work-related stress. Low pay, little progression, poor conditions. That is why a third of social care workers leave the sector each year. That is what this bill and that is what these clauses fix. Today's adult social care negotiating body, it means more social care workers speaking as one voice, gaining higher wages, better conditions and more training. And these benefits don't just appear on pay slips. It means less time spent worrying about paying the bills. It means better time with families. It means more time reading to our children. It means makes workers more productive. It benefits employers. Madam Deputy Speaker, it makes life worth living. And those on the opposite benches, they say that life cannot improve. They talk a lot of fear today instead of hope and the change we can achieve. They will likely vote against our amendments. They will likely vote against the bill. And in doing so, they denied their constituents better wages and indeed a better life. Madam Deputy Speaker, we cannot simply sit back and hope that wages rise or that training will magically appear or conditions will get better on their own. We have to act to make it so. And these amendments and this bill, by giving social care workers the ability to negotiate for higher wages, better training and better conditions, does exactly that. By giving them the power to speak with one voice, benefiting employee and employer, pro-worker, pro-business and pro-growth. That is what this bill stands for, that is what I stand for, and that is what we stand for. Thank you, Madam Deputy Speaker.
Neil Duncan Jordan.
Thank you, Madam Deputy Speaker. I draw the House's attention to my register of members' interests. As a trade union activist for 40 years and a former regional official, I have a genuine sense of pride in seeing this bill make its way through Parliament. It is truly transformational and seeks to redress the imbalance in the workplace that has existed for far too long. Many of the amendments before us strengthen existing rights so as to ensure that unscrupulous employers are unable to frustrate, delay or act unreasonably when dealing with their workforce, either collectively or as individuals. But other amendments, such as new clause 101 in my name, seek to introduce new rights and protections for groups of workers that have hitherto been forgotten or overlooked. That is why this clause calls for the establishment of a regulatory body for foster carers. Currently, those who employ foster carers local authorities, charities or independent fostering agencies also serve as de facto regulators with the power to register and deregister workers. This puts too much power in the hands of the employers, and according to the foster carers branch of the Independent Workers' Union of Great Britain, illustrates a structure within the sector that fails to bring consistency, transparency, fairness or decent outcomes for the children and young people in their care. A new regulatory body would therefore accredit educational institutions to provide standardised training courses, and once completed, these courses would remain on a carer's work record. At the moment, every time a foster carer starts with a new provider, they are required to do the training again. This is both unnecessarily costly and time-consuming. The body would also be responsible for maintaining a central register of foster care workers and will ensure proper standards of care and deal with fitness to practice cases. And as with the very best regulatory bodies, it will include those with lived experience of foster care. But one of the key roles of this proposed body will be to standardise the employment rights available to carers, such as maximum working hours, entitlement to statutory sick pay and protections against unfair dismissal, whilst also looking at the important issue of collective sectoral bargaining. Through this, we would hope to see improvements in pay, minimum allowances, holidays and pension entitlements. As the UK continues to lose foster carers at an alarming rate, the time is now for this basic oversight that will help ensure we have enough safe and loving homes for the vulnerable children who need them. Now, my other series of amendments from 316 to 323 relate to the issue of redundancy. Over the years, I've negotiated with a number of employers over hundreds of redundancies, and it's based on first-hand experience that I'm seeking to improve the existing legislation. Amendment 316 would require an employer to hold meaningful consultation even if they were preparing to make less than 20 staff redundant, something many good employers already do, of course, and whereas 317 and 318 introduce greater sanctions on those who fail to consult properly. Amendment 319 would treat workers dismissed under fire and rehire as being made redundant and ensure they received greater remuneration as a result. And the amendments 320 through to 323 all seek to improve the level of redundancy pay by removing the 20-year cap on entitlements, by ensuring that someone, for example, with 10 years and 6 months service receives 11 years redundancy pay rather than 10, and bases the statutory redundancy calculation on months rather than weeks, and ensures those with less than 2 years service also have the right to redundancy payments. Of course, Madam Deputy Speaker, there are many reasons why redundancies occur, but at the moment, the rules and sanctions around this issue enable some unscrupulous employers to exploit the situation and treat their staff unfairly. These amendments would seek to address that imbalance, and I hope the Government will consider ways in which these issues that I've highlighted today can be included in the legislation.
Thank you, Madam Deputy Speaker. I'm a proud trade unionist and I refer to my register of interests. I'd like to commend my honourable friend, the Minister and the Deputy Prime Minister for introducing this landmark legislation, as well as my honourable friend, the member for Middlesbrough, who did a huge amount of work on this as Shadow Minister. All of them have dedicated their lives to standing up for working people, and this bill is a culmination of that work and the work of trade unionists over many, many years. Madam Deputy Speaker, I would like to speak in support of Amendment NC 73. My own experience of taking time off work as an MP and the contrast with the experience of those on statutory sick pay made it clear just how badly reform is needed. A couple of years ago, longer than that now, when I needed to take a leave of absence because of the severity of my post-traumatic stress disorder symptoms, I received full pay and a phased return. But for many workers, this is a million miles from their experience. The UK has some of the worst sick pay entitlements in Europe. The fact that this bill will mean that sick pay is paid from day one instead of after day 3 is very welcome, as is the removal of the eligibility threshold, increasing access to more than 1 million low-paid workers. But we must acknowledge that without increasing the rates, the low level of statutory sick pay will continue to place a terrible burden on those already poorly paid. And that's why Amendment 7, tabled by my honourable friend, the member for Bradford East, is so important. However, these are far from the only issues. Another problem is the inflexibility of statutory sick pay, and that's why I've worked with the mental health charity Mind to table this amendment. More than 8 million working-age people have long-term health conditions and experience challenges at work. Statutory sick pay, as it currently stands, does not allow for a proper phased return or for workers to reduce their hours during periods of ill health. Statutory sick pay can only be paid for a full day of sickness. So if a worker needs a half day, for instance, then SSP cannot be used to cover the hours that they're not working. If we force people to return to work before they're ready, whether that's because they can't afford to remain on statutory sick pay or because a phased return isn't an option for them, then they are far more likely to be trapped in a cycle of poor mental well-being and to fall out of work completely. This amendment would mean that sick pay would be paid pro rata, so by hours rather than days, to allow for that greater flexibility. Madam Deputy Speaker, years of successive government reviews have come to the same conclusion, that a flexible statutory sick pay model would improve lives and better support people to remain in work. I've appreciated Minister's engagement with me on this issue, and I hope that the government will commit to looking at it further, especially as the cost to the government would only be administrative, but the impact that it would have on people's lives would be huge. The Labour movement fought long and hard for the right to statutory sick pay, the right to sick pay at all, and proper support for those with long-term illness and disability, whether in work or not, because our movement and our party exists to stand up for the whole of the working class.
Yeah.
So I want to conclude by saying how crucial it is at a time when more people are affected by sickness and disability, that this government supports them and does not scapegoat them for the failures and the political choices of the party opposite.
Marianne Foy.
Thank you, Madam Deputy Speaker. I think, just to begin with, as a young worker, I experienced the precarious nature of the world of work, along with many of my peers in the late 1980s, and that lack of knowledge and the knowledge about our rights and the fear of being sacked if we complained about our terms and conditions is what made me, what politicised me and what made me a lifelong trade unionist and a member of Unite and Unison. And today, Madam Deputy Speaker, I wish to speak about the amendments in my name. New Clause 92, rolled up holiday pay for irregular hours workers and part-year workers. And new Clause 93, working time regulations 1998 records. And alongside most colleagues in this House, along with the trade union movement and the millions of workers who will benefit from its provisions, I really warmly welcome this Employment Rights Bill, and I thank everyone who's campaigned long and hard for it. Now, the majority of people spend a huge portion of their lives in work. Work should be an opportunity to be fulfilled, to live fully, and to support ourselves and our family, to develop as individuals and contribute to society. But the reality is that for too long and for too many, the world of work has been and is a world of uncertainty and of ruthless exploitation, often stripping people of their dignity and their worth. For millions, there is a struggle to obtain secure work, and this strengthens the hand of employers to drive a hard bargain to benefit their balance sheet and their profits. For those who can secure work, work and life can remain unclear and insecure. It can include irregular and uncertain employment, uncertainty about hours, about payment, and about vital matters such as holiday pay and entitlement. And while others in this House boast of their endless push for so-called flexible labour markets, the reality is very different for those on the other side of the employment contract for the workers. The last government spoke about cutting so-called red tape when they really meant reducing the working rights of people and strengthening the powers of boardroom billionaires. And in relation to workers in these sectors in particular, is that I've submitted these amendments, although the amendments proposed would benefit all workers. Now, it's widely known and acknowledged that some employers can use the so-called rolled-up holiday pay as a device to tackle their obligations to provide paid time off for holidays. Holidays and breaks from work are essential for workers and are a recognised factor in delivering an effective organisation in the public and private sector. So-called rolled-up holiday pay is a mechanism by which an employer adds holiday pay to basic pay throughout the working year, but does not provide it separately at the time of taking the holiday. And it's acknowledged, including by ACAS, that this creates a risk that the worker may feel under pressure not to actually take any holiday or to take less holiday than they're entitled to. And this is particularly at risk of workers in the sectors of the economy where their work is irregular. Along with being irregular, their work tends to be lower paid. And this pressure on these workers is immense. So the first of my amendments, New Clause 92, seeks to address this risk. It was a risk accepted and addressed by rulings by the European Court of Justice. And the second of my amendments is New Clause 93, and that would ensure that working time is accurately recorded by employers. Colleagues across the House may recall that record-keeping requirements under the working time regulations were watered down by amendments laid down by the previous government in November 2023 following the UK's withdrawal from the EU. They believed that it was too cumbersome to require employers to maintain accurate records on behalf of employees, referring to it as time-consuming and disproportionate reporting. What a load of rubbish. With advances in modern technology, there is no excuse for an employer to fail to accurately and precisely keep records of the working time contributed by the worker. The onus of managing their own records should be shifted from employees to allow them to focus on their own roles without the added administrative requirements. This government's Employment Rights Bill will indeed deliver a new deal for working people, and I wholeheartedly support it. But I urge the Minister to take account of the issues that I've raised and to accept these amendments. They will strengthen the provisions and increase protection for the sections of workers who need it the most. Thank you.
Thank you, Madam Deputy Speaker. I draw attention to my register of interests, and I'm a proud member of Community Trade Union. It's an honour to speak as this landmark bill passes, hopefully, its next stage, bringing in an era of insecurity and low pay under the party opposite finally to an end. This landmark bill brings in day one rights for workers, a fair pay agreement for social care workers, and greater entitlement to statutory sick pay. As the focus for what I'd like to speak about, I'd really like to highlight the way in which the bill and some of the amendments really strengthen the impact for care workers, carers, the majority of whom are women. We've heard already in this debate many proposals from honourable members on this side to go further than the excellent proposals before us to strengthen day one rights of employment, including from the member for Luton North, who movingly spoke about pregnancy loss bereavement, as well as the member for Walthamstow in talking about the need for stronger entitlements to parental leave. All of these will have a really positive impact, particularly on women. I particularly want to draw attention to the day one right in terms of the strengthening of flexible working by default, and invite the Minister to consider giving guidance to employers that they should require flexible working to be advertised. The Fawcett Society have made a particularly strong case around the importance of this for women, and I know that is also true for carers. If they don't know before applying for a job that they can secure that flexibility, many people will not even apply. So 40% of women who are not currently working said that if flexible work was available to them, it would enable them to do paid work. So we're missing out on a huge potential for businesses. And the Fawcett Society survey in 2023 said that 77% of women agreed that they would be more likely to apply for a job that advertises flexible working options, while 30% had had to turn down a job offer when employers were unable to offer the flexible working they need. So while the bill makes excellent provisions, I would urge the Minister perhaps to respond to this about how we can implement this in practice so that carers, and particularly women, can have the confidence to apply for jobs and know that they can have those flexible working requirements. I will briefly give way.
Thank you, Honourable Lady, for giving way, and I thank her for her warm words about carers. Will she therefore support the Liberal Democrat amendment, which would make paid carers leave an entitlement?
Yeah. I thank the honourable gentleman for his intervention. He may know that I am co-chair of the APPG on carers, and indeed I know that we're very pleased that there is now unpaid leave requirements for carers, and I think I have on other occasions urged the government to look into going further with paid entitlements for carers, and indeed I think there is a real opportunity to enable the 3 million carers who are in paid employment to remain in employment, and to stop the loss of an estimated 600 people per day who leave work due to their caring responsibilities. So while it's not part of today's bill, I think it is something that hopefully the government and the Minister will respond to. So that's the first area. The second area that I'd really like to welcome that has huge benefit for care workers is the bill's provisions around the pay and conditions through pay agreements. And I echo some of the comments of the member for Loughborough, who's no longer in his place, about the huge benefits that this will bring to so many of our valued adult social care staff. So the establishment of the new Fair Work Agency will really ensure that everyone is playing by the same rules. And strengthening powers against modern slavery and labour abuse will further extend protections to those care workers, many of whom have come here, Madam Deputy Speaker, on overseas visas, and who've then found themselves having paid extortionate fees in their country of origin, being here tied into accommodation on 0 hours contracts and being exploited by the care companies. And so it's very welcome to see provision here. We know that too many care workers live in poverty. Research by the Health Foundation suggested that some 1 in 5 can't afford the essentials either for themselves or their children. And I am proud to be sitting here on these benches as we bring forward fair pay agreements along with the abolition of exploitative 0 hours contracts, which will provide finally that security for our valued social care workers. So in implementing this, though, it's really important that we establish the framework to enable home care workers in particular, some of whom I met with recently, who are not paid for their travel time or their sleep-in hours, despite the fact that these should be illegal. So as we take forward the fair pay agreement in adult social care, I would urge the Minister to work with colleagues to ensure that there is an ethical charter surrounding this that care providers sign up to. And obviously this government has already shown how serious it is about valuing those who do so much to care for and provide support to disabled adults and older people in this country. So the third area that I think other colleagues have talked about, and on which the member for Bradford East in their new clause 102, yes, I believe, Madam Deputy Speaker, I keep looking at the clock, whether there is an issue, if you please advise of my remaining time.
Yes, the clock has stopped and you started at 7, but you did take an intervention, so I think you can go for one more minute.
Thank you very much, Madam Deputy Speaker. So I'll very briefly say that I am delighted the government is strengthening statutory sick pay. Many care workers were forced during COVID at their own risk and the risk to those that they were caring for to go into work because they were not eligible for statutory sick pay. So I think this is an excellent move that we are strengthening that. So in conclusion, this bill, together with the proposed government amendments and some of those suggested by my honourable colleagues on this side, will ensure that the 1.5 million people working in adult social care can get fair pay, guaranteed hours, statutory sick pay and day one rights. It's good for workers and it's good for women. Thank you, Madam Deputy Speaker.
Thank you, Madam Deputy Speaker, and I draw the House's attention to my register of interests and my unison membership. I welcome the Employment Rights Bill, a once-in-a-generation chance to give more power to working people, including in Ealing Southall, and I support the government amendments to pay decent sick pay to 1.3 million low-paid workers. I do not support the opposition's amendments that attempt to tie us up in knots in an effort to block working people from getting the rights they should be entitled to. Now, I want to particularly consider the impact of the bill and the government amendments on disabled people. Madam Deputy Speaker, there are almost 3 million people currently off work on long-term sick, a record high. Some of them, of course, are disabled people who are unable to work. However, there are also many disabled people who desperately want to work, but they have been kicked out of their job because their employer refused to make simple changes that would allow them to succeed. In my previous role as National Disability Officer for the country's biggest trade union, Unison, we worked with Disability Rights UK and Scope to develop the Disability Employment Charter. This is a list of improvements to help disabled people get and keep employment. Over 250 employers, both large and small, signed up to say they backed the ideas in the Charter. They backed disabled workers' rights. But the previous Conservative government saw it all as red tape. They didn't listen and they refused to introduce these changes. They left millions of disabled people who want to work stuck on benefits. And their amendments today are just more of the same. But those 240 employers who signed the Disability Employment Charter and the many disabled workers who have been pushed out of their jobs will be heartened to see the changes being introduced in the new Employment Rights Bill, many of which implement the demands in the Charter, including allowing flexible working, more support for trade union disability reps and strengthening sick pay. Those 240 employers would reject the opposition's many amendments that try to frustrate this support for disabled workers. But to turn to the government amendments, Madam Deputy Speaker, people are often surprised to learn that if you're a low-paid worker, you aren't entitled to statutory sick pay. And unless your employer has its own scheme, you can only claim statutory sick pay after 3 days of being ill. During the pandemic, this led to social care staff in particular feeling forced to work when they had COVID, potentially passing the illness on. Lack of access to sick pay is a public health issue, and this new law will ensure low-paid workers no longer need to choose between not being paid or going to work sick. But it will also allow, importantly, disabled workers time off to recover from illnesses rather than struggling into work, becoming sicker and potentially falling out of employment long term. Being paid to take a few days off to recover could save them and the economy a lifetime of being left on the scrap heap. I welcome Government Amendments 80 to 85. I know there's many people waiting to speak, so I welcome Government Amendment 80 to 85, which lay out the level of sick pay low-paid workers will now be able to expect from day one. I know some employers wanted to pay a bit less and trade unions wanted a bit more, but at 80% is a compromise. I certainly do not support the delaying tactics of the opposition, who are looking for impact appraisals that already exist and show that these changes will lead to an increase in productivity and an increase in growth if we can get disabled people working when they want to do so. This transformative bill introduces a key demand of the Disability Employment Charter for a default right to flexible working, and for many disabled workers, being able to organise their hours around taking medication and dealing with pain or fatigue can mean they're able to keep their job rather than end up sick or marched out the door. In line with the Disability Employment Charter, this new law also introduces paid time off for trade union equality reps, which I know we will discuss tomorrow, Madam Deputy Speaker. But having a trained person to help you negotiate reasonable adjustments, it can take time and input from that person whose priority is to keep the worker in their job will make all the difference. But Unison research has shown that nearly a quarter of disabled workers who asked their employer for reasonable adjustments waited a year or more for help, and some never even got a reply for their employer. You can't do a job that causes you pain or sets you up to fail, so it's no wonder disabled people end up out the door. The Disability Employment Charter calls for a new right for a 2-week deadline to at least get a reply to a reasonable adjustment request. Currently, there is no deadline for a response, unlike flexible working requests, for example, where the employer needs to respond in 8 weeks. I have had constructive discussions with the Minister for Disabled People about this, and I am hopeful that we may see this included in the Get Britain Working Plan, which complements today's bill. Madam Deputy Speaker, many good employers already support disabled workers, and I pay tribute to the 240 employers who have backed the Disability Employment Charter and back rights for disabled workers. The Employment Rights Bill and the Government amendments will ensure a level playing field so bad employers can't undercut those who want to do the right thing, and it will ensure more disabled workers can keep jobs they value and can contribute to the growth we need to get our economy moving again. Thank you.
And keep his remarks to 4 minutes.
Madam Speaker, I refer to my register of interest and my membership of the GMB for 28 years. I'm speaking in support of new clause 72 in my name, which tends to put a duty on employers to investigate whistleblowing concerns, to establish internal channels for reporting and managing whistleblower disclosures. In recent years, we've seen scandals rock the country where whistleblowers raise the alarm early on, only for their warnings to be ignored and disastrous consequences to follow as a result. Scandals with thousands of victims, such as the Post Office Horizon, Grenfell Tower fire tragedy and the collapse of Carillion, saw whistleblowers raise alarms only to face a wall of silence. We saw the very worst of this at Yorkshire Cricket Club in my constituency, where Azim Rafiq suffered years of racist harassment and abuse. Yet despite the number of players who admitted to racist remarks or actions, Yorkshire Cricket Club's leadership refused to accept its mistakes and refused to release the full report, only releasing an edited summary. It was only by Azim going in front of the DCMS Select Committee the full scale of institutional racism at the club became known. These failures have a tragic human cost and they've placed significant strain on the taxpayer. In the cost of whistleblowing report, it was found the avoidable costs incurred due to failure to listen to whistleblowers in the Post Office, Carillion and Letley cases, 426 million. It's unacceptable for the taxpayer to bear the burden of failed systems and a failed legislative framework. It is for this reason why we need a new legal duty for employers to investigate whistleblowing. This new clause would ensure the employers must take reasonable steps to investigate any protected disclosure made to them. This new clause would compel large employers to establish internal channels and appropriate procedures for reporting. By ensuring disclosure and investigation, we prevent scandals such as Horizon from occurring and ensure the harm in the workplace is dealt with early on. This new clause is proudly pro-worker and pro-business, tackling one of the long-standing issues of our current whistleblowing legal framework for workers. The status quo only provides an after-the-event remedy for whistleblowers. This new clause ensures there are chance for whistleblowers from the start. EU Government Protects research found that 76% of workers want a legal duty on employers to investigate whistleblowing concerns. This new clause delivers on these long-standing demands from workers. In light of recent scandals, businesses are realising the value of whistleblowers to help root out wrongdoing and harm within their own companies. The IOD recommend that all employers should be required to meet the standards of whistleblowing and follow recognised procedures in their report on the Post Office scandal. This new clause requires employers to take reasonable steps meaning vexation or insignificant concerns don't always require an investigation. This is a once-in-a-generation opportunity to revolutionise the whistleblowing law. The Public Interest Disclosure Act of 1998 was groundbreaking for its time, but since then the UK has fallen behind our comparative jurisdictions, such as the EU and Japan, on whistleblower protections. I hope the government considers supporting this new clause or equivalent measures, which is good for workers, businesses and taxpayers. I hope the Minister will meet with me about this matter following today's debate. Through this new clause, we can take action to ensure that whistleblowers are supported, that businesses are given the tools to root out wrongdoing, and that taxpayers are spared from bailing out state scandals. Thank you.
Speaker Catherine Atkinson.
Thank you, Madam Deputy Speaker. I draw attention to my register of interests, and I am a proud trade union member. I'd like to give my full support to the measures in this landmark bill. In Derby, we make things, from nuclear reactors that power our submarines to the trains, cars and aeroplane engines that get people and goods to where they need to go, to food production operations that help put food on our tables. And we don't just have large companies with big economies of scale, we have thousands of small and medium-sized companies too. And many businesses that I've visited, large and small, are investing in their workforce, want to pay them properly, and to provide stable, secure work that enables their employees to build lives and families. But what they want is a level playing field, so that they are not undercut by competitors who don't play by the rules, avoid their responsibilities, and exploit those who work for them. When people are stuck in insecure, low-paid work, planning for their future is impossible. It is wrong that so many people have no idea whether they'll have 5 hours of work that week or 50. Wrong that they have no idea whether they'll earn enough to pay their bills. Wrong that they can have paid for childcare, be on a bus to work, and get a call just saying they're no longer needed. And what is shocking is that we had 2.4 million people in irregular work, like 0 hours or low-hour contracts or agency jobs. And I am proud that it is this government and this bill that is taking action to end exploitative 0-hour contracts, and with Amendment 32 and 33 to ensure that agency workers are also protected. And at the second reading of this groundbreaking bill, I spoke also about the importance of enforcement, because a right isn't worth the paper it is written on unless it is enforced. And the provisions that we make, the guidance that we set, the laws that we pass are only as strong as the enforcement that there is. For part of my career as a barrister, I had the honour of representing working people. But I always knew that for the many who did seek justice through tribunals, there were many, many, many who didn't feel able to take action. And the Low Pay Commission found that low-paid and exploited workers can be reluctant to speak out about abuses of their rights. Now, last year we celebrated 25 years of the Labour government bringing in the national minimum wage. But the Low Pay Commission estimates that 1 in 5 workers receiving it were not provided with the correct pay in 2022. And at the second reading, I called for the strengthening of the Fair Work Agency, which will enforce the national minimum wage, statutory sick pay, and a wider range of rights such as holiday pay, so that everyone plays by the same rules. And I am hugely pleased to see that new clauses in this bill will strengthen the powers of the Fair Work Agency. Like, for example, as we will be talking about tomorrow, new clause 57, that gives the agency powers to bring proceedings to an employment tribunal in place of a worker. And this could make a huge difference for workers. It helps protect businesses from being undercut by acting as a real deterrent. The sooner that these workers are in place, the sooner enforcement can begin, the sooner justice will be delivered. And this will bring us better protections, better productivity and better growth.
I now call the Minister for Wind-ups, Minister Justin Madders.
Thank you, Madam Deputy Speaker. So, first of all, I think we need to just mention my from the member for Gateshead and Central and Wickham, who is celebrating his 40th birthday today. And what a great way to spend his birthday. I know he has been one of the people who has worked tirelessly over many years in different guises to help us get where we are today. And given the number of speeches and contributions made, it's just not going to be possible to pay tribute to everyone in the time that I have got, or indeed reference every speech and every amendment, but I will do my best to cover as much as possible. So I'll start with my honourable friend, the member for Nottingham East, whose new clause 73 relates to significant structural changes to the statutory sick pay system. I thought she made a very personal and persuasive speech, and I agree with her that phased returns to work are an effective tool in supporting people to stay in or return to work, helping to reduce the flow into economic inactivity and the cost to businesses of sickness absence. By removing the waiting period, employees will be entitled to statutory sick pay for every day work missed. This better enables phased returns to work, for example, supporting someone who normally works 5 days a week to work a 3-day week with the other 2 days paid SSP. This simply would have not been possible under the existing system, and we are committed to continuing to work closely with employees to develop and implement a system that is fair, supportive and effective in kick-starting economic growth and breaking down barriers to opportunity. And I know that we will continue to have conversations in respect of that. Turning to Amendment New Clause 102 from my honourable friend, the member for Bradford East, who I pay tribute to for his work as a shadow minister in this area. The changes that we are bringing through this bill mean that up to 1.3 million low-paid employees will now be entitled to statutory sick pay, and all eligible employees will be paid from the first day of sickness absence, benefiting millions of employees. The new percentage rate is consistent with the structure used for other statutory payments. It's simple to understand and implement, and with the removal of waiting periods, the internal modelling from the Department for Work and Pensions shows that most employees, even those who may nominally earn less per week, will not be worse off over the course of their sickness absence. I will now turn to the speech from my right honourable friend, the member for Sheffield Heeley. It was her first speech from the back benches, I believe. I don't think she'll be on for very long if she continues to make contributions like that. I thought it was an excellent speech, and the way she spoke about her constituent, Mr B, really hammers home the importance of tackling the area of non-disclosure agreements. I would like to pay tribute to her and her ongoing efforts to ensure victims of misconduct and bullying can speak up about their experiences and get the help and support that they need. And I also want to thank the Honourable Member for Oxford West and Abingdon for originally tabling the amendment and meeting me last week, and for sharing, sadly, another horrific story about the abuse of MDAs. And also I thank the Honourable Member for Bath for her contribution as well in this area, because we do know there are legitimate uses of NDAs, but I want to be clear, and we've heard too many examples of it today, they should not be used to silence victims of harassment or other misconduct. I understand that honourable members want to ensure equal protection in relation to NDAs concerning harassment across the economy, and I absolutely hear what honourable members have said. However, we have to acknowledge that this would be a wide-reaching change and would take a significant step without properly engaging with workers, employees and stakeholders and assessing the impact on sectors across the economy. So I want to reiterate that I recognise that non-disclosure agreements are an important issue which warrant further consideration, and we will continue to look into the issues raised. And my honourable friend said she wants me to go further, and I look forward to engaging with her and organisations such as Can't Bar My Silence in respect of this. The Honourable Member for Bridgwater's new Clause 30 would give employees who are special constables the right to time off from work to carry out their voluntary police duties. And I would join him in paying tribute to special constables who make an invaluable contribution to policing across the country. It would not be appropriate, however, to support additional legislation on this matter without a comprehensive analysis on the impacts such a change could bring to policing. But we have debated this before, as he knows, at the committee, and my officials have been in discussion with colleagues at the Home Office to learn more about this topic. Further engagement is continuing with the Staff Association for Special Constables and the Association of Special Constabulary Officers. I do recognise that this legislation is now half a century old and does need a considerable look at. And whilst we cannot support the amendment tonight, I'm glad that there's at least one member on the Conservative benches who supports increasing employment rights. So I will turn now to new clause 7 from the Honourable Member for Walthamstow. I want to start by recognising the key role that parental leave plays in supporting working families. The arrival of a child is transformative for all parents. The government understands and values the absolutely vital role fathers and partners play in raising children, and we want to support them to do that. And I commend the work of my honourable friend, the member for Walthamstow, for her work in this area. We already have a statutory framework in place that guarantees eligible employed fathers and partners a protected period of paternity leave, ensuring that they cannot be required to work while claiming that leave or be discriminated against by their employer for taking it. But I do recognise what my honourable friend, the member for Darlington, has said about the limitations on those protections, and I also pay tribute to her for her work on this issue. Paternity leave is available to the father of the child or mother's partner, irrespective of their gender, and this leave can be taken by the father or partner at any point in the first year following the child's birth or adoption. But I do want to make and acknowledge the wider point made by my friend, the member for Darlington, which is that we need to do more to ensure that the parental leave system as a whole supports working families. As a government, we've committed to doing this, and I've recently met with Dad Shift, pregnant and screwed, and working families to discuss this very issue. And through this bill, we are making paternity leave and unpaid parental leave day one rights, meaning that employees will be eligible to give notice of their intent to take leave from their first day of employment, removing any continuity of service requirement. This brings them both into line with maternity leave and adoption leave, simplifying the system. We're also committed to reviewing the parental leave system. This review will be conducted separately to the Employment Rights Bill, and work is already underway across government on planning for its delivery and will commence before Royal Assent. We are scoping the work already across the Departments of Work and Pensions, Business and Trade and MHCLG, and it's already underway. And of course, we will want and expect to engage widely with stakeholders as part of that review process. So I'm not going to take any interventions, but I would expect the honourable friend to be engaging with us in respect of that. Turning now to the honourable member for Leeds East and his amendment on the reinstatement of the Equality Act. This would partially reinstate a similar measure that was sponsored by the previous Labour government, and this government continues to have sympathy with its aims. We all know that the statutory questionnaire was sometimes found to be a helpful, informative tool. While the government will not support this amendment today, we will be giving close consideration to the impact of the repeal of the statutory questionnaire and any steps that may be needed during this Parliament. I'd now like to thank two people who've been very instrumental in shaping our offers on the area. Sorry, did they want to go?
And I'm very pleased to hear confirmation that the review into parental rights, which I understand is going to begin in June, will go ahead. Can you just confirm, when he talks about stakeholders, will that also include our trade union colleagues? Because many of us are very happy to withdraw our amendments tonight on the basis that working people can be part of this conversation. Minister.
Well, I would fully expect us to consult with all relevant parties, so I don't think she's got any worries in respect of that. I want to just pay tribute to two people who have been quite instrumental in shaping our thoughts on this. First of all, my honourable friend, the member for Middlesbrough and Thornby East, and my honourable friend, the member for Birmingham, Hodge Hill and Solihull North, and they brought some amendments in relation to employment status, and I think it's important that we say we are taking action in respect of those who work for umbrella companies, and we've been clear that some reforms in the plan to make work pay will take longer to undertake and implement. We see consulting on a simpler two-part framework as a longer goal, but I can assure both honourable members that I remain committed to that. And I also hear what my honourable friend said about his concerns about fire and rehire, and we will of course be looking very closely about how our reforms work in practice. Turning now to new clause 17, this seeks to create a legal definition of kinship care to be used to establish eligibility for kinship care leave. New clause 18 then aims to establish that new kinship care leave entitlement for employed kinship carers with a minimum of 52 weeks of leave being available for eligible employees. I'm pleased to say for the first time this government's Children's Wellbeing and Skills Bill will create a legal definition of kinship care for the purposes of specific measures in the bill. And by defining kinship care in law, the legislation will ensure that all local authorities have a clear and consistent understanding of what constitutes kinship care. I'm also also pleased to say that the government has recently announced a £40 million package to trial a new kinship allowance. This is the single biggest investment made by this government on kinship care to date, enabling children to be raised within their communities with their extended families. I also turn now to another Liberal Democrat amendment from the Honourable Member for Torbay, which we previously debated in committee, and would commit the government to introduce an entitlement for employees with caring responsibilities to be paid their usual wage while taking carers' leave. And whilst we have stressed the government's commitment to supporting employed unpaid carers, and I've been engaging with ministers and relevant bodies in relation to this, the Carers Leave Act 2023 only recently gave employed carers a new right to time off work to care for a dependent with a long-term care need. And so we are reviewing this measure and considering if any further support is required. And I recognise that many of the Liberal Democrat amendments have come from a good place, but they have to decide whether they're going to be Manchester United or Manchester City, because their speeches were littered with concerns about the increase in costs from this bill, yet every amendment seems to only add to that. I do understand they're coming from a good place, but they have to make a decision of whether they support this bill or not, and I hope they can make that before tomorrow night. But at least they're here, unlike the new kids on the block behind them. I pay tribute for them for actually turning up today. I'll now address the points raised by the opposition parties in relation to harassment set out in the amendments 288 and 289, and named the Honourable Member for Arundel and South Downs. These amendments seek to exclude the hospitality sector and sports venues from the bill's obligations on employers not to permit the harassment of their employees by third parties, or alternatively to remove Clause 18 altogether, thus depriving employees of protection from all types of harassment by third parties under the Equality Act. Let's be clear, this government is committed to making workplaces and working conditions free from harassment, and so we must protect employees from third-party harassment. And I want to underline two important points in relation to this clause. The first relates to the expectations it places on employers. I would like to assure the House that employers cannot and are not expected to police or control every action of third parties. Instead, employers simply need to do what is reasonable, and what is reasonable, of course, depend on the specific circumstances of the employer. Further, the steps that an employer can reasonably take in respect of the actions of third parties in their workplace are clearly more limited than the steps they can take in respect of their employees. And this will, of course, be something that the Employment Tribunal will take into account when considering the facts of the case. The second point I would like to emphasise relates to the threshold as to what constitutes harassment. Far too often I've heard objections that this clause implies that it will make employers liable if their staff or offended by comments made by third parties. That is not the case at all, and I think that's something that was reflected by the fact that the party opposite did actually support a similar measure in the previous Parliament. The Shadow Minister did ask in his opening remarks what evidence this was showing as being needed. And of course, the NHS 2023 staff survey showed that a quarter of all staff had harassment, bullying or abuse from patients or service users. And the Unite survey said 56% of their members had suffered third-party harassment, which is presumably why UK Hospitality, in their written evidence to the committee, said they supported the measures in principle. So I will work with them to make sure that we do protect everyone in the sector, because I believe that everyone who works in this country deserves protection from harassment. And I think it's incredible that the party opposite cannot see the difficulty with arguing against that. I'll turn now to the amendment, new clause 105 by the Honourable Member for West Suffolk in relation to substitution clauses. I think it's fair to say we are aware of the risks, and we've been working closely with the Minister for Border Security on illegal working by irregular migrants in the gig economy and the role that substitution clauses play in facilitating that. We will continue to work closely with the Home Office on this issue. The opposition have also tabled new clause 87. This amendment would have the effect of requiring the Secretary of State to have regard to the UK's international competitiveness and UK growth when making any regulations under Part 1 and 2 of this bill. But the government is already laser-focused on this key objective. Our plan to make work pay is a pro-growth package and sets out an ambitious agenda to deliver our plan for change by ensuring employment rights are fit for a modern economy, empowering working people and contributing to economic growth. The plan will bring the UK back into line with our international competitors and directly address our low growth, low productivity and low pay economy. And they may be laughing opposite, but they're the people who delivered that economy for so many years. So international competitiveness and growth are at the heart of what we do. We will pay close attention to the potential impacts as we develop regulations to implement the measures of this bill. And on the point of small business support, I can remind members that I actually had a meeting with Inkwell last year who said introducing these changes will help create a happier and productive workplace and create a level playing field for employers. And that is exactly what we want to achieve with this bill, because we understand the best of businesses want to look after their staff, and treating them well is good for business, it's good for workers, and it's good for the wider economy. The opposition's narrow view seems to be that anything that is good for workers is automatically bad for businesses. We absolutely reject that analysis. So, in conclusion, Madam Deputy Speaker, giving people a baseline of security and respect at work is fundamental. It is clear that we need a change from a system where people don't know what hours they will get from one week to the next, don't know where people with caring responsibilities never get the same benefits of flexibility as their employers, where a minority of rogue employers can fire and rehire at will, and where care workers and teaching assistants have all been undervalued for far too long. It is time to end these injustices. It is time to make work pay.
The question is that new clause 32 be read a second time. As many of their opinions say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. The question is that new clause 32 be added to the bill. As many of their opinions say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. We come to government new clauses 33 to 38. I call the Minister to move clauses 33 to 38 formally.
Move formally.
The question is that new clauses 33 to 38 be added to the bill. As many of that opinion say aye. Aye. Of the contrary, no. The ayes have it. The ayes have it. New clause 7 has been selected for separate decision. I call Stella Creasy to move new clause 7 formally.
Withdrawn.
Withdrawn. New clause 10 has been selected for separate decision. I call Steve Darling to move new clause 10 formally.
Move formally.
The question is that new clause 10 be added to the bill. As many of their opinions say aye. Aye. Of the contrary, no. No! Clear the lobby. The question is, as on the order paper, as many of that opinion say aye. Aye. Of the contrary, no. No. The tellers for the ayes are Charlie Maynard and Bobby Dean. The tellers for the noes are Jen Kitchen and Tara Awatemi. Speaker.
The ayes to the right, 95. The noes to the left, 323.
The ayes to the right were 95. The noes to the left were 323. So the noes have it. The noes have it. Unlock. New clause 30 has been selected for separate decision. I call Sir Ashley Fox to move new clause 30 formally. The question is that new clause 30 be added to the bill. As many of their opinions say aye. Aye. Of the contrary, no. No. The question is, as on the order paper, as many of their opinions say aye. Aye. Contrary noes? No. The tellers for the ayes are Paul Holmes and Jerome Mayhew. The tellers for the noes are Jen Kitchen and Taylor Awatemi. Order.
Ayes to the right, 189. The noes to the left, 324.
The ayes to the right, 189. The noes to the left, 324. So the noes have it. The noes have it. Unlock. New clause 87 has been selected for separate decision. I call Greg Smith to move new clause 87 formally.
Move formally.
The question is that new clause 87 be added to the bill. As many of their opinions say aye. Aye. Contrary, no. No. The question is, as on the order paper, has made that opinion say aye. Aye. Of the contrary, no. No. The tenants for the ayes are Paul Holmes and Jerome Mayhew. The tenants for the noes are Jen Kitchen and Tower Amatemi. Order, order.
The ayes to the right, 106. The noes to the left, 340.
The ayes to the right, 106. The noes to the left, 340. So the noes have it. The noes have it. Unlock. Amendment. You're not doing this one, do you? No, these come before page 20. I'm on page 21. Page 20. Oh, yes. I call the Minister to move amendments 8 to 50 and 79 to 85 formally.
Formally.
The question is that amendments 8 to 50 and 79 to 85 be made. As many as that opinion say aye.
Aye.
Of the contrary, no. The ayes have it. The ayes have it. Amendment 288 has been selected for separate decision. I call Greg Smith to move the amendment formally.
Formally.
The question is that amendment 288 be made. As many as that opinion say aye.
Aye.
Of the contrary, no.
No.
Red lobby. The question is, as on the order paper, has made that opinion say aye?
Aye.
Of the contrary, no.
No.
The tellers for the ayes are Paul Holmes and Jerome Mayhew. The tellers for the noes are Jen Kitchen and Terrell Awatoni. Just because it's your birthday, Mark Ferguson, that doesn't mean you can carry on talking. Order, order.
The ayes to the right, 105. The noes to the left, 409.
The ayes to the right were 105. The noes to the left were 409. The noes have it. The noes have it. Unlock. I call the Minister to move amendments 86 to 161 formally.
Move formally.
The question is amendments 86 to 161 be made. Is made that opinion say aye?
Aye.
Of the contrary, no. The ayes have it. The ayes have it. We come to Government New Schedule 1. I call the Minister to move New Schedule 1 formally.
Move formally.
The question is that New Schedule 1 be added to the bill. As many of that opinion say aye?
Aye.
Of the contrary, no. The ayes have it. The ayes have it. I call the Minister to move amendments 51 to 78 and 240 to 245 formally.
Move formally.
The question is that Government amendments 51 to 78 and 240 to 245 be made. As many of that opinion say aye?
Aye.
Of the contrary, no. The ayes have it. The ayes have it. Bill will be further considered what day?
Tomorrow.
Tomorrow.